Who's manning the sound?
Anyone?
Is it Tony?
Bueller?
Who's going to be? They usually sit with you guys. Where are they? We need to go live. Oh, my sound is good?
Test, test.
Oh, okay, so I guess you can hear me. Okay, the meeting of the State Board of Equalization is called to order. Ms. Richmond, will you please call the roll and determine that a quorum is present?
Chairwoman Harkey,
Here?
Ms. Ma,
Here.
Mr. Renner,
Here.
Horton,
Here.
Bowers,
Here.
We have a quorum. Okay, good morning, members and guests. Welcome to the State Board of Equalization. This is our annual Irvine meeting. Very pleased to be here in Orange County in this beautiful facility. Thank you to the council and the staff for arranging this for us. We're going to commence with the Pledge of Allegiance, and I've asked Member Ma to please perform that duty for us.
I pledge allegiance to the flag
of the United States of America and to the republic for which it stands,
one nation, under God,
indivisible,
with liberty and justice for all. Thank you. All right. Ms. Richmond, please introduce our first item.
Good morning, members. Our first item on this morning's agenda is item B, corporate franchise and personal income tax appeal.
We're
Item
going to speak
B1,
up there.
Richard R. Betchley and Kellie S. Brunk, please come forward. Board proceedings has received contribution disclosure forms for today's hearings for the parties, participants, and agents. All forms were properly completed and signed, and no disqualifying contributions were disclosed. All parties, participants, and agents are on the alpha listings provided to your office. Each person sitting at the table will be asked to introduce themselves and, if necessary, their affiliation. The taxpayer for the record. 10 minutes is allocated for the taxpayer's opening presentation, followed by 10 minutes for the Franchise Tax Board's presentation. 5 minutes is allocated to the taxpayer for rebuttal. And Member Ma, I need to ask you if you've had any ex parte communication with this taxpayer.
I think you need to speak more into the mic. For some reason, we're not picking you up very well, Joanne. Said no.
Oh, okay.
As part of their new procedure, I have a question about.
Are you asking everyone?
If you've had any ex parte communication with this taxpayer?
I don't think so.
Mr. Renner?
Yeah, I actually have a question. Because I knew this was part of our procedure, and I was a bit concerned about how it came down. You know, one of the things that we had asked for, I had asked for, and I think we actually as a board did, and I did back in the end of June, was a workshop and training for members on ex parte. So I was particularly concerned over the memo that came out that
Last minute.
at the last minute, that had some interpretation of the law that I believe is incorrect, when it asked us if we had ex parte communication prior to the law being in effect. I don't think that was, number one, I think that's outside the law. The other question I have is, there seems to be a lot of information or discussion in regards to ex parte regarding taxpayers, but very little understanding or discussion in regards to conversations with the department. So I'm a bit confused, because I would think ex parte goes both directions.
You're absolutely right. The ex parte communication would involve a communication with any party to the proceeding, be that the department or be that the taxpayer. I am not prepared to give you a workshop on ex parte, but my opinion on this is that while the communications prior to July 1, while the parties may not have been restricted on their ex parte communications, the proceeding is still pending, and while the proceeding is still pending, the obligation on the presiding officers, which you all are that the decision should not be made with that ex parte communication. So I think the safer course would be to disclose those communications from either party to all parties involved and make those part of the record. So I don't think we need to ask individually whether or not you've had communications with the taxpayer. I think prior to the start of any one of these proceedings, the members could disclose the communications that they have had with either side.
Well, and just to clarify, this would be communications by the members or their offices?
I don't know exactly how your offices are set up, but I would say that if communications came in that you as the decision maker did not review in any way, you could disclose that communications came in and they were not reviewed.
Well, here's the problem. Our offices would have daily conversations with the department in regards to issues that were coming up on an agenda. Impossible to track and articulate. So I find it very difficult for me to talk and make a commitment or to make a statement that says that there's been no ex parte. I cannot do that.
And I think to the best of your ability, the way in which to handle it would be to summarize any of those, the sum total of those communications.
I have no idea what they are. They happened quite naturally.
Excuse me, here is the problem.
Let me finish, please.
But
Let me just finish this conversation. So that's the challenge that we have. So to ask me if I've had ex parte conversation, it's impossible for me to answer that question. So I feel compelled to feel like I could be endangering myself if I give a communication that isn't true, because of the definition that has now been given, that ex parte applies prior to June 30th or July 1st.
Yeah, I totally agree. I've got some issues with it too. We're trying to scramble together a memo for a last-minute email that we received telling us now we have to go backwards into time to disclose. And this was all forward-looking as of July 1, as I understood it, because it was very much understood that we frequently talk to taxpayers, not just members, but offices. We also communicate with the department. That's how a lot of these cases got dropped, is communication with the department and explaining some of the issues that we saw with the case, and they go back and figure it out, and either they drop, they'd reach settlement, they do something. That's why these cases dropped. We've now got a lot of cases coming before us, and to try to think if a year ago somebody talked to somebody, because many times this comes up months in advance. They circle around months in advance, and so it's not an easy thing to disclose. We also do not have, and I want the staff, I want everybody in the audience, and I want this on record, we do not have legal counsel for an elected board right now. And we were told we were going to be able to borrow one from DFA, the new department, somebody who had been working with us previously. That's not happened. So we're up here kind of flying blind. And so for legal reasons and for other reasons, I feel like we're not protected. I feel like I am personally going to make a suggestion that I am able to hire an outside legal counsel till we get this right. I'm going to I've got a budget, so I can't think of anywhere better to spend it than to be sure that I am protected, because right now, nobody is watching the board, nobody is protecting the members. We're all kind of reading the books and citing the particular statute that may or may not apply. And I do believe that we can't go back retroactively and start to disclose something that we didn't have to disclose before. I'm fully able to say at this hearing that I talked with certain people and that my staff may have communicated, but we're going to prepare a letter on one particular because we know that there was, I am aware that there was, but I cannot say on these with clear conscience that nobody at my office has spoken to them or that I haven't. I don't think so. But I am with Member Runner. This puts us in a very, very bad situation. So I just want that on record in case something comes back. It's not the staff that'll be in problem. All of you know elected officers are subject to much higher criteria, much higher prosecution issues on small, simple things, little mistakes, little hiccups, but if you're elected, you can find yourself in problems with FPPC, with the AG, with everybody in the book. And so I don't want to be there. You know, I mean, if I didn't have anything personally to lose, I might feel a whole lot different and just fly with it. But on the city council and also when I was elected in the legislature, we had people that represented and gave us counsel. And that's what we need again. We need somebody that's looking out for the board, not just tax policy, but that's looking out for the board. That was our complaint earlier this year, and that is still our complaint. We had an RFP out for this purpose. And then we got our duties diminished, and I know that the controller has her own attorney. We each either need to be able to hire one on our staff, which I am going to make a request to do, or we need to get somebody in gear from an outside firm that's used to dealing with elected officials and the issues that we face, as well as we've got plenty of policy people, a lot of policy people. What we don't have is anyone that protects us, and that's what we need.
Let me finish now. Let me make this clear from my perspective. Unless I can be assured by counsel that indeed my staff nor I have any responsibility in terms of ex parte communication prior to the law being put into place, that any conversations in that does not meet ex parte requirements, I will not participate in any of the hearings today or tomorrow. Because I can't, if the question before me requires me to make a commitment to which I cannot make, I cannot, in good conscience and exposure to me and my staff, move on with any of these decisions. So my question, because that's in conflict with a memo that I received that then said that I had responsibility for conversations prior to the law being in place.
Well, first, Ms. Richmond reminded me that I should introduce myself. My name is Noreen Marks. I'm from the Department of Consumer Affairs. And I was initially asked to provide advice on Bagley-Keene Open Meetings Act rules. With respect to the ex parte issue, my reading of it is, again, that because the proceedings are pending, I think it is the safer course to disclose those communications to the best of your ability. So even if it were a summary of, I'm sure my office had communications with respect to this proceeding. I do not recall any of the specifics, at least to give all parties to the proceeding the opportunity.
But isn't that in essence a violation of the ex parte if you say ex parte applied prior to July 1st?
I'm sorry, I didn't catch that.
Wouldn't that be a violation of ex parte if all of a sudden I say we may have had conversation? If you're telling me that the law applied prior to July 1st, and I make a comment that says we may have had communication, isn't that then in essence violation to what you're saying I'm needing to disclose?
Well, as I said, the restriction on the parties to give ex parte communications or to provide ex parte communications prior to July 1 was not the law. The law now is that while the proceeding is pending, the presiding officers have the chance to cure that. So it's not, so if you were to say I had communications prior to July 1, I don't think that's the violation. I think the cure then, but I think the violation would be potentially to make a decision without disclosing.
Is the
The law
cure-
gives you the opportunity to cure any of those
So the only
violations.
cure of the violation is to say that there may have been communication?
Well,
That is
the-
adequate cure without having any exposure?
The cure is to disclose what those communications are.
I don't know what they were.
We don't keep track of that.
I don't know
kind
what they were, and again, the confusing part is there's been no conversation at all in regards to what that communication requirement is in regards to department. Just to make it clear, and I'll go on the record for this, to make it clear for the record, prior to the July 1st, I asked our chief counsel at that point to do workshops for members as this law was coming into place. Unfortunately, as this department was split apart, that chief counsel then went to the new department, leaving us without a chief counsel. I then had a specific conversation with the Secretary of Government Ops. Specifically said, we need to have a workshop prior to our hearing so that we can understand what we have exposure to and what the law is going to be and how it's going to be applied. She assured me that we would have that. That has not even taken place. That hasn't even been an attempt to take place. In fact, our ED has communicated constantly about what it is that we need and the protection that the board should have and the concern for replacement, of which then, as far as I could tell, has been virtually ignored.
I have no answers for that, I'm sorry.
David Gow, Executive Director. I have been obviously making this, as I've been trying to communicate to the
Right.
board members, a key concern of mine is the lack of legal support for the elected board, and in particular for the proceedings, the hearings we're having here in the next 2 days. I was in negotiations, I guess I would call it, with someone who was going to come over and either be loaned or act as the chief counsel. That, as of last Thursday, didn't happen. So then I continued the conversation to try to secure someone to help with the proceedings here today, which is, and I want to thank Ms.
Right.
Marks for at least, coming here today. That's where I am. Kind of jump-starting before my report this afternoon or whatever it'll be, I have another meeting on Monday to try to see about bringing a loan, but that's still to be negotiated. I'm not there yet. So we are where we are right now with Ms. Marks to try to help procedurally today.
Well, and again, the frustrating part for me is, as was described oftentimes by this splitting of the agency that was supposed to be seamless, is anything but seamless, especially when we can't even get good communication. So again, I'm frustrated. I'm still deciding. I cannot tell you whether or not, if the question before me is going to be, as it was to Member Ma, did I have communication with these? I cannot answer that question. And then at that point, I will then have to, again, ask the chief counsel, or ask our attorney, who's, I think, representing us today, I guess, what exposure do I have? What exposure do I have if indeed it turns out later on in some dispute, any of these could be going then to court in terms of an appeal? What exposure do I have if indeed I had ex parte communication and the interpretation that I currently have in writing says that I'm supposed to disclose things prior to July 1st? The thing that would satisfy me would be if indeed we would interpret, if the chief counsel would, or counsel now, would interpret the fact that the law did not apply prior to July 1st, then I don't have an issue. But as long as there's some part of an interpretation that says this applied prior to July 1st, I am really hesitant to make any decisions on these issues.
Okay. And I would agree too. We just got the memo 2 days ago, and we're like scrambling in our office trying to figure out what is it that we are supposed to be giving or disclosing. And, we've been hearing cases for, 2.5 years now, trying to go back to prior emails. I mean, some of these have been on appeal. There are 30. We had to go back, I guess, trying to remember the 30s coming back. I mean, that is a lot, to ask for with, the memo just coming out 2 days ago. So, as I understood, the law applied July 1st. We're ready to comply as of July 1st. We have stopped all communication with any taxpayer if they called us. We basically said, we are not allowed to, talk to you anymore. We get that. But trying to go back, we have 130-30-30 that was what?
Last
A
year. Yeah.
a year ago. And so trying to ask all of our attorneys, anybody talk to them? What's the communication? We just don't document everything like that. It's just going to take time.
We couldn't even do it with time.
Right. We could.
And that's the problem we're in. And so we would like from you clarification that the law begins July 1. We're all prepared for July 1. No one is prepared to go back. And I think getting this at the last minute was really troubling. And because it's in writing, it is legal advice to us, even though it's just a few little bullet points in an email. We want to be sure we have no liability here. And we can go July 1, but I don't think any of us can go back. And so that's the dilemma. We don't keep tracking notes of everything. It just doesn't happen that way. We have a little conversations. We call the department. They have conversations. Some of the people that had these conversations probably don't even work for us anymore. So it's like, this is an impossible situation. We've been here 2.5 years doing it the same way. As of July 1, it changed, and we've all changed going forward. But we can't retroactively apply a law that didn't apply. And I think that's the big issue. Yes, Member Horton.
Thank you, Madam Chair.
I'm sorry, people in the audience. It's just come to this. Thank you.
Thank you, members. I somewhat echo the concerns of the members, but I got a couple of questions that, Ms. Marks, what is the legal basis for your conclusion that the ex parte communication is basically retroactive for any cases that come before us subsequent to the enactment date?
The way I read the code is while the proceeding is still pending, that if you've received communications that would otherwise violate it prior to your start of...
what section of the code?
It's 11430.40 of the government
But the law
code.
wasn't in effect at that time.
But the law wasn't in effect then.
The
The law was in effect July 1.
The law with respect to the communications being provided was not in effect, but the law with respect to whether or not you're making a decision and received communications.
No, we had no ex parte before. No ex parte law applied to this board.
So,
I think my suggestion...
given that, my lawyers have looked at this and they disagree with your interpretation, but you are our counsel for the day. And so, I don't know to what extent you have obligation to the board as a whole as a lawyer. Can you elaborate on that? Is your obligation to us or Consumer Affairs in this new capacity?
No, my obligation is to you. I have a copy of the MOU between DCA and BOE.
So pursuant to the ethic codes of the lawyers followed, you have strict liability and obligation to the board, to the body, to the individual members?
To the best of my ability.
The, under ex parte communication, my understanding is that you can actually have communications with the taxpayer, but you're required to invite both parties. Is that true?
Correct. The idea is that you're not receiving information from one of the sides that the other side does not have an opportunity to comment on.
It's also my understanding that the other side has to, either side has to waive their opportunity to participate in that communication. Is that true?
I'm not sure I understand
So
that
we
question.
invite both parties, and one of the parties has to, say we invite the department, and we invite the appellant or the taxpayer to a discussion prior to the hearing. If one party waives their right to participate in that, we can continue to have the communication. Is that true?
I haven't looked at that specific type of proceeding, but I would say that if both parties understand that there's an opportunity to give comment to the presiding officer, and one side does not show up, then it would be like any other evidentiary hearing. You'd be
So you fulfilled your
receiving-
obligation as far as ex parte communication?
I'm sorry?
If that happens, you fulfilled your obligation as far as ex parte communication?
I would, depending on the circumstances, I would say yes. If one of the sides has the opportunity to comment on the receipt of evidence and does not make use of that opportunity, then there would be no violation. You have not received communications that the other side does not have an opportunity to comment on.
You indicated under certain circumstances. What circumstances would that not be the case?
I don't think I know enough about how your proceedings work, but if you're at a proceeding such as this,
No, a proceeding wherein they're invited to a discussion with individual members prior to the hearing.
I don't know how that would happen, but that would
It's just,
strike me
we
as...
sent out the invitation. and
That would strike me as then not ex parte, because they have the opportunity. Now, if there are documents that are received during that communication, during that kind of proceeding, then I would think that those would be made part of the record, and that the other side would eventually have an opportunity to review the entire record.
If the documents are considered part of the existing briefing by the presiding officer, would they be required to disclose it? Under what circumstances would they be required to disclose it? The additional documentation?
I would think that they would still be required to disclose that. I mean, if one of the parties comes and says, I have documents, I don't know why those documents would not be provided to the other party.
No, I'm not asking a logical question. I'm asking more of a legal question. Are they required to, under what circumstances would those documents be required to be disclosed to the other party?
You mean if they were already in file? If they were part of the file?
If it was presumed that that evidence was part of the file?
If the other party did not have an opportunity to see that that's part of the file, I would say then you would always have a requirement to disclose.
Okay. Would the party not attending at this point, given that this is somewhat retroactive, I mean, it's being interpreted that these communications, the law applies retroactively to communications that the presiding officer are hearing the case. Given that, would the non-participating party be required to issue a waiver at this point? Because they never had the opportunity to attend these ex parte communications.
I think at this point, the other side would have the opportunity to ask for 10 days to comment on any of the ex parte communications that have been received and disclosed.
So at this point, if we had ex parte communications and we disclosed that we've had it, we should give the non-attending party 10 days to respond.
If they need it, or if you had copies of those documents now, we could talk about how to give them the opportunity to review any documents that may have been received.
And what would we need to do in order to cover the board from any exposure in order to cure that problem?
I think this would be my suggestion as you start to call the cases. If you thought you had either documents or, written communications or oral communications with one side that the other side was not a party to, you can disclose that. If you don't know, then you can say you don't know. If you had either oral or written communications that you can disclose, the other side would have the opportunity to review those, and we can talk about whether or not they need a couple minutes, whether or not they need to trail to the end of the calendar, whatever it is. And then lastly, there would be the opportunity for one of the parties to disqualify one of the presiding officers.
See, this is the problem. We've got 2 days of board hearings. We got this memo. I looked at it actually yesterday morning. My staff has been working on one case, but we got everything from the file. We did not get any new information. But did we talk? I'm sure we did. And so, what's that? I mean, does that mean that this case can't be heard, or that it can be postponed, or we can hear it and we can decide on it, and then all of a sudden somebody can say, oh, but we weren't party to that, so we're going to reschedule this later on, in essence, after the board is gone. So I'm just saying this is very confusing, and I think what you need to do is to just tell us that anything after July 1, follow the law. Prior to July 1, a verbal maybe disclosure that you've had some kind of conversation or whatnot would probably be advisable, since no one can verify. And, just let us get on with the meeting.
Madam
I'm just not, I'm not comfortable with the way this is going, to where we've got taxpayers here that have been scheduled for hearings that are coming before us, and all of a sudden they don't know if our decision's going to be real or not real. And you can't seem to tell us, because everybody gets to object for something that happened before the law went into effect.
Madam Chair, if I may.
Well, I don't think they would be objecting after the fact.
Madam Chair, if I may.
July 1 is when the law went into effect. July 1.
Is there representation from the department here, Franchise Tax Board?
Yes, my name is Craig Scott.
Mr. Scott, is the Franchise Tax Board willing to issue a blanket waiver of any discussions prior to July 1?
I think we would need to go back and discuss that.
See, there's the problem.
Okay.
And that's why
So,
this comes up.
We're faced with somewhat of a dilemma here.
Let me make a quick suggestion.
Sure,
I think a path that I could feel comfortable going down, for me, we'll see how the other members feel, is I could proceed with the hearings without any votes. And then at that point then, and wait,
You still
hold
have
on,
to vote.
and wait until there's definitive direction from either the AG's office or the new tax agency department, or bureau, whatever it's called.
Mr.
Hold on, hang on just a minute.
Yeah.
Or their chief counsel, or the chief counsel for government ops, assuring us that the law of ex parte applies after July 1st. At that point, once that assurance is done, then we can bring these back up and vote on them. That's how I would at least see that we could proceed. But until that point, I'm not prepared through, especially after this conversation. Because here's my problem. My concern is that as we have a taxpayer that comes forward, and again, one issue is with Franchise Tax Board. We know we've had limited conversation because of the procedures that we deal with them. The problem to me is going to be on the old BOE side, where we would have daily conversations with the department. And again, a lot of this emphasis seems to be around the taxpayer, but my understanding is the law applies to the department too. And those are like daily conversations that could take place regarding a case. And so there's no way. In fact, I would probably have to submit to the fact that we did have conversations. I just don't know when they were or what they were about. And so until I can get that assurance, I just cannot move forward on voting on these issues, because what could happen very clearly is you have a taxpayer who say loses in a decision, and then they go ahead and appeal this and go to do a court decision, and the part of their court appeal is their decision making is the fact that we violated, according to the memo, some aspect of ex parte communication. So that's the concern that I have because of the interpretation of being prior to July 1st. So that's kind of where I'm at right now. I'm not prepared to vote on any cases until I can be assured that the ex parte application of the law that went into place July 1st actually applies starting July 1st.
That was our understanding, too.
My counsel has advised me, Mr. Runner, that the mere participation, if there's a violation, doesn't cure the violation. If there's a sense that and I have to sort of follow what our counsel, it is our counsel. So if her interpretation is that there's a violation of ex parte communication, if it occurred, the mere participating in the proceedings without curing it somehow is a violation on our part.
When you say
So-
your counsel, your personal, or did she say that?
My personal counsel. So
I'd like, well, we need to have clarification on that, because that would be an important point.
well, I've asked for, I mean, hopefully, our counsel, Ms. Marks, will provide us with a legal analysis that kind of gives us some direction, and then possibly we can hear from the Franchise Tax Board at some point as to what their perspective is on this issue, as well as the department. I think that would be important. And the waiver that I spoke of would be waiver of any testimony, not the department, either department, not having access to any testimony that we may have heard, intentionally, unintentionally, we don't know, doing
Does it apply to
those-
documents as well?
Pardon?
Would it apply to documents as well? that
It
you
would
may
apply to
have-
documents, it would apply to testimony, it would apply to incidental discussions, it could apply to the phone call to the secretary. If in fact, the appellant indicated to the secretary that they have certain documents that they wanted to present to the presiding member, then that's ex parte communication at that point. And so it's not just the members, at least this is our interpretation. I understand Ms. Marks believes that it's just the members, but my lawyers are telling me that it's all our entire staff. And the other challenge that I have, and Member Ma may have the same challenge, and Member Harkey may have the same challenge, that as a member of the Franchise Tax Board, I actually was privy to information on some of these cases. The Hyatt case that's coming up next month, I was privy to certain information as a member of the Franchise Tax Board that may or may not have been available in these proceedings, so I kind of need to know what that was and whether or not there's those discussions sort of provided me with some insight that may not have been available. I'm not asking at this point, I'm just giving an example so that when you consider what you're waiving as a department, that that you consider all those factors as it relates to me.
And I don't know if the memo that you've been discussing is something that is public, that would, something that we would want to look at also to see what it is actually that the requirements are and what we
Well,
would be.
that brings up
waiving.
another point. My apologies for Ms. Marks, has your memo been provided to all of the parties?
No, that would be attorney-client privilege communication.
So all of the parties now are aware that their communications to the board may or may not be in violation of the law. And so they too need to either waive or disclose. Would that be correct?
So I think the way I would suggest you could proceed is that the members could disclose to the best of their ability what they know of communications that occurred
How would
with the
the-
proceeding before them.
How would the appellant and the department cure?
How would they, what, I'm sorry?
How would they cure their discussions in an ex parte communication?
Well, it is not their obligation to cure, it's the obligation of the presiding officer to cure.
I agree with that. Maybe
But
I
I think
asked- maybe I
they
asked the
could
question
offer these, if
How
they
could
knew
they-
that they had provided documents to one of the members, those documents could be provided, they could assist the members in providing those documents to the other side.
So if an appellant provided documents to the members that they have not provided to the other side, they're under no obligation to provide that information to the other side?
If they were provided prior to July 1, I would think not, because the restriction on actually giving the communication only existed after July 1, but now the obligation for the presiding officer to, before a decision is rendered, to disclose those and to cure any of the potential violations exists now. So I don't see why the other side could say, hey, you may not remember that I gave you this document, but I know I gave it to them and provided it to the other side.
But if in a case that the appellant did provide information, but we did not remember that they provided that information, and later on their argument is that we provided that information to you, but you didn't take it under consideration, the other department didn't know, so the case itself is somewhat tainted.
Part of their appeal.
But as our counsel, would you advise us to request the parties to disclose if they provided us any information so we get that on the record?
You could certainly ask. I do think that the law provides for, at some point, for the matter to be reopened. I'd have to find that particular section. So that is one way in which the proceedings could go forward. The members could disclose to the best of your recollection, a summary of what those communications may have been, and it can only be to the best of your recollection at this point. The other side would have an opportunity to review any documents. Obviously, if you can't disclose any oral communications, there'd be nothing to review, but the documents they would have an opportunity to review and comment on, and then we could deal with how long that would take them at that time. And then the proceeding could go forward, and the presiding officers could be subject to disqualification, but we can see how that goes.
Can we, could the board waive their attorney-client privilege and ask that you disclose your legal opinion to all parties?
That decision has to be made as a board,
But we can't do that.
as a body.
Why would we?
So that brings up another,
Why would we,
I mean, just on this particular case. But I'm not.
The thing that I'm concerned with is I don't agree
I mean,
with the memo. I think
this,
it's wrong.
Memo,
And so it just kind of adds fuel to the fire. Another
it's
question.
already disclosed, though.
Well, we know we have a memo. It is attorney-client privilege memo that we're disagreeing with on ex parte communication. That's, then the particular point is that it's after it's prior to July 1. I just heard FTB say they don't know what they'll accept and what they won't. And so my question is, why is FTB deciding this? We hear their appeals. Why are they the deciding factor, or are they not? I think it's up to our legal people to decide how these appeals go forward and to support us, not necessarily the respondents.
Yeah, disclosure to us wouldn't necessarily prejudice the taxpayer, but it would have some prejudice for the department if the department hasn't had that information. Would you agree?
Well, which is why I understand you were asking the question if we'd be willing to waive.
Right, that's really the reason.
Which is what should happen if it's prior to July 1. There should be a waiver so that we can move forward. I mean, I'm fully prepared to say I may or may not and whatnot. What I'm not willing to do, what I'm not prepared to do is go through each of these cases and say that never had, I don't know. Some of these things are old. Some of them are retreads. Matter of fact, the first case we all heard, and I'm not sure what happened before the first case, before the first time we heard it. So, this is the problem. So I think it's kind of impending upon you to issue an all clear prior to July 1. Just do the best you can with what you've got. You have no liability, and the FTB is going to need to sign a waiver, or figure out another solution. Because I think we have an obligation to hear hearings until December, and we're trying to do that. We have people sitting out here waiting to be heard. They need to know there's some finality to their appeal. FTB is saying, well, we don't know, we might or might not. Why are they controlling the process? Question number one. Number two, what can you do to put a comfort up here so that we can get on with business? That the law really is in effect as of July 1, and that just do the best to the best of your ability, just, disclose if you think you may have had a conversation. Because I would probably be willing to say I may have had a conversation on every file here, or my office. I don't know. I don't think I did, but who knows?
Members,
so that's kind of where we're going.
Members, this is just my own personal perspective, Ms. Marks and members. If the FTB is willing to issue a blanket waiver for the cases before us at this time, I would feel comfortable kind of hearing the case. I only had ex parte communication, which I'm willing to disclose with with one party, and I will disclose, I have disclosed to board proceedings in the form of a memo exactly who had that conversation, down to the receptionist, just in case, you know. So I just said everybody had the discussion. And those who had specific discussions that was actually in the meeting during the time, just one of the taxpayers. So the rest of them I have not had ex parte communications with. But would the department be willing, can you, within the next hour or so, talk to somebody and kind of come back with determination that your department's willing to issue
I mean, if there's not new information presented, if the information is from the file,
well, I don't know if there's
I mean,
information.
that's,
I mean,
I can tell you that I've had no new information that isn't from the file on any of the cases here. It's all in the file. So I think, you know, the fact that we had a conversation 5-6 months ago, and that we spoke to that new file data that the FTB actually received, had a chance to assemble, look at, review, and actually respond to.
Well, Ms. Marks, I got a question in that regard as to what is new information. If we had communications with the appellant and we asked the appellant questions and the response was not part of the record, for example, do you have information relative to the value of this and this and that? And the response was yes, and here's the information, or yes, and we will provide the information at the hearing. Is that considered new information?
Is that new information, are you asking?
Is that, strike the term new, is that information that is, if that information is not part of the record, is that considered information supplementing the record?
I think, if I understood you correctly, if you had a conversation with a taxpayer that said, do you have information? And that person said yes, and I would provide it at the time of the hearing?
Yeah, oftentimes during the discussion in the communications, there may be some exploratory questions that sort of explores the evidence or additional evidence that could be presented. The discussion about additional evidence that could be presented in the defense for the appellant, would that be considered evidence that supplements the existing record if it's not part of the record? That question and that response?
I think the record, as far as I understand it, is you're talking about a file. I imagine that there's a file that exists prior to today, but all the evidence that comes in today is also part of that record.
No, oftentimes what happens is that you have discussions with, or I don't say happens, has happened in our office in the past. None of the proceedings are before us to my knowledge, but the discussion is about hypotheticals, or discussion is about probabilities of additional evidence to support the case. And the taxpayer will often respond to those questions. Well, do you have, as it relates to a valuation discussion, for example, do you have an appraisal? No, I don't have an appraisal, but I can get an appraisal. Or I do have an appraisal, I just got the appraisal, and the appraisal said, so it's a testimony, we haven't necessarily seen it. The testimony is that the appraisal said something that wasn't part of the original briefing or the original records. Excuse me, I was choking a little bit.
Would the appraisal have been made part of the record? I think if
No.
all parties have it, no.
Yeah, I mean, that's the inherent challenge of, I mean, we typically, in our office, if we provided additional evidence, we will typically go through appeals and seek a response to that. But another caveat of this, of the new legislation is that appeals has advised us that they're not allowed to supplement the existing record. So if we ask appeals a question that is not part of the record and ask appeals to go back to the department to get their response, that's not part of the record, appeals has said they can't do that. So that creates another challenge for the board, and just trying to clarify, so that actually, in the future, in the future, I believe, Madam Chair and members, I believe that all parties should have far more than just 10 minutes to sort of explore those questions, because
Exactly.
the communications and the discussions, which I'm not debating the appropriateness of this at this time, but has to take place in this process.
With respect to how a record for these kinds of cases is built, I can't answer that, and that would have to be, I think, part of your question from your appeals bureau. But I can say, I think with the example that you're giving, if, from an ex parte view, if the taxpayer provided you with an appraisal and that did not go to...
Verbal, not an
A
actual
verb,
document.
okay, well then, I think then you could disclose either, yes, I got a verbal communication that the appraisal was X, or I got a verbal appraisal that, or verbal communication that, yes, they could provide an appraisal and would do so at the time of hearing, or would do so and I didn't get one. That could simply be disclosed. Yes, they said they had an appraisal.
So we would have to disclose it. If any of these proceedings end up in court, and this becomes an issue, will you represent the board?
I'm sorry?
Will you represent the board in the legal proceedings if it goes there? I mean, who represents the board if there's litigation that
I would
involves
imagine that the Office of the Attorney
discussions?
General would provide
No, I mean, who would
representation during any
represent?
litigation in
Typically, the
Superior
Office of
Court.
Attorney General represents us, but our legal counsel actually represents the board in that process, accumulating information, testimonies, all that other stuff. The AG does an exceptional job and goes in and kind of handles their business after that. Okay. Thank you, Madam Chair.
I have a couple of follow-up questions in regards to some of this. First of all, this whole process, I think, is unfair to taxpayers we're going through right now. Those folks moved through in a process to which they thought they knew the rules of the game, and unfortunately, the legislature and the governor changed them at the last minute, which has created this confusion. This whole process could have been much easier done if indeed there was a more methodical, thoughtful process to which these laws and transfers of powers would have taken place. Unfortunately, they chose not to do that. And as a result of that, we have these issues of confusion. And again, ones that we had already identified as being potential confusion, that in essence, we were ignored. So now we come to today. We come to today when there's a bunch of taxpayers out here wanting to have their due process. And the process that they thought they were in got changed. So I think that's the unfortunate part of this whole process, and it's what happens when government tries to go ahead and monkey around too fast with the issues and without taking clear understanding and guidance of what they're doing. But let me just ask this specific question, because it has to do with how we can move forward. Member Horton asked, or had the opinion from his counsel, that if we even hear a hearing, if we even take testimony, that we are therefore participating, even though we may not make a choice on it until we get clarification on this issue. Is that your interpretation also?
Could you repeat that, that even participating in the hearing today?
If we, for instance, said, okay, let's go ahead and have the testimony, taxpayers are here, let's respect them, let's hear their testimony, and until we get, and then later on get clarification in regards to the fact that the ex parte did not apply prior to July 1st, then we go ahead and make a decision based upon that interpretation. And so we heard the hearing, we then got the clarification, and then we would make a decision at that point. As opposed to, for instance, where I would be, and that is if indeed we'd had the hearing, the interpretation was, no, indeed, these are, the ex parte did apply before July 1st, and therefore you must disclose, and I would not be prepared to make a decision on those cases, because I can't. I just cannot do it in good conscience for me or my staff in regards to what I believe could be exposure. Unless, again, FTB and also, the new department, TFA, gave us gave us the waiver that protected us at that point. And they then would opine that the application of ex parte does not apply prior to July 1st. Then I could go ahead and move forward with those decisions. But until I get that, I'm in this no man's land that I'm feeling uncomfortable about because of potential legal exposure, both personally and also to the state, and also, quite frankly, to the taxpayer.
Yeah.
I had not
If I may
done-
augment that before you respond, Ms. Marks, our view was that we would have to recuse ourselves from the proceedings. You know, I mean, before it even started, I would recuse myself. I mean, if in fact I thought that there was some legal exposure.
Can we get the answer specific before we start kind of go? I want to know if indeed that's the case, that we can't even hear a hearing and then make a decision later and violate ex parte.
No, I don't think that's the case, because
What's the case?
because the proceeding would still be pending, and you would
Right.
still have that opportunity to disclose any ex parte communications that occurred. Again, it's going to be to the best of your ability, as it always is. If you needed to do a search for written communications, that could be done. If you needed to somehow
Again,
search
you're
your
not
memory.
hearing us. It is impossible for us to come up with those documents that you're asking for, especially on the verbal side. Again, this first hearing was a hearing that was done last year. For us to go back and try to reconstruct what conversations may have taken place between taxpayers, between department and all that, it's impossible. So those
Again, my
documents
suggestion
cannot
is you
be
can only
provided.
you can only do what you can do to the best of your ability with any oral communication, is to give some summary to the best of your knowledge. I do not think it's a violation to go forward today, however.
The memo that I read applied to members, not to staff. That's clarification number one. I know who I talked to and who I didn't that's on file today. But as far as any staff communication, I would not be able to, nor would my staff be able to disclose, because we don't know, and that's very similar to what Member Runner is saying. I don't meet with that many taxpayers myself, so it's easy for me to remember who I met with. That being said, we do need some assurance to go forward with this hearing that we're not going to be in some personal liability, state's not going to be a liability, the constituents or the taxpayers are not going to have issues, and that what we decide, or if we can postpone the actual decision till we get clarification as of July 1, that would actually, I think, you don't think we have a problem going forward. I'm prepared to hear cases under that advice that you have opined that we do not have a problem going forward, but we can probably, if we can take Member Runner's suggestion that we not vote until after we get a final, and which you may even be able to provide by the end of the day, quite honestly. I think if you got together with somebody that are, you know, some legal counsels used to dealing with elected boards and this type of issue. I know you're used to doing, I think, with more of appointed boards, and we appreciate you sitting in. This is kind of a whole different animal. And so maybe even our ex-chief counsel might be able to be of assistance at this point. I think I would be willing to go forward, but I would not be, I'm not really willing to disclose or not disclose at this point. I have one memo that I've tried to do the best with, just simply because I wanted to, but Mr. Horton has a memo that's very generic. We discussed the case. We think we met. Is that it? Does that provide cover for Member Horton and for the rest of us?
Let me see if I can answer those questions. First, I am not aware of any code section or any case law that imposes personal liability. I have not done that research, but I'm not aware of any. I am aware of the provision that says that the presiding officer may be disqualified, and that is the extent of my understanding or my reading or research up until now of what the consequences are of a violation. I don't see an issue with going forward today. I think that the members could, again, respond to Ms. Richmond's initial question about those communications to the best of your ability. The code does provide that it says the presiding officer has the discretion to allow the party to present evidence concerning the subject of the communication, including discretion to reopen a hearing that has been concluded. And I understand that the board members would like to give all parties, particularly the taxpayers, some finality, and that may be contrary to the finality that you want to give, or it may provide some sort of confident approach in how to proceed, which is proceed as you normally do, with the understanding that you will provide any written or communication to the best of your ability for each of the proceedings in turn, and then understand that the matter could be reopened, that you have the discretion to reopen a hearing.
I think, though, I would like for you to, by this evening or something, contact someone regarding the July 1st date. I would be willing to go ahead and hear these cases because people are here and they're scheduled. I think that we probably do not vote on them, but we've got a lot of things. I've reviewed every case. I would disclose what I am aware of. I don't think the memo you sent out applied to staff. I think it applied to member communication, presiding officer. My staff is not presiding officer. I am. And so I would be willing to disclose any personal meetings I recollect. But I think if that would suffice for this meeting, I'm ready to go forward with that, but I don't know if that suffices for everyone else up here.
Madam Chair, I think it's important that Ms. Marks kind of explained exactly who this applies to. I mean, my interpretation, based on counsel, is that it applies to the entire staff, ex parte communication, anyone that works for you. And then I would like to hear from the department as to when they think they could get us a waiver of any potential communications of which additional evidence was provided.
Well, I think if we were going to consider waiver, that we would want to see the memo that was directed on ex parte communication to know exactly what it is we are waiving.
Has the department,
we would want to look at that.
Has the department taken a position on ex parte communication?
Well, yes, we do not have ex parte communications with your, your board.
Has the department taken a position on ex parte communications that the members may have had prior to the enactment and additional information was provided? Would it be the department's view that that additional information should be made available and you should have the option of waiving or not?
Well, yes, we always think that in the fairness of coming to a correct result, we should have all the information that's, given to everybody, all the parties.
What constitutes all the information? Not anything that's not new documentation. If there was new documentation, that would be information you should have, correct?
And I agree.
A phone call here and there, is that all new information to you that you would not be willing to waive?
Well, I guess it would depend on what was provided in the
conversation.
Well, we would not know.
Mm-hmm.
To the best of our ability, we would not know. So to the best of our ability, we don't know. We think there may have been, but I am not prepared to answer for my entire staff.
Ms. Marks, it might be helpful if you disclose what the liability might be if we fail to adequately cure, and if in fact later on there's dispute as to whether or not the actions taken to cure the violation was sufficient or not. And just another question aside from that, giving us some guidance on our personal as well as the agency's liability, does the appellant or the department have the ability to ask that certain members be, recused. In a 5-member board, you recuse 2 or 1 can change the outcome of the proceedings. First question, personal liability, agency liability. Second question, if there is a dispute and a request that members be recused from proceedings because of ex parte communications, what's our course of action?
Well, as I said before, with respect to personal liability, I'm not aware of anything in the code that imposes personal liability on the presiding officer, nor am I aware of any case law with respect to that. I'm just not aware. I didn't see any when I reviewed the code sections, but I did not research that particular issue. And then with respect to the board's liability, was that the second?
Yes, the agencies. And the third was the recusal of members or request for recusal of members by either the appellant or the department because of their perspective that the violation was not cured. In other words, we're still in violation because evidence was provided.
Well, I think with respect to that, if one of the parties were to allege that the decision had been made with, based upon evidence that they did not have ability to comment on, one of the, as far as I read the code, those proceedings could be reopened to give the parties the opportunity, both parties the opportunity to review all of the information that was before the presiding officer at the time the decision was made.
Okay. Madam Chair, I would just, if we proceed, I would just like an opportunity to ask both the appellant and the department to disclose any discussions or any additional information that they think they may have provided to me. Although, to the best of my knowledge, I've disclosed that to board proceedings, but so many unknowns.
I'll make a quick motion then from the board to agree to disclose the memo to all interested parties.
I'll second that. Do we have any objection? No objection? Such will be the order.
Mr. Renner, just for clarification, this is the memo from...
I'm sorry, I should
The
have been more
memo
specific.
from our
The
chief,
memo in
memo
regards to-
from our acting.
Yeah, the memo that was given, that memo specifically we're talking about is the memo that was given to the board members regarding the issue of ex parte communication.
And what's your view of the subsequent analysis?
Well, it would
Which
be
is-
the memo, you mean the analysis?
That is supposed to come forth?
I-
I've been advised that there is no analysis. There was
Right. The
conversation.
only thing we're disclosing right now is because I heard FTB ask to see the memo.
Yes, we would like to see it if it's,
So
if we're
I
being
just
asked to
wanted to
waive.
disclose the memo to FTB, I suppose the new tax department hasn't seen it yet. I suppose the public hasn't seen it yet. I think taxpayers haven't seen it yet. I think everybody should see it.
All God's children.
Yeah, with that
Need to see the
clarification,
memo.
I'm supportive.
Okay, thank you. And yes, Member Ma?
I'm kind of not comfortable until we clarify this issue. And I don't know whether it'd be helpful to take an hour, have the attorneys all from your agency or the new TFA, Franchise Tax Board, our attorneys get in a room because, hearing a case, not voting on it, rehearing it, opening it up, having a memo come out next week or next month about the cases we just heard because we didn't disclose this or that. I don't think it's helpful until we get clarification from everyone. Our understanding was the new rule started July 1st. There's not going to be any ex parte communication starting July 1st, which is what it said in the memo, as all of our understanding. We have done our best to comply with your memo. My attorneys have, submitted information to the clerk of the board, but I'm not comfortable until we get this clarified, and it seems like nobody knows what the rules are. I don't want the taxpayers also to be disadvantaged, based on what happens here today. I don't want the state to be disadvantaged based on, the cases heard today, but there is no clarity in terms of the results, how we rule on this case, and then any subsequent, actions that may happen because we have not clarified what it is we can or can't do, what we should or shouldn't be doing, what is our liability or the waivers that are afforded to us for everybody involved. I think it is important and imperative that the attorneys get together and tell us and issue one decision to us.
Yeah, I'm not, excuse me, it sounds like you were given prior advice. I'm not privy to that. So that, whether or not that could be disclosed, if it could be disclosed, that might be helpful to me as well.
Well, we didn't get any prior advice. We're talking about the legislation that took effect and the wording in the legislation that no ex parte communication shall take place after July 1. Because that was the severing of the two agencies.
Well, then
and so we are prepared to deal with July 1. We're not prepared to deal with retroactive activity, other than maybe a verbal blanket statement saying we may or may not. And we need to know that blanket statement would be accepted by the agencies, and that the taxpayers wouldn't be further subject to a reopening, or that the board would not be suffering liability.
Well, in the interest of full disclosure, I have received legal counsel, but I'm not prepared to waive my attorney-client privilege in that regard. And I concur that might be a good idea for departments and legal counsel sort of get together and just give us some guidance. I mean,
Let's recess for a half hour, and I'm sorry to do that to everybody, but I'd like to recess for a half hour, let the councils get together, figure out the responses, let us go forward with that would let us go forward with the meeting, with the FTB saying, okay, fine, we get it, and with the CDTFA, and let's just recess for a half hour till we ferret this out. Are you
Before
okay?
we recess, please, can you clarify the memo, the motion that Mr. Runner made?
Yeah, we had a motion to release this memo, which was to the council. It's basically a little short email. There is not a lot of analysis to it, but it just tells us that, sets out certain codes and violation codes, and...
That's the July 25th email from David Gall?
Yes.
Thank you.
Tuesday, July 25th. Okay, we'll be back in a half hour. It is now 10:20, let's say. We'll be back at 10:50.
Can we just point of clarification in terms of what we're asking them to talk about?
We're asking them to...
Well, let me see if I interpret it. I think what I'm hearing the board say is they want assurance that ex parte communication that took place prior to July 1st is not disclosed because the law wasn't into effect at that point.
It's not going to affect the hearing.
And do we have legal representation from the CDTFA?
Well, I was just going to request that if you're going to disclose it, is it possible for you to send it to us electronically so we can forward it to our legal counsel back in Sacramento?
So who is the legal counsel for CDTFA? Appeals or the...
Well, we have a chief counsel in Sacramento that I'd like to forward it, the memo to.
The memo that we received.
In the proceedings, just out of curiosity, in the proceedings, does appeals represent the department or the appeals? Who does appeals represent?
Well, appeals is only here to provide the board members with counsel regarding the substantive matters on the appeals before them.
Yeah, per the memorandum of understanding.
So you're representing the board. Your legal obligation is to the board?
Only on the substantive matters before them
Only on the
today.
case issues,
Right,
not
with
on
respect to
anything
just the
broad.
cases, right.
Okay.
And I
Okay.
have the same request. If it's in electronic form, I would like to have it so I could send it to our chief counsel up in Sacramento.
Sure, sure. It's pretty simple. It's not, that's why we've got so many questions. And we're
But
all
if
trying to
Mr. Gao
comply
could
with something we
email
don't
it
know
to
what
me,
to
and then I'll
comply
forward it
with.
to our chief counsel.
We want to be sure that the taxpayers have some assurance and that the department has assurance and that we all have assurance as members.
So just
Yeah.
for clarification
Okay.
then, this email was to us, this memo was to us, and none of the agencies that, or either of the agencies or departments or whoever they are referred to these days, are aware of the interpretation of ex parte in regards to us until they see this memo.
Right,
correct?
and this is
Okay.
brief. So we'll be back in a half hour. Let's just take a short recess and let them ferret this out so that we can give you some
So
finality.
who will be sending it?
I think Mr. Gao.
Okay.
Mr. Gao will be sending it, if he would send it around.
If I, just for clarification, I'll send it to Mr. Eppolite and Mr. Scott.
That's good.
Pardon me?
Yeah, that's good. Thank you.
Thank you.
All righty, and we apologize. we are ready to hear from our council.
So if I could provide a possible framework for moving forward. There's been talk of the requirement to disclose as being retroactive, and I don't quite see it that way. What I see in the statute is that, as I said, it's not saying that the communications that were received prior to July 1 violate the statute. It's prospectively, if you apply the provision for disclosure, I'm looking at providing it prospectively, just looking at the language of the statute, which says, today, if you got it, would you violate the statute, and do you need to disclose? And the answer is yes. So I think prospectively applying it puts upon the presiding officers, all the board members, the requirement to disclose it. And I think the way to do that is, in each of the cases, if you can say, yes, I know I had communications with this side or that side. It's consistent with whatever in the record, whatever the brief said. I don't recall anything that's inconsistent with that. And you can ask the parties, do you recall any communications that I didn't disclose or any communications that were outside of what is briefed in the record? And if there's either side can disclose anything, then I think you can move forward. If you don't recall, if you can say, I don't know because I don't recall, I think you can say that. I see no issue with moving forward today at all, whether or not you'd want to put off making a decision today. I think that, you can make a decision today. If you were to determine that there were communications that you failed to disclose, those can be disclosed, and the parties would have an opportunity to comment to the point that they could request that the hearing be reopened. I think the idea is that the decision maker is not making decisions based on information that the other party has not had a response to, which is one of the reasons why I think that you look at the communications that were provided prior to July 1. I think the idea is that it would be somewhat inconsistent to say, I can make a decision based on any of the evidence that's open to everybody after July 1, but I happen to have in my back pocket information that was not disclosed, and I think that's inconsistent with the statute. The idea is that that you are impartial and that everybody has the same information. So that's what I think I would offer as the way to proceed. You can.
Okay, that's a lot of words. Will you make a specific statement as to what you expect us to do here and now? Like, I asked you if we disclosed that we've had conversations with the taxpayer and the department, and we discussed the issues in the briefing both by the taxpayer and the department, have we met our obligation as board members?
If you disclose that you had communications and at least a summary of those communications, or you don't recall anything that's
The
not
summary
consistent
is
with
that
the
we
briefs,
discussed
then
the
yes.
issues in the briefing.
Then yes, I think you've met your obligation to say, there was nothing that I recall that was discussed that's not contained in the briefing. And you can ask the parties, do you recall any conversations or communications, written or oral, that we may have had that's not contained in the briefing? And if they say no, then I think you've done what you're expected to do.
Okay, Member Runner has an issue with that.
I can't say that I would say that there was, again, this would be, it's easy on the department side. Again, would be going not to FTB, but for old BOE conversations. We probably always were discussing things that were in the record, so that's not a problem. The problem is I can't say that definitively in regards to the taxpayer. The taxpayer may have given us all kinds of information in a meeting, in a conversation, in a phone call. So I can't say that definitively that it did not have any.
What about saying to the best of your ability? Can we, if the best of your ability, you know, I mean, we just need some closure to this?
Did we not get, well, I thought the way we had left was that we were asking for the a clarification in regards
All
to
parties.
one of two things. One was the issue of the clarification in regards to communications prior to July 1st, whether or not ex parte applied. And the secondary issue to that, and it was then, if it didn't, that there would be a clear waiver then of any expectation in reporting of ex parte by both tax agencies. Did that not happen?
In my opinion, communications prior to July 1, because the proceeding is still pending and you're still operating as presiding officers, should be disclosed.
Okay, we were always presiding officers. From the time this hit appeal, we were the presiding officer. So we have always been the presiding officer. That didn't change as of July 1. So,
The application changed as of July 1.
I don't know if that answers Mr. Runner's question, but I defer.
No, and again, I think we're in the, it seems to me we just had this conversation. We took a break to get clarification. So am I understanding that there has been no clarification in regards to whether or not ex parte applied prior to July 1st, outside of what you've already opined?
My opinion has not changed. My opinion
But
is
we
that
didn't
it
ask
needs
your
to be
opinion. We
disclosed.
stopped asking your opinion. We asked for going back to the tax agencies and to get greater clarification. So did we not hear back from GovOps or anybody else?
I'm not sure
Well,
if someone
FTB is here, Mr.
from the board or the department would have spoken with them.
Senator Runner, we do have people that are looking at it back at FTB, but we don't have a response
Okay,
yet.
so we really don't have an answer to the
We
question?
we do not. We're
Do
looking
we
at
have
it.
any-
We're not
Do we
ready.
have one?
My understanding is that our chief counsel spoke with the assistant chief counsel, Amy Kellie, and she agreed that that was the application. But I did not speak with anyone at the department.
Okay,
Well,
okay.
why don't we have the department go on record as to what their understanding is?
Okay.
And I've been told by our legal counsel that the Department of Tax and Fee Administration will not provide the board with any general legal advice.
Wait a minute, that,
no, that's not what we want. We want clarification as to your understanding of the ex parte. We didn't
So-
ask you for your advice. We want to know how it applies, how your department sees it applies.
appeals here to answer our questions, so can you answer it? I mean, you're not representing the
Well,
department, you're representing the board.
so you're- and-
Based on your testimony
Okay,
earlier.
it started as of July 1. Does anyone disagree with that?
Everyone.
That was the legislation, that's the statute. July 1 was the date. If we make a very simple blanket statement that we may or may not have had ex parte communications with both the taxpayers and the departments, and we were disclosing to the best of our ability for the purpose of this hearing, that is the case, and that we will get a response from everybody within 2 weeks that we can circulate amongst us so that we don't continue to get into this quagmire. Would that be unacceptable? I would like to make a suggestion that our council opine, if we disclose that we may or may not have had conversations with the taxpayer and the department, and to the best of our knowledge, we discussed the issues in the briefing, and we've met our obligation.
Well, that doesn't solve the problem, though. I mean.
Well, it doesn't solve the problem,
if
but
I may,
allows
Madam
us
Chair.
to move forward
The
with
challenge
this
would-
hearing.
The challenge would be in the appellant's situation, if the appellant learns subsequent to the member's voting, believes that a member that voted against him, that he provided or they provided certain information, can ask that that member be recused and the case be heard again. Based on their testimony, that additional information was provided. And we don't know. I mean, I would have to say, well, he's probably, I don't know if he's right or wrong.
I think what might be the answer to that, if anybody asked that this be reheard, it wouldn't come before us, it would come before the ALJs. We quit as of December.
It may not allow it to be reheard.
Yeah, it may end up in a court proceeding.
Right.
I mean,
Which it may end up anyway.
I'm personally prepared to, let me just clarify, I'm prepared to hear most of these cases because I haven't had ex parte communication with most of them. But I would like to have a waiver from the department if I could get it at some point before I go on the record. Even though I or an ability to be able to say, make a statement that clarifies that I don't know if there's any additional information, and if any additional information comes about later as a result of a court proceedings or a recollection on the part of the department or the appellant, then I can have the option of recusing myself from that vote. I don't know if I could recuse myself. That's the problem. I don't know if I can recuse myself
Okay.
after hearing the case.
What I'd like to suggest is that we make a blanket statement, that we hear the cases, we maybe don't make any decisions, and then by tomorrow, your department come back with us with a definitive answer before we vote.
A definitive answer about whether it's
A
sufficient.
definitive answer as to the July 1 date and any waivers, what else is there, Mr. Runner?
Well, I mean, either the definitive date that didn't apply or waivers, if indeed they interpreted did apply.
Yeah, okay.
I
The
didn't
definitive date being July 1, which is what's in the statute, the legislation. Is that the definitive date? Is that the deciding going forward, which it should be, because it certainly didn't apply prior to the statute. And then if not, if you find not, then we want to know from the department what, will they provide waivers, or how are they specifically handling this in all cases, and the taxpayer win, lose, or draw? Okay? Because I think it's pretty obvious that, I mean, it's all about who loses here. If you win the case, you're not going to go forward. If you lose the case for some reason, you're going to try to use this as a little tool, and that's what we're trying to avoid.
So then on the record before each matter continues, will the members be able to say, I recall having conversations?
Or we'll just
they
say,
were consistent?
I'm going to make a
Or-
blanket statement right now. We had conversations, or we believe we probably had conversations with everyone that's appearing today. That being said, there was nothing discussed that we understand or that we recollect that was outside the record. And I feel I've met my obligation. And I don't have to say it for each case. I'm just saying it blanket for the day, because that is the truth. We think we've probably spoken to everybody, either myself or my staff. There's no information that was received that's not of the record that we are aware of. And that way, I will be willing to go forward and proceed with the hearing, but I do want by tomorrow morning, because if we can get this shoved down our throat in one day, you all can respond pretty quick on your waivers. So everybody needs to kick it up. We have another hearing tomorrow. We can vote at the end of the day tomorrow, but we can't have this discord. I mean, it happened to all of us real fast, and nobody benefits by not just having a simple solution and moving forward, because it's not supposed to be a war here. It's supposed to be getting to the right answer. And so that's what I'm willing.
I think the reason why, and I don't know exactly how these matters proceed, but the reason why I would suggest that you do it for each of them is so that the record for that matter is clear. And as repetitive as that sounds, I think that the parties would want a clear record should this ever be challenged. If the
Okay,
decision of
I'll
the
just
board
read.
should ever be challenged.
That is the point.
That's the problem.
That is exactly the point, that the appellant could challenge whatever we say and do.
Well,
Well,
any
if the
one of the parties could always challenge what you say or do, but the point that I'm trying to make is that if you can state to the best of your ability what you remember, or say, I don't recall anything, and ask the parties, do you recall anything, or do you recall anything other than what I'm disclosing, I think that sets the record pretty clear. And I think you've
Okay, so
discharged your
before
obligation.
each hearing, we're going to disclose, we may or may not have had, to the best of our recollection. Then we're going to ask each each, the appellant and the department, what?
I think that you would ask them, if you say, I know we had conversations, I think they are completely consistent with what's in the briefing, and there was nothing discussed that's outside of the briefing, ask them, do you recall any other written or oral communications that we may have had?
Okay,
that
and I
are
would
not-
ask that you ask that question before each hearing. Ask that question of the department, get it, and ask that question of the appellant, and get it on record.
I can do that.
Okay, good. Are we ready to go? And I also want a clear, answer before we vote tomorrow on anything else. What was I talking about on the date? And if the date's not July 1, as we all understand the statute to read, then will the department waive? Are you ready to go forward, members, and hear a case and then just not vote?
And, well, I'll
With-
be interested
with
in
the-
listening carefully as to how council questions both the department and the members in regards to this issue.
Okay, well, let's get on to the first case and figure out how this goes. Okay, thank you, members, guests, taxpayers, or not. Anyway, we already did our pledge. We've had a big discussion. Ms. Richmond, please introduce the first item.
Our first item is B1, Richard R. Betchley and Kellie S. Brunk. Please come forward.
Okay, I will start this out. To the best of my knowledge, we did have, my office did have conversations with the taxpayer and the department. We discussed the issues in the briefing, both by the taxpayer and the department. And that's to the best of my knowledge.
I
at
thought the
this
council
point.
was going to ask the question.
Well, council's going to ask the questions of both of these people.
I think I could ask all of the board members to go down the road,
Okay,
down the line,
thank you.
if you
That's
recall
good.
receiving any written or oral communications from either party in the proceeding before you that has not been disclosed prior to now.
Have we received any oral or written information by either party that has not been disclosed to either party?
Correct.
And I would have to say, to the best of my knowledge, no, we did have conversations, but we believe that it was, we discussed the issues in the briefing, and the briefing is on record.
Okay, we're just going to go down the line, huh?
Right.
All right. I can call from memory. To the best of my knowledge, we've had communications with the appellant, Mr. Richard R. Betchard, in regards to the upcoming appeals, the current appeal before us, case number 874758, calendared for today. The following persons were in attendance with the meeting: myself, Linda Chain, and Saba Sriracha and Fletcher. We also believe that conversations were held with the secretary or receptionist. To the extent that those conversations were held, we don't know the extent of that, have no knowledge of it whatsoever, and any other subsequent conversations we may have had, can't recall those conversations in any detail.
That's good.
Hold on, I'm checking.
Okay.
Chairman,
I'll
I can
go.
Okay, go ahead. I'm sorry.
While this case was under submission, or excuse me, 30/30/30 in 2016, appellant left a voice message to discuss the case. I did not return the call. Today, July 27th, I spoke with the appellant in the lobby. He confirmed that he did call me merely to say thank you.
I have not had conversation with this taxpayer nor the department since July 1st. when I believe this law went into effect. And I believe any conversations that may or may not have taken place prior to July 1st are not applicable to the law.
Member Ma?
I do not believe that my office or myself has met with the appellants or received any documents or information.
I would
from
ask the appellants whether or not they recall any communications with any of the members about this matter other than what has been disclosed.
Mr. Betchley?
Will you answer me? I'm sorry, I couldn't, I'm
I know,
having a hard
finally
time
your
hearing
turn.
it, so the volume's pretty low. Can you hear me okay?
Yep.
No, to the best, I mean, I don't want to say to the best of my knowledge because it's a fact. I have not had any conversations with anybody sharing any information that hasn't been disclosed to everybody anywhere that would listen. I mean, I am an open book, and everything that I have mentioned has previously gone to the Franchise Tax Board on a minimum of 19 occasions that we have documented. So, no, I did, if I have to address each member directly, Ms. Stowers is correct. I just called because after 8 years of the Franchise Tax Board coming after me, it was finally a year ago I had an opportunity to meet with people who would really listen. Franchise Tax Board denied every one of my rights to meet. And when Ms. Stowers apologized on the record on behalf of the state, I was grateful, and I left a message to thank her. Mr. Horton, I had a couple calls with his staff. His previous staff counsel had sent me some information and some ideas, helped me when this was all happening. I had just had 2 strokes as a result of what the Franchise Tax Board had guns to my head. I'm sure you've seen all of that. And so I did get some help as to where could I go, taxpayers advocates, those sort of things. And I just asked what a normal person would ask of elected representatives. In Ms. Harkey's case, I've never communicated to her directly. A couple of attorneys on her staff helped me probably more than a year and a half, 2 years ago. And in Mr. Runner's case, I only received a call from an attorney on his staff before the last hearing who had a couple questions about the submission I had submitted for the board in advance of the hearing, and that was it. And in Ms. Ma's case, I have had no conversations whatsoever or exchange with anyone.
I would ask the representatives from the board whether or not you have, you need an opportunity to reply to or respond to any of the communications that have been disclosed.
I'm not aware of any ex parte communications that we have had with any of the board members.
And you, do you need an opportunity to respond to any of the communications that have been disclosed?
No.
Okay. And you're not aware of any communications you have had with respect to this matter?
Correct.
Okay.
Okay, we can begin, and thank you very much for your patience. Mr. Benchley, you have 10 minutes to present your case. Oh, excuse me, I'm sorry, I'm off script, pardon me.
That's okay.
Appeals, will you please introduce the items for the record?
Absolutely. Good morning, Ms. Harkey, members, Anthony Eppolite and Lou Ambrose of the Appeals Bureau. There are 4 issues before the board in this matter. First, whether appellants have substantiated their claimed capital improvements for the purpose of calculating the capital gain on the sale of the residence in the 2005 tax year. Second, whether Dakota Enterprises made bona fide loans or dividend distributions to appellant husband, its sole shareholder in the 2006, 2007, and 2008 tax years. Third, whether appellants calculated their home mortgage interest deduction correctly in the 2008 tax year. And fourth, whether appellants have shown reasonable cause for the late filing of their tax returns for the 2005, 2006, and 2007 tax years. This is the continuation of the September 27, 2016 oral hearing of this matter. At that time, the board requested additional briefing through the 30-30-30 process, seeking documentation relating to the capital improvements made to appellant's Lafayette residence. As the parties have already fully addressed the board at the September 2016 hearing, The Appeals Bureau requests that the parties focus their discussion today on what was requested of them in the additional briefing letter. Thank you.
Thank you. Mr. Betchley, you have 10 minutes to discuss the items that were in the additional briefing matter.
Thank you. Thank you again also for putting me on the agenda. I don't know if you all, I don't want to go into that I'm the guy that all this stuff happened to. You probably remember that. You know, the Franchise Tax Board has written to me on numerous occasions that I owed $274. They went to the IRS and requested that I be audited. The IRS complied. They were trying to, the Franchise Tax Board filed felony tax evasion charges against me. They said the amount was $88,000 for over 4 years. Of course, subsequently, as we all know, the way this worked out, finally a Superior Court judge reversed everything, completely exonerated me, and threw all the charges from the Franchise Tax Board out. But this is very traumatic for us. I mean, the strokes, I have a special needs child. It's been a rough go for us. But one of the clerks here, or I shouldn't say clerk, one of the colleagues asked me to address my comments now to the exhibits that I brought today, because they bear on what the discussion was this morning. I asked after the last hearing, because I remember I was asked by the board to do 3 things, but one of the byproducts of my stroke is memory loss. So I asked to get the official transcript so I could be sure to comply with everything that was directly requested. But there were a couple things that were in that transcript. First, I received an email from Mr. Epplite, I'm sorry if I get the name wrong, who told me the transcript would do me no good. But I did manage to get it through Ms. Richmond's department. But it was interesting that in the official transcript, the Franchise Tax Board admitted that I didn't know anything at that point because my appeal rights had not been exhausted. It was my first appeal, and I didn't owe any taxes. And yet, they've also published on their website that I was a tax evader, filed 6 tax liens in 3 counties around the state, which is kind of interesting. But anyway, that is on page 42 of the official transcript. In the last meeting, Mr. Runner asked a question and he asked it of Mr. Epplite, that because I produced the evidence of a full IRS audit, of checks being issued that I had overpaid taxes, even proof that the Franchise Tax Board had paid me back or credited me for overpayment of taxes in one of these years, Mr. Runner asked Mr. Epplite if there was any collection or any activity or any debts due to the IRS. Mr. Epplite said no. That's in the official transcript. And then on pages 77 and 78, Ms. Harkey asked the Franchise Tax Board to review the disputed information with me within 30 days and stated that the Franchise Tax Board department would be back to me to work with me and possibly a member of her staff. On transcript page 80, Mr. Horton states the Franchise Tax Board is to look at the entire case, because when I was being audited by the Franchise Tax Board auditor, he tried to help me. He found a number of deductions that I was entitled to, but I didn't take because I didn't think I owed any taxes, as the letters from the Franchise Tax Board said to me. So excuse me, I'm a little nervous about this. So he asked, let's see, so I asked on the record, the official transcript, I asked the board if we were going to open this up to a 30-30-30, was I entitled to bring forth these additional deductions that the Franchise Tax Board auditor had told me. He had told me also he wasn't allowed to use them because they had directed him to just audit what I had submitted. This question was then asked by Ms. Ma to the appeals section if they would work with me. And Mr. Epplite's response on the record is sure. Then, which is this, and this is leading somewhere, I assure you, on page 82, Mr. Epplite states very directly, and I have to quote this because it applies to the things you were talking about this morning. And we definitely suggest and recommend that during this process that you work with the Franchise Tax Board as much as possible, so when this matter does come back before the board, as much as possible can be resolved and has been resolved by the time this returns to the board for a follow-up. So why is that important? I mean, it's important because after receiving that official transcript and the specific 3 requests from this panel, I attempted to do just that. I asked for the transcript. I got, the exhibit is attached to that. I got the communication from Mr. Eppolite saying the transcript would do me no good. I then wrote to Ms. Coakley at the direction the board had asked me to do, to ask who I should work with to comply with the board's request. That email is in your packet as well. 3 hours later, on that same day, I got an email from Mr. Eppolite stating that I should only address the home issue, none of the other tax issues that were brought up. And he said, quote, specifically requesting that Ms. Coakley not respond to me. That email there is in there too. So it didn't surprise me, you know, after trying for 9 years to work with the Franchise Tax Board and being declined every meeting with a taxpayer advocate or any meeting with an auditor or any meeting to go through things and try and follow this up, that I would get a letter from another staff attorney that said, you know, he's directed the Franchise Tax Board not to comply with your orders. That email from him is in that packet as well. I wrote on January 5th to Mr. Eppolite and asked if explaining, you know, that this is what the transcript said and I was just trying to follow through. There was no response to that. And then that same afternoon, I wrote to Ms. Coakley to confirm that it was her understanding that the board wanted us to work together about a resolution for the next meeting, but she was out of town and I never received a response. I mean, I had been told through the process that coming to the Board of Appeals was going to be a waste of time, but I haven't. You know, this is the first time in 9 years, 9 years, 2 strokes, the Franchise Tax Board agent on film holding a gun to my head saying, I'm going to see that you die in prison. And this was the first time I'd ever had an opportunity where somebody would listen and actually look at these documents, all produced by the Franchise Tax Board. The letters that said I owed $274. Even the testimony by a district attorney that said I owed $278. So all those exhibits are enclosed. I really don't think I'm going to need my full 10 minutes because the only thing that Mr. Eppolite said I could address today, even though the Franchise Tax Board did provide all the deductions that I would be entitled to, that Mr. Horton went on record to being allowed into this discussion. The only thing I would be allowed to address was the property improvements to my home of 19 and a half years. And Ms. Harkey, you were correct at the last meeting. You know, it was, 20-something years later, and none of the banks had the canceled checks. None of them had any of the records about the loans. They've all been destroyed. I had the mortgage interest deductions. I had all of that. That showed that I had those mortgages of those amounts, so the house was clearly worth more than what the Franchise Tax Board said. So what the next best thing I could do after contacting banks that had been merged, banks that had closed, all of that, next best thing I could do was I went to the MLS and I went to the realtors who were involved in helping to sell it, who did a history on the house. And believe it or not, you wouldn't think the county recorder would be so helpful. The county recorder pulled all the permits, all the plans. I had pictures, the different stages, showing at different stages in the life, the improvements, and I submitted that. And so you have all of that. I'm sorry, there's drafting drawings and all that kind of stuff. But there's also the permits. And the response from the Franchise Tax Board was, you don't have canceled checks, you don't have receipts. And they just have refused. I'll remind the panel again that under sworn testimony, under penalty of perjury, the Franchise Tax Board agent who put the gun to my head told me I would die in prison. He was going to be sure I died in prison. He testified I had not filed any taxes in 18 years. Of course, I had because they'd issued me refunds for overpayment. And he also testified that the house cost $960,000, and as he put it, $400,000 of improvements. Now, that's unacceptable to the Franchise Tax Board, apparently, because They're saying it's unacceptable. So I don't know how you back your agent under oath and then say, well, no. So it's either perjury one way or the other. I mean, I don't know how you have it both ways. But that's their position, is that none of those improvements were made, and then in their submission to you, they show a cost of the house of, what, $161,000 or something like that in that little table, for a 4,200 square foot house on 4.5 acres, as you saw in the materials, and this was 1988, but you can't even put appliances in your kitchen for $31 a foot. So I'm going to stop. I don't think I've used 10 minutes, but I'm going to stop there because I'm sure you'll have questions. And I included also, I should state, the other copies of letters, of emails, of the direction I received or direction I was told not to go and not to meet with the Franchise Tax Board. I apparently, I don't know, I didn't apply for another, I had been declined 3 times by the Taxpayers Advocate to meet with me. But apparently I applied again, which I don't know anything about because I got a letter last month saying they've turned me down for any meeting about tax consultation and they would get back to me with an appropriate party in 30 days. So my last attachment is not even complete, but this is 10 points that the Franchise Tax Board does not deny. Now, if they do deny it, we can right here address every one of those, and we have third-party independent verification, that being court transcripts, letters from the Franchise Tax Board, medical records, any third-party thing. They have agreed that virtually every one of my taxpayer rights have been violated in this matter in terms of threats to my life, my freedom, my access to documentation. As you saw in there, they refused to give me all my records. They copied the cover sheet of every file. It's what they gave me. And that's entered into the court transcript, which I have provided previously. They issued a press release about arresting me before I was arrested. It's on the newsstands. They have not denied that because that's public record as well. We have the newspapers, we have their press release. They posted their press release on their website. They admitted under oath that they never wanted to know any of my tax deductions before they arrested me. This is directly under oath sworn testimony from the Franchise Tax Board agent. They wrote on many occasions, I've produced 4 separate occasions where they've produced letters that the amount I owed was less than $300, it was $274.38 if I remember right, and it was paid immediately. And that was even confirmed by a county district attorney in a court transcript stating his comment was that it was $278. The Franchise Tax Board agent clearly wasn't telling the truth on the witness stand. I filed a report with the Franchise Tax Board that found its way to a guy named Tom McPherson, who apparently, I don't know if he still is or was, the Chief of Internal Affairs, I guess the equivalent of it. And he wrote back to me that they had looked into it. They didn't feel that the use of force against me for what they thought was $88,000, the gun to my head and dragging me out of the house, they didn't think that was a violation. But they did discipline him in some way. And they wrote that he was disciplined, but because it was an internal matter, they would not divulge it.
Time's expired.
As I understand it now, a Superior Court judge is probably going to be getting that report.
Mr. Betchley,
Yes.
your time has expired. Do you
Okay.
need a few more minutes to wrap up?
I won't even take 1 minute. I'll just say the last thing is that when I read the submissions from the Franchise Tax Board, they act like a Superior Court judge believed them. Their response is, well, that was the criminal matter they brought against me. This is a civil matter. I mean, I need to know on the record if the Franchise Tax Board just doesn't care what the IRS, H&R Block, and the Superior Court judge care about. That will stop. I'm sorry I used it too, full time.
Thank you, Mr. Betchley. That's fine. To the department, please introduce yourself for the record, and you have 10 minutes.
Good morning, Chairwoman Harkey and members of the board. My name is Suzanne Coakley. Seated next to me is my co-counsel Adam Seuss and Craig Scott. Together we represent Franchise Tax Board. This appeal originally involved 4 issues which were presented before your board last September. They include whether appellants have substantiated basis of approximately $1.5 million for their home located in Lafayette for 2005, whether appellants have established that they can take a home mortgage interest deduction for 2 properties for 2008, whether Dakota Corporation made bona fide loans to appellant husband during 2006, 2007, and 2008, and lastly, whether appellants have shown reasonable cause for filing delinquent joint returns for 2005, 2006, and 2007. Last September, your board heard oral arguments in appellant's appeal and granted a motion requesting additional information limited to the issue of gain from the sale of appellant's home in Lafayette, California. Specifically, your board allowed appellants an opportunity to provide additional evidence to support their basis. The issue before your board today is whether appellants have provided new information, which entitles them to an increase in basis in their Lafayette home over the amount of approximately $880,000, which respondent has already allowed. In 2005, appellants sold their home and reported gain of $196,000 after applying basis of approximately $1.5 million, as well as the principal residence exclusion. The law provides that basis is the property's initial cost, plus the costs associated with capital improvements. The burden is upon the taxpayer to establish basis. Respondent relied on property tax records to provide an estimate of appellant's basis. In 2004, prior to the sale of the home, property tax records show an assessed value of appellant's home of approximately $880,000. As I mentioned before, respondent allowed the entire assessed value of the Lafayette property. After the hearing in September, appellants provided the following items to your board in an effort to increase their basis. These items include permits and plans for construction of their home, plans for a pool house structure, and decks, as well as photos of their home and property. After carefully reviewing the information and documents provided by appellants, it is clear that appellant's basis should not be increased beyond the amount already allowed because the construction of their home, pool house structure, as well as decks were included in the assessed value of the home. According to records from the Building Inspection Division of Contra Costa County, appellants pulled a permit to construct a new single-family residence in 1987. Then in 1995, appellants pulled 3 separate permits to construct a pool house structure, as well as decks for their Lafayette home. Then the Contra Costa County Tax Assessor's Office assessed the value of appellant's home in the amount of $750,000 after the completion of all capital improvements, including the pool house structure, and decks. Then from 1996 through 2004, the assessed value of appellant's home increased annually at a rate that did not exceed 2% as provided by Prop 13, from $750,000 to approximately $880,000. Respondent allowed the additional amount of $130,000 as part of appellant's basis to account for additional costs or improvements which are not documented by permits. In conclusion, it is respondent's position that the evidence provided by appellants are for items already allowed by respondent because the construction of their home, pool house structure, and decks were included in the assessed value of the home. And appellants have not provided new evidence showing that they are entitled to an increase in basis over the amount already allowed by respondent. In closing, I respectfully ask your board to sustain Respondent Franchise Tax Board's position on this issue. Thank you.
Thank you. Mr. Betchley, you have 5 minutes to respond.
I couldn't hear most of that, but I'm sure it's the same thing that's in their brief.
Well, let me just clarify. What we're basically dealing with is the additional evidence to prove that you brought that proved that your basis of 1.479 is verified versus the FTB's allowed basis of 878,571.
Yeah, that's the original argument. So I guess the only thing I would say again in response to that is I tried to do everything we could. There were no no bank records anymore because so much time had passed. I produced all the additions in terms of permits, in terms of pictures, all those things that were done since the original house was made. There was no way for me to document, the cost of the gate or any of that because I didn't have all those canceled checks and couldn't get them. So, and just like before, my main defense is I guess as simple as their agent testified under oath that I had spent that money. So I don't know. I have previously produced the official court transcript under penalty of perjury of what he said. So I tried to do what I could. If that's not enough, I don't know what else to do. You look everywhere. I think, Ms. Harkey, last time you were looking at Google Earth or something, and you were seeing the home, very complex home, very costly to build home, and you saw what I sold it for, and what it was since offered for before that, and what the loan balances were. So it was clearly improved. Those loan balances and everything support the fact that the basis was probably much higher than what I claimed, but I could only itemize the 1.4 that the Franchise Tax Board auditor testified under oath about. So that's the best way I can do that. In terms of the other deductions, this thing about and I'm very grateful to the Franchise Tax Board auditor. He tried to be really fair. He told me what he was told to do, and he said he was going to try and help me. And he said, I've gone through all these things. You haven't taken deductions for your special needs deductions. You haven't taken deductions for loan losses. And he goes, they're going to claim that loans you took from the business were income. They were dividends. He says, but they're not addressing these other losses, that what the loans were used for, which was investing in real estate. And they're not going to address that. And he said, here's where your checks are, here are the numbers. And he ran down it all with me. He said, these are allowable losses that will offset what they're claiming or going to claim is, in effect, dividends. So I offered, as you've seen through the record, I offered 19 times to Selby Stanislaus. I offered 4 times to the tax advocate. I offered to everybody else who would listen those deductions. And I did send them to Stanislaus, every check number, every amount, the date, and all of that, and the fact that I lost it all in the recession. So that's the only way I can respond to that at this time.
Thank you. Okay, members, Member Ma.
So I do have a question. I'm looking at the escrow closing statement in 2005. It showed you sold the house for $2.175. It also shows that you had to pay off a first mortgage loan of $1.5 million, a second mortgage loan of $600,000.
Yes.
So that's, the two of them add up to 2.1.
Well, I don't expect you to remember this, but because I live it every day, and you have so many things to deal
Right,
with.
if you
But
can just remind
that
me.
house was appraised. I had submitted appraisal 2 years before that house had been appraised at $2.8 million. So the loans were based on that, and you have that appraisal in file, I believe. So unfortunately, or fortunately, it depends on how you look at it, it was mortgaged to 80%. But then when the property value started to fall, that shows the improvements, by the way.
Okay, so I'm not a banker, but I'm just wondering, to the banker, how do, it was 2 years, a loan 2 years before, based on an appraisal, obviously, because the banks always require an appraisal before they make the loan. And how, is it based on I guess the appraisal takes into account the cost that goes into building a house, as well as the fair market value that it's
Right, the
market,
replacement
right?
cost, which would be
Replacement
the
cost.
cost.
So would the replacement cost be,
That doesn't necessarily justify what was spent at the time, which is the problem, because there was inflation and whatnot. You'd have, in this case, you would have probably, let's just assume it would be a lesser expense to construct in, 95 or whenever it was, 1998 or 1988. And then pool in 95 and pool house pavilion in 95. So when you got your appraisal, the cost to replace is probably going to be higher. You also have to appreciation of the property, the land value. All that probably is considerably higher. So the appraisal doesn't necessarily reflect the cost. It includes cost, the cost component, but it doesn't necessarily reflect the cost at the time of construction.
and when you presented the appraisal, did you give us an appraisal? I don't have the appraisal in there.
Yes, sir. In the first go-round of thick
Okay.
exhibits.
I don't know if anyone has it, but Just
And I also gave you the listings from originally, like several years later, and then when it was, that showed the changes in the house of what had gone, as well as the plans that were submitted.
I thought normally in an appraisal, there's like 3 different methods to assess, and usually one is cost of replacement. I don't have the,
Right. Cost of
Cost
replacement,
replace new, market value.
right.
market value, and then, what's the other one? I'm not an appraiser, so there's 3. But we know there's cost, and we know that there's the market value. So I don't have the appraisal here in my file, because we're only we were looking at any additional items that might be produced that might justify changing the allowed basis from 878 to 1.479. Unless the appraisal did include the costs of construction at the time they were made, which it may, but that might be really unusual. I don't think you'd take the original, well, maybe you'd pull the permits, so. But then they're stuck with what we've got here. The permits, the permit value was 132,026 on the home in 1988. The pool was 25,000 permit value, and the house pavilion, 3,535. So that's what you'd have if you were going back, unless you produced other evidence, which is what we're looking for.
And when you pull a permit and it says the pool is 25,000, I know you pull a permit before you actually build, but what happens if the pool costs significantly more? Do they go back? Or is the taxpayer supposed to go back and tell the assessor that the pool wasn't 25,000, was actually 40,000?
I do not know that. I was not an appraiser. We're going to get into a lot in property tax assessment.
Exactly, well, we might as well.
But I don't have that answer on this. This is an income tax case. I don't have that answer from my experience. Yes?
I'm going to actually ask appeals, maybe they could speak to that, because I recall in prior cases when there was some substantial improvements, the assessor would come out and do a value once the improvements are completed. And a lot of times, that's the starting value. So let's say in Ms. Ma's example, they start with a pool and they said job value 25,000, but it actually ended up being closer to 50,000. Would that be reflected in the assessed value once the job is completed? I'm hoping that Mr. Ambrose, who has some property tax experience, could speak to that.
Well, yeah, it's reflected as new construction. Yeah, I mean, it's an improvement, it's an addition. I mean, the house was, and the property was already there, right? Mm-hmm. And they put a pool in. So, yeah, it'd be reflected as new construction. So it would be added to the value, to the adjusted base year value as it stood on the property, before that improvement was put in. So it should be reflected on as in the assessed value, well, in the new adjusted base year value.
So even if they thought it was going to be 25,000, but it ended up being 50 or 60,000, it would be in that.
Sure, yeah, I mean,
value.
yeah, right, cost doesn't equate to fair market value, generally.
But I
But
guess
that's if the assessor comes out.
The question
me?
is, if the assessor comes out, or even if the assessor doesn't come out, what do they use to deal with the assessment? The permit?
I think the assessor gets copies of all the permits, and then whether they have somebody come out and do a site inspection, I guess it's up to the office.
Yeah, but they wouldn't necessarily ask for costs. What's your real cost?
Yes, they would.
What's your real cost? Did you lie to us?
We have an expert in the audience here.
Okay, can we have an expert in the audience? I guess we can't do that. can we?
Yeah, a property tax appraisal expert, and he's nodding and saying that yes, the assessor would ask for the costs.
Okay.
And would ask for copies of the check, or if they said, your pool is 25,000, $100,000, is that how much it costs? And they would say, show us your invoice, your final invoice of how much it is?
I would think so, yeah, sure, yeah. But, I mean, whether they, to some extent, they might rely on that, I just don't know. Again, I'm not an appraiser.
Depends on the due diligence of the assessor.
Right.
Okay.
Madam Chair, just a quick
Yes,
question.
Member Horton.
Thank you, Madam Chair. Question of the department, or maybe the appraiser can listen in and nod his head one way or another again. The assessor goes out and does an assessment. The valuation of the property is what's perceived to be the market value. Is that right or wrong?
Can you repeat your question? I wasn't able to.
The valuation, the assessor's value is what they perceive to be the market value.
We got a yes coming
That
from
is
up
my
there.
understanding.
So the
Yeah,
market
that's
value
fair.
would be the assessor's value.
Where's this assessor? You guys are watching for the nodding.
Way up at the top.
Oh, okay, I see.
Under In
Oh.
God We Trust.
All right, I got it. So, Dean, so the concern that I have is that in the real estate market, typically there are improvements that don't really add a real value to the property. You know, your realtor will be very careful to advise you that a pool adds no value whatsoever to the property unless the person actually wants a pool. So the market value of a pool is relative. And there's a study that just came out that said basically, in general, the market value of assessed value of a pool is 50% of what it actually costs you to put it in. And my neighbor actually had a pool, to my surprise, and filled it up with dirt. That's how much it was important to her. That's the value. So if the department used the assessed value on these items, did they give consideration to the differential between the assessed value and the actual construction costs based on some analysis in the market as to what, if you add they say if you add a kitchen, that adds value and you can get a one-for-one in the valuation or that type of evidence?
Okay, so the information I got from the Contra Costa County Tax Assessor's Office is as follows. I called them to get some more information myself. They said that copies of all building permits are sent to the assessor's office by the cities and counties. And if the construction is new, I think we already went over this before, such as a room addition, a pool, what have you, a reappraisal is required. And in appraising the new construction, the market value of the addition is determined and then added to the value of the existing property. So that is how the tax assessor's office operates.
Okay, so it doesn't really take in consideration the actual construction value, the actual construction cost?
Not always.
Okay. Were there, question of the appellant, were there, and I know you're not necessarily a real estate agent or appraiser, but we're talking, well, back to the department, is there an itemized listing of the improvements under consideration by the board? Like pool house? We've got that somewhere,
I have
something.
here $163,455, which is the home construction, the pool pavilion, pool house pavilion, and the deck.
Yeah, see, based on my experience as a realtor, the pool, the actual construction cost of a pool doesn't really add value to the property. So in that case, the construction costs might be higher than the numbers used by the department. If it's a pool house, the more elaborate they get, the less actual value that it adds to the cost. You go in and you put a regular sink in versus a Kohler sink, you're just going to get a valuation on the cheapest sink that you can get from Home Depot.
Yeah.
So inherently, the using of the appraised value alone is as it relates to the construction items that I've heard, is lower than what the actual construction costs would be because they're using the market value and these items don't really add value, significant value to the market. Or they do, I don't, generally, my experience is they don't. So, the challenge is that unless there's some industry average, if we were to take these itemized items and say, what value does that add to the property based on the industry average? The number that I saw for a pool was 50%. And so inherently, you would get, the construction cost would be 50% higher than the assessor's valuation of the property. Did the department take a look at this as a potential way of determining the construction value?
No, I mean, the problem that respondent had with the situation is that we have no other way to value the pool or the improvements because we didn't get any documentation or substantiation from the taxpayer. That's really what we were looking for. That's what would be helpful.
The courts have sort of ruled that if the department is aware that a pool was there, they're aware that a pool was there, they can see from the pictures that the pool is constructed and seems to have either expensive tile, not cheap tile, whatever. I mean, the basic fundamental structure is the basic fundamental structure, wood and so forth. It is the extras that the department does, which can be reflected in the picture. They've said that if you can determine, based on a picture and based on the testimony of the appellant, then you are then the respondent is to give value to that, and somewhat an imputed value. Otherwise, we're left with the testimony of the appellant. It's a statement, but I'd like to hear your thoughts on it.
Sure. You seem to be referring to the Cohan rule?
Yes.
Which is a two-part test where the costs incurred, and if so, provide a reasonable estimate of those costs, very
Right.
heavily against the taxpayer. In this case, respondent's position is that we feel we have applied the Cohan rule because we know that the costs were incurred. You are correct. The only way that we could estimate those costs was to allow the assessed value of the home because the
Based on
assessed
the-
value increased once the capital improvements incurred.
Based on the assessed value, what was the value of the pool? Just as an example. 25,000?
So according to the Building Inspection Division of Contra Costa County, the job value of the pool in 1995 was $25,000. The Contra Costa County Tax Assessor's Office made it very clear that the job value and the market value are not always the same.
What does that mean? In
Well,
your
if-
case, in this case, does that
Well, if
mean
you,
that my apologies for interrupting, does that mean that the county assessor used the market value, or they had evidence as to what the job value, the actual construction cost was, and they used that?
my understanding is that the Tax Assessor's Office used the market value. If you look at the job value and you add up all of the job value costs, it comes to about $163,455 of capital improvements. That's including the construction costs of the home and the capital improvements. Franchise Tax Board allowed far more than that because it was based off of the assessed value of the home. So the Contra Costa County Tax Assessor's Office allowed far more than the job value that you have in front of you, which is from the Building Inspection Division.
Yeah, I have a little bit of a concern, understanding the Cohan rule, that given that the market, the industry says that, just using the pool as an example, that the assessed value is generally 50% less than the actual construction value because it's the market value, and adding a pool and a pool room and a special tile doesn't necessarily add to the market value. So inherently, just using that as an example without going through each item, the valuation, the assessed valuation of these particular construction items is less than what the actual industry would say the construction items was. So was there, on any party's part, was there any effort to just call a pool or call any individuals and see what the value was at that time? That the appellant, in their attempt to defend it, I'm not saying the department has an obligation to do that. The appellant, in the attempt to provide evidence, that you contact, in using this as an example, that you contact other pool builders to ask what it would cost to build a pool at that time? Yes.
Did I? Well, I tried to contact the guys that built the pool, and they were no longer around. But if you saw in the pictures of it, I can't remember what it was that I submitted to the Franchise Tax Board and the IRS as to what the cost total was, because it was done as a complete project with a pool cantilevered out over the hillside.
My question is a third party. Is there a third party that can attest to what the value of the pool would have been in 1995?
Can I assess to, I'm sorry.
Is there a third party?
Is there a third party?
A third party?
Other than yourself?
Probably. I mean, you saw from the pictures, it was a very complex pool, cantilever with a pool house, so probably.
All right. This case has been going on for a while, so I don't know if we can allow more time to get the basic evidence, but that's not my call. But I will say to the department, under the Cohan case, possibly there should have been some effort to try to establish what the actual construction value would have been, given that the assessed value for these particular items is typically quite a bit less than what the actual construction value is, and that's a just standard norm. I see the appraiser up there nodding his head, so that must mean that I'm on track. Okay.
Are there any other questions?
No, I think
Member Stout?
taxpayers should get something, but I don't know what. For the pool. I mean, for the construction. I mean, this is really probably should have went to settlements, but.
Mr. Mayor?
Yes.
So if I understand what you're saying, Mr. Runner, is that you feel that the cost to construct a pool, or the value of the pool, is understated in the assessed value?
If I may speak on behalf of Mr. Runner.
Yeah, I'm sorry, I can't do that.
That's all right. We look
Brilliant question.
I really wasn't trying to isolate just the pool. I was just saying from a methodology perspective, the method of assessing the value using the assessed value is a good method. It's an appropriate method. But when you're faced with items that don't add any market value to the property, and if that is the case, then you're better off using some industry average as to what the cost of what the actual construction cost would have been, because the construction cost for a pool is typically based on, I can't remember the association, but I'll try to pull it up. It's typically 50% less than the market value. So the answer is yes. That's a preacher's way of saying it.
Okay. Then probably what you're saying is that we have a $25,000 permit value, but you believe that you could conceivably justify $50,000 for a pool. Are you looking for anything to that?
Madam Clerk, I would say, I'm just using the pool as an example, but if I was to take the time and itemize each of these items and compare it to the industry average as to what value it adds to the pool, adds to the market value, I would use the industry average to determine what the construction value was, because that's the average construction value.
Okay.
It's an inverted way of getting to that. But
Right, I understand that. We are back here, though, because the appellant was to provide more evidence that what the FTB allowed, which was allowed for the permit values, and they came to, the FTB came to $878,000, which is the $750 assessment, and what does that include?
So the $878,000 includes the acquisition cost, so the initial purchase price of the property, which is $150,000. Then all of the construction costs and capital improvements, which after the completion of all the capital improvements was $750,000. Then the assessed value of the home increased annually until the time of the sale of the home. So there's a $130,000 cushion there that respondent allowed, which is actually not, or allowed as part of the appellant's basis to account for additional costs or improvements, because we assume that there were probably additional costs or improvements and wanted to allow for that.
Okay. The value here is actually irrelevant. What we're trying to establish is how much Mr. Betchley actually paid, and the assessment may not capture that, but that's why it was impending upon Mr. Betchley to produce his checks, invoices, whatever he had. How long has this case been going on?
The audit started in 2012.
In 2012, so it's been a while. And
That's actually not correct. The
Okay,
case
Mr. Betchley.
started in, May of 2009. And it started when I heard there might be an issue about taxes with me, and I contacted the Franchise Tax Board and officials and said, is there anything you need from me? And they've acknowledged that in court transcripts, that yes, they were offered opportunity to meet and to see anything they wanted. They chose instead to arrest me and put it on the web and put it in newspapers.
Yeah, I understand you testified to that, but I guess what I'm asking is, did you bring any additional proof that changes the difference between the 1.479 that you're claiming and the 878 that you were allowed?
Well,
And
I
you
mean,
said you brought in some plans and
I'd
whatnot.
answer that in two ways. One is just simple common sense. When you look at, they've acknowledged that I paid $150,000 for the lot. They've acknowledged I paid a total construction cost at the time the first mortgage was placed on it of $960,000. Then the improvements started. And that's all shown by plans, it's shown by photos, it's shown by the different things that were filed. Then they testified under penalty. I don't know if they're now claiming that Samlick, their agent, has committed perjury, but under the penalty of perjury, he said $400,000 was spent on improvements by me.
Let me just ask you, you just made a comment. You said that there was a mortgage that said that there was $960,000 spent.
Yeah, when the house was built, it had a construction, typical, I bought the land for cash, that became the equity in building the house.
Right.
It was $150,000. The Franchise Tax Board's acknowledged all of this. And then I built the house on top of, after the $150,000 with a construction loan from a local bank that's now not there, La Marinda Bank. It was one of the banks I tried to get to. They were since acquired by U.S. Bank Corp. So I spent days weeks going through, trying to track down this stuff. And then at the time when you get your completion and your completion notice and your occupancy permit, they can close a first mortgage, as you know.
Right.
And that first mortgage was put on then at 80% of the $960,000. Then the improvements started, and the improvements, I think, there's no reason you would recall this, but most all of the improvements, other than things that were less than $10,000, were all kind of put in as...
That's the first comment that really makes a bit of a difference, is that the $960,000 construction cost, and the first TD was 80%. Is 960 the value of the property that the first TD was based on, or the lot and the house together were $1,000,001?
No, the lot and the house at that time were, I'd say 960 was 960, 980. The
Okay,
two
was the
combined
construction,
together.
was your construction loan for 960?
No, that was the.
What was
complete-
your construction loan for?
I think this construction was six something, 680?
Okay,
It was the
so-
difference between that and the 150 cash paid for the lot.
Okay, so if the construction loan was 6, then see, we're getting back up to the 878 thereabouts. So I don't see that that's making a difference here. So, members, are there any more
I
comments?
just want to comment on, trying to understand what Mr. wrong with me today, Horton was saying regarding the pool. Based what I hear him saying is that the assessed value of the pool, the assessed value is going to be lower than the actual cost to construct the pool.
But value isn't what we're looking at.
But we're trying to get to cost, we're trying to estimate using
No,
the Cohen rule.
if I may-
The cost of the property. So we too, as the sitting body, could apply the Cohen rule and give additional cost estimates to that pool if we chose to.
We could.
Well, I'm.
We could, but we
Just
have a
for the
point of
clarification.
justification. Excuse me, Mr. Horton.
okay,
But
yes.
you could use the Cohen rule, but you still, I believe, would want to justify your percentage or whatever.
Yeah.
That's why I asked the question. So are you saying that the pool value should instead be 25, should be double that? And I got told not necessarily. So I was trying. Thank you.
Okay, now,
Horton.
just for clarification, I was speaking of the construction value, that the appraised value is typically lower than the actual construction value of a pool and of many other construction items that may take place. So the utilization of the assessed value is the best way to go in the absence of that. But the Cohen rule allows you to look at evidence to determine if there are items that are within the assessed value that really have a less of a market value in comparison to the actual construction value.
Okay, so, but what I'm asking, I guess, is specifics. Does anybody want to contribute that there might be something additional that they would be willing to support in some way? Is there any member that is volunteering that? I understand the rule, I understand the law. Problem is, we're down to evidence here, and we're not looking at value, we're looking at the evidence to support the cost.
Do you remember the other list of improvements on there too that did add value? The extra bedroom, the pool house, the driveway, the extra decks, all the landscaping down, it's 4.5 acres. Those were all itemized in
We
there.
have, excuse me, I do have this, capital improvements made.
Yes, that's it.
Right.
Upper acre only landscape and stripping, landscaping actually has a dollar for dollar value according to the real estate market. Replace asphalt driveway with hands in, I think the value is 75 cents to 1. I mean, that's how I would go about sort of doing this, using the industry average and go down and then come up with a calculation as to what the construction value would be based on industry average. Adding a room is typically the appraised value is the same. Japanese garnet fountain has no value whatsoever as far as valuation, would have a construction value. Custom gate for courtyard, depending on the customization, it's just a gate as far as valuation is concerned. But from the construction perspective, it may have an incremental increase in the construction costs. Install living room, windows, planters, dollar for dollar. Additional lower deck, off master and guest bedroom, no real added value to have a lower deck. Deer fence for property. I mean, we're not going to vote on this, so I don't mind. I'll do the work. I mean, but I think my suggestion is that the department take a look at what the industry construction value is for these items compare it to what they've come up with as to what the appraised market value is, and see if there's any differentials. There's data out there that will provide the respondent with a way of inverting, capitalizing the actual value using that data.
Okay.
I mean, the burden
I'm-
of proof, I agree, is not on the department, but if the appellant was to make that type of computation and present it to me, I would accept it. So I don't care who does the work. I mean,
Member
I'm just-
Horton?
Just trying to get it right, that's all.
Construction costs here he
Sir,
has were
one
982.
second, Madam Chair. Respondent?
Just as Ms. Coakley did point out, though, we did allow approximately $130,000 of basis that has not been substantiated. So we believe that provides that cushion for the things that you've been talking about.
So it's your testimony that that 130,000 was a result of you taking this into consideration?
Well, I think we wanted to try to be reasonable and have a cushion here for any additional improvements or costs that are not being captured, and we believe that had that result.
Yeah, I mean, I've often said, and I believe this, is that if the department makes an adjustment and they don't attribute that adjustment to a specific reason, that adjustment has valid. It is valid. It is a valid adjustment. It is not an extra that you just gave away. It is a valid adjustment based on your assessment. So, and if you were to say that based on your assessment, you allowed that because you felt that there was a difference between the construction value and the assessed value as a result of the some industry data that you are aware of, then I could give that some consideration. Otherwise, it was appropriately done, it was the right thing to do, and you had a reason for doing it. You didn't just do it just to make it safe. That's kind of a question.
Well, I think again, giving those Prop 13 increases, just because a property increases in value does not mean that additional improvements were being made. So I'm just pointing out that I believe there is a cushion here.
We're still looking at actual costs. Okay, members, we will take this matter under submission. I'll make a motion
Move
for
to take the
that.
matter under submission.
Thank you.
Second.
It's been moved to take the matter under submission by Member Stowers, second by Member Horton. Any objection? Such will be the order. Thank you. We will be deciding this later. Thank you very much.
Thank you.
Thank you. Okay. Our next case, Ms. Richmond, please introduce our next item.
Our next item is B2A, Fuscoe Engineering, Inc. B2B, Eric Armstrong and Nancy Armstrong. B2C, John Oliver and Cynthia Oliver. B2D, Raymond S. Tokehiro and Thu Chuck. And B2E, Patrick R. Fuscoe and Bonnie K. Fuscoe. Please come forward. This taxpayer has also been granted an additional 10 minutes to present their presentation.
Is this working?
Okay, thank you. Mr. Eppolite, will you please introduce the issues in this case?
Madam Chair.
Oh, we need statement from attorney.
Yes, I will ask
pardon.
the members of the board if, with respect to the matter before it, if there have been any oral or written communications that have been received that are outside the record. In other words, communications that have, to which the other side has not been party. Go down the line to answer that question.
Okay, I will disclose that we have had conversations. We discussed the issues that were in the briefing, both by the taxpayer and the department. We have not done briefing outside, or we've used the information from the briefing, from the files, and I think that's it.
To the best of my knowledge, I've had no communications with the appellant, and my staff, to the best of my knowledge, have not had any communications with the appellant. I am currently awaiting a response from my staff in that regard.
On June 26, 2017, I had a communication with the appellant and and the owner of the company. We discussed the murder of the case. Based on information included in the briefing, they provided documentation titled Project R&D Activities 2003-2006, which are included in the record and is provided today as an exhibit. Since the appellant indicated a desire for FTB settlement, after July 1st, 2017, I notified the Franchise Tax Board about the appellant's desire to discuss settlement options. I did not discuss settlement options with the Franchise Tax Board.
I have not had communication, written or oral, with this taxpayer nor the department since July 1st, when I believe this law took effect, and I believe any conversations that may have taken place prior to July 1st are not applicable under the law.
On Friday, June 23rd, my staff, Natasha Ralston-Radcliffe, Emily Vina, via telephone, and Catherine Asprey via telephone, met with Patrick Fuscoe and Anika Van Hagen, taxpayers representative, to discuss the issues in this case. Taxpayers provided several documents, which I believe were already included in the record. Taxpayer can confirm or correct this. Subsequent to the meeting, Mr. Fuscoe emailed Natasha Ralston-Radcliffe thanking her for the meeting and providing 2 videos. The first discussed Fuscoe Engineering's business. The second was footage regarding the Desert Palm property. Ms. Van Hagen also emailed Natasha Ralston-Radcliffe documents regarding the fixed fee settlement numbers. She copied a representative from the board proceedings, and those documents appear to be part of the record. That is it. I have not met with them.
Then I would ask the taxpayers whether or not there are any communications that they're aware of that they have made to the board members that are inconsistent or in addition to anything that has been disclosed.
Not inconsistent or in addition, but as a clarification. It's on your agenda, by the way. I anticipated this. We met with many of the board members totally and only because our case depends entirely on these projects, and there are 12 of them, and it takes about a half hour to go through each one. There's not time in the hearing. So we wanted to get to each board member and go through that detail. So that was the extent and all that we talked about.
And I would ask the representatives of the board whether or not they're aware of any communications that they have made to the board members that are inconsistent or in addition to with what has been disclosed.
I'm not aware of any other discussions. And I do want to clarify, and maybe I didn't do that in our last hearing, but that we're aware of the discussions, but we're certainly not waiving any objection to it, depending upon what your opinion ends up being.
And then I want to go back and ask. See?
Okay.
Then I would ask both the appellants whether or not you would like an opportunity to respond to any of the communications that have been disclosed.
Not at this time.
Okay, I asked that of the taxpayers, and I'll ask the appellants, I'll ask the same question. Are you asking for an opportunity to respond to or comment on any of the communications that have been disclosed?
No.
Can I ask?
Okay, are we?
I have a question.
Go ahead, Mr.
FTB in
Member.
regards to some how to apply that statement in regards to decisions that are to be made then?
Well, I just wanted to clarify and make sure that we are still looking at the waiver issue, and anything that we did here, I didn't want to suggest that we were waiving anything that we haven't made a decision on.
Thank you.
Okay. Right. We've introduced
Madam
the
Chair,
items.
let me ask a question, just out of, given that appeals prior to 7/1/17, conversations would go through appeals to the Franchise Tax Board in the form of a member inquiry. Would it be appropriate, would your response include such inquiries?
Well, those are generally in writing, aren't they, if there's a board member inquiry?
So they're part,
So I think those are part of the record.
Right. And your response is generally in writing as well?
Our response would be in writing and part of the record.
And typically, the appellant has privy to your response?
If we received a board member inquiry, they would have our response.
And they, in turn, would be able to respond as well? Did any of that take place, appeals, in this case?
There were no board member inquiries regarding this appeal.
All right. Ms. Marks, I would encourage that you add that to the questioning, just to make sure that all bases covered here. All right, thank you.
Okay. To the appellants. Please introduce yourself. It's
Hi.
for the record.
Ms.
you-
Ms.
Yes.
Harkey?
Yeah.
I introduced them.
Oh, that's right. You haven't introduced items yet. We had to disclose. Okay, go ahead,
Thank you.
Mr. Eppolite.
There are three issues before the board members in this appeal. First, whether appellants have presented evidence sufficient to establish that Fuscoe conducted activities that constituted qualified research as defined in Internal Revenue Code Section 41D. Second, whether appellants have established that Fuscoe engaged in qualified research as defined in Internal Revenue Code Section 41D. Have appellants met their burden of proving qualified research expenses for the tax years at issue? And third, whether appellants have substantiated Fuscoe's fixed base percentage as required by Internal Revenue Code Section 41C3A. Thank you.
Thank you. Okay, now, you're on. You have 10 minutes. Please introduce yourself. Or I think you got
20.
extra time, did you not?
We asked for an extra 10
Yes.
minutes. We did.
Okay, so you've got a total of 20 minutes?
Don't worry, we can do it.
Okay, thank you very, very much. 20 minutes to introduce your items or to
yes.
explain your case. Thank you.
Now?
Yes.
Hi, good afternoon. I'm Pat Fuscoe. I'm the CEO and founder of Fuscoe Engineering. You have in front of you an agenda. I gave you an agenda because if you're like me, as you listen to me, you want to know how close you are to the end. So now you can see. And my role, and the reason I am personally here, is not because I'm the founder and CEO of Fuscoe. It's because I am in charge of research and development, and I am the guy who leads the technology we develop in our company. How do you like that? So it's so important in our little company that the CEO runs it. This is Anneke Van Hagen. She's our counsel, just by way of introduction. And I also want to say, with regards to this ex parte discussion, that we did meet with most of you, as I said a moment ago, mainly to just review these projects, which are very detailed and time-consuming. But today, I will repeat everything I said to you in those meetings, just really quick. So stand by for news. I did get something, I learned a lot from you when I met with you personally. I found out what your priorities were, and I think it's relevant. Most of you really care about the environment. Well, guess what? So do we. We are the engineer everybody knows that is eco-adaptive. We trademarked it because it was our brand. We are the guys that know how to engineer things to fit into nature in a harmonious way. So I thought that was relevant because the only way you can do that is through a lot of research. Secondly, we found out that you care about alternative energy. 10% of our top-line revenues is alternative energy, a very emerging industry, very hard to predict. Everything's changing every day. Guess what? Trial and error, experimentation. And lastly, I learned that you all care about water and that there's a need for water conservation in this state thanks to the droughts. Well, guess what? We spend a ton of research on water and figuring out ways to use it twice. I have a graduate degreed scientist full-time on my payroll that does nothing but research water. Okay? So now, I'd like to tell you about our company. There they are. There's 200 professional people, and they own the company. This is an employee-owned company. They are all professionals, and 70% of them have licenses. Most all of them have a degree. Why is that relevant? Because it takes very bright people to invent new solutions and be creative and come up with, go through this scientific process of trial and error, trial and error. You can't do it with robots or with people that just draw. So I think it's relevant. By the way, I'm not bragging, but half the staff are women. Engineering. half are women, 12 ethnic cultures represented. I'm not bragging about it. It's relevant because I found out that you get creativity when you have diversity. If you take a business student, an engineering student, and an artist, and you put them on a team, you're going to get a better outcome than if they're all business students or they're all engineers. So that's what we do by design in our makeup. Now, let me tell you what we do. We make places. We make places where people live. We make where they play, where they work, where they learn, where they go for health care. We make places. And you think, it's cookie cutter, Pat. You guys just do a shopping center and you just can repeat it everywhere, or a house, right? Just copycat it. Wrong. Architects can do that because they can have a greenhouse here and a blue house there. But it's where the site is always unique. If it's in the mountains of Aspen, I've got to deal with rock slides and freezing water pipes and avalanches. If it's on the beach in Santa Monica, I got to worry about tsunamis, I got to worry about saltwater corrosion. Every site is unique. It's unique in our world. And so guess what? We have to attack it with a process. We have to go, what are all the constraints? What are all the opportunities? What are all the regulations? And then we have to compile all that and start experimenting with solutions that will meet all those things. And that's the process that we do every day in our core business, and I think it deserves and earns the R&D credit. Now, there's one more aspect to that. We don't get paid for our failures, which is relevant because you guys, that's part of your deal. If I was just getting paid T&M, time and material, to experiment all day long, I'm not begging for the credit. But we don't. Our clients say, Pat, solve this, and they pay for solution one. If it takes me 7 ways to skin that cat until I get to that solution, that's on me. And so that's why I think we deserve this. So let me also add, and this is really special, in your handout you'll see this little Denny's menu. It's a Denny's menu, I call it. This has got 6 pieces of technology in it that we developed and that we deliver to the public and to our clients. This is important stuff because all of this came out of the thin air. We have 6 full-time people, that's right, 6 full-time people that do nothing but develop technology in our firm. 2 of these 6 things we have U.S. patents pending on. No one in the world can do it except us. It took us 6 years to get it developed and to put it to play, and now it's disruptive in our world. Thank you, Pat. So I think that also adds to the argument that we are really a firm that does a lot of R&D. And I can, if there's other time, I can put you guys on the 3D goggles and you can tour through a house, okay? But let me go to the projects now, if you don't mind. Do you want to do this, Annika? Thank you. So real quick, there's 10 or 12 projects on the list, but I picked 3. All of these projects were done in the year 2005. It was a long time ago, but these are great examples of what I was just telling you, the process of trial and error. On the right, you can barely see from where you're sitting, I'm sorry, but in your handout, you'll see 8.5 by 11s of a project called Mountain Park. I picked this, it's on the list that the staff reviewed, because it was remarkable. I worked on it personally. It was one of the most challenging assignments I ever had. Why? Because it's 3,000 acres that the Irvine Company, the preeminent developer in the world, by the way, wanted to build a community in the mountains in the Cleveland National Forest. And they said, Pat, you're the guy to do this because you guys are eco-adaptive. You're the guys that can figure out how to put a couple thousand people with schools and parks into the mountains and leave the mountain lions alone. And so everybody's happy. Okay, great. Well, it wasn't so easy. So there's like drainage where we have to have flood control for all the new houses, but the water's dirty. And we don't want to mix it with the natural water because then we can't turn it loose in the river, right? So we had to separate the water from the dirty houses, if you will, the driveways and roofs, from the water that falls on the plants, which is clean and nice. So we invented a dual storm drain system, one that has nature's water, one that has people's water, and the county adopted it and approved it, and now that is the standard of practice in the county. My favorite story, though, is the peanut butter and jelly sandwich. We had to build a bridge over the freeway, the 241 tollway that comes into the 91. Oh, great. Caltrans fighting with the city of Anaheim, fighting with the Irvine Company. Who's going to own and be responsible for this bridge? So we kept designing it to like 15 times to get these three agencies to all agree on it, and they're never coming together. So I finally said, tell you what, you guys, we're going to do it like a sandwich. The bottom, the brace of the bridge will be Caltrans, and all they have to worry about is that it stays up. Number two, on top of that is a road, plain Jane, regular old road like you drove on to get here today. The city has roads all over. We're going to give that to the city, and that's all they have to worry about is the road. It's the bologna in the sandwich. And then on top of the road are the cute little street lights, the plants and the signs and all that stuff, and that belongs to the Irvine Company, and they all high-fived each other, and that was the end of it. So thank you, Pat, for coming up with an invention like that. Okay, next to it, this is Annika's favorite story, and some of you will remember about the frogs. Okay, this is the San Mateo Creek. It's in the Camp Pendleton. I got a call from the U.S. Marines. Pat, come down here. We know you're the eco-adaptive guy. What's the problem? We got 18-year-olds driving Sherman tanks through the marshes, and they're squashing the arroyo toads. Well, arroyo toads are endangered species, and they're big, like dinner plates, these giant frogs. I go, oh, well, let's put a fence. Let's just put a fence up, and that'll be the end of it. Well, all the biologists said, no, you can't do that, because then the bobcats, the raccoons, the coyotes, they can't get through. You ruin the whole ecosystem. Oh, okay. So then we got to work. What is it about arroyo toads? I had to read and study everything there is to know about arroyo toads in order to engineer a solution. What's that? And is anybody paying me to do that? No. I'm researching the snot out of a frog, okay? So, but guess what? Anybody wants to know, I'll tell you all about them. But what I learned is they don't hop. They can't hop. They crawl on the ground. So I made a fence 6 inches high. It's amazing. It looks like a Barbie doll fence. And it worked. The frogs can't get through. The bobcats step right over it. It's a miracle. Okay, great. Thanks, Pat. And by the way, that is now approved arroyo toad fence for the world to copycat. All right, the last project, do you want to switch for me, is the Great Park right here in Irvine. I lived in this room for 10 years with the city of Irvine doing this park. Why is it relevant? Because it's another great example of my life. We get the El Toro Marine Corps Air Station is a project to turn it into a park. Well, the Marines just contaminated the living hell out of it. It wasn't malicious. They just dumped jet fuel on the ground for 5 decades. So guess what, Pat? Figure out how to put lakes and buildings full of kids and all kinds of stuff in there. Just figure it out. Okay, great. So I had to study like how groundwater behaves so that I could put a lake in there, and when the water percolates from the lake, it doesn't grab the pollutants and contaminate our drinking water. So I had to, I mean, we must have done 100 models of this groundwater aquifer until we found a way to do it. So I could go on and on, but there's not time. The Great Park also had a wildlife corridor, which is the first time ever in the history, I think anywhere, except in Switzerland, where we're going to connect the Cleveland National Forest to the Laguna Canyon coast. Now, this is 2005, folks. This is right in the middle of this period of time that we're asking you for indulgence on our credit. We designed a wildlife corridor that got every agency's approval. Fish and Wildlife, California Fish and Game, everybody, EPA, everybody did it. And no one's ever designed a wildlife corridor. I had to do it. It was amazing. I could go on it. I'm very proud of it, actually. But there's fundamentally 3 habitats in there. There's aquatic for the fish and the frogs. There's riparian that's up on the banks. The emergent, they call it. That's where all the little critters live that eat the fish and frogs. And then, believe it or not, there's the bugs. We got to have the bugs, Pat. We got to take care of the bugs up on the high meadows in the woodland. I said, well, what do I have to do? They said you have to grade the ground and make little tiny habitats for the bugs, little piles of wood and rocks and stuff. And so we're designing this. Are you kidding me? And we're making plans that show exactly how to do it everywhere. And people are going to build it. So that's just my quick run-through on 3 projects. They're all in your book. I know you don't want to read it, so I'm just surfing through it. But please read it if you're interested, especially the frog. If you want to read a cute story, read the part about the arroyo frog. So I'm concluding now, so I'm on time. We meet your 4-part test, okay? We meet this. I'll take anybody on that wants to argue whether we do these things. We also meet your AE qualifiers, right, which is the stipulations of what an architect or engineer should be doing to qualify for this. And our results have public benefit, which is one of your criteria. In other words, if I was solving all these funny little things about frogs and bridges, and it just went to bed somewhere in a hole, it's no good to the public, but these are. There's a board over there, Annika, if you would. There's two more, Green Streets in My Brand. This is a book that has 12 features of what we call green streets. This is how to build a street that breathes, people. This is how to build a street that's conducive to nature. Where did I get this? How did I come up with this? I spent 2 years researching and coming up with stuff, took it to the city of Irvine, and they adopted it. Here it is. This is their policy now. If you build a street in Irvine, you're supposed to follow these guidelines. So it goes into the public domain and makes a difference in people's worlds. So, one more thing, our brand. Next board, please. It's underneath there. Thank you, Vanna White. Okay. Every company has a brand if they're any good. Coca-Cola, Nike. Well, we do too. This is our brand. If you call any one of my clients and say, what is Fuscoe Engineering's brand? They're going to say, oh, those guys have that crazy full circle thinking brand. There it is. There's our little logo on it. Look, what's the top bar say, everyone? Research. It means get smart on the site. Know everything there is to know about the regulations, the client, the goals of the project, the constraints, the weather, everything. Know it all. Then design. What does it say there? It says ask the question, what if? What if we don't do Laguna Canyon Channel as a concrete trapezoidal channel that's ugly and horrible to nature? What if instead we leave it as a natural creek and we put gabions in there and build riffles and rocks to slow the water down, have it function just like the concrete channel, but instead it's full of life? That's what that's about. It's about asking, what if we do it this way? What if we do it that way? What if we do it another way? And in comparing and picking. And that's what we do every day. Then we build the things, and trust me, we're not done. Because when we go out there, remember all the sites are different? Remember that? They're all unique. And sure enough, we get out there, and, oh, we thought that bridge was going to fit, and it doesn't. Now what? Quick like a bunny. Solve it. So we do that during construction. And finally, this is like nobody does this, but you go back after it's done and see how it works. I got a quick story. It's really cute. Costco is one of our biggest clients. We've done all the Costcos south of San Luis Obispo, 300 of them. The very first one I did 28 years ago, I was so proud of myself. I put a little half-inch curb in front of the front door so the water wouldn't, when it rains, go in the door. And I got out there for the day it opened. All the people are there, have hot dogs and Cokes, and they had their stuff. And I saw this little gal push one of those giant trolleys, and she hit that curb, and all the mayonnaise and Wesson oil fell off her trolley. And I thought to myself, no more curbs. Because I paid attention to it after it was built to see how it actually worked. And I learned never to do that again. And if you go to a Costco today and you go to walk in the front door, look, and you'll see it's a panel curb. It's flatter than a pancake, so those wheels roll right up. So that's just an example of what the last thing is on our brand. Thank you very much for your time and for listening to me. This is Annika Van Hagen. She's our counsel. She has a couple minutes to tag on for legal purposes.
I'd just like to offer a couple items here. One, in reference to items 1 and 2, evidence of qualified research, and that the taxpayer actually engaged in qualified research. I'd like to offer that it's our position that between the thousands of pages of substantiation that we've provided, in addition to Mr. Fuscoe's testimony, that we have not only shown that Fuscoe has engaged in qualified research, but we've also substantiated it. I should also note that the conversation that you just heard, or the information that you were just given by Mr. Fuscoe, was never given to the FTB on exam. These types of, sort of back and forth where he could actually offer information on perhaps what some of these plans are indicating, the plans being some of the substantiation that we've provided for each of these projects. That never took place, so I guess I'm offering that to opine, I guess, on the fact that it's possible that exam didn't really understand what they were looking at when they were given, pages and pages of.
They're looking at a frog fence. You think they could figure that out?
Right, of CAD data and just, different versions of plans which would illustrate basically different iterations of design. It's possible that exam did not necessarily understand what they were looking at because, again, this type of conversation didn't take place. Today, hopefully you have a couple additional exhibits in reference to a couple items which go to the qualification of the research. Exhibit 2 is in reference to the funding analysis. 2 and 3 are both pertain to the funding analysis. Exhibit 2 is in reference to the financial risk portion of funding. And essentially, it's just sort of a distillation of the sort of current and most prevalent controlling case law, which is Geosyntec. And this is being offered in conjunction with, it doesn't have a number, but it was the exhibit that I think it said fixed fee settlement numbers on there. This is being offered in conjunction with that to support that proposal. And it basically highlights why fixed fees, or how the court sort of determined that fixed fee contracts can qualify for the credit. In brief summary, they basically indicate, the court indicated that fixed fee contracts confer maximum risk on the contractor, because when you're performing a service or even constructing a widget for a fixed fee, in the process of providing that service or constructing the widget, to the extent that you bump into issues or errors or have to go back to the drawing board, that comes out of your pocket. That is not accounted for in terms of the overall contract price. So you have to eat those costs of basically reperformance until you actually conform with the contract specifications. So in an overall picture or a global picture in terms of the contract, that makes the contractor at risk for the overall profit and or loss of that contract. That's what the court said. So the court the court held that fixed fee contracts are inherently risky. The court then said there are terms in the contracts that add risk, in addition to the fee structure, that add risk. Terms that allow for Fuscoe's clients to accept the work or reject the work, or make payment that specifically state that payment will be conditional upon acceptance of the work, or that they can withhold payment if they are not, if they disapprove of any portion of the work. That's an additional risk. And then 2 others which the court indicated were minor risks in terms of contract clauses, were a warranty clause and a default clause. And the warranty obviously just would warrant his services for, that they would be free from defects for a period of time.
Pull your mic a little closer to your mouth.
And a dispute mechanism, a dispute mechanism would allow his client to, would dictate sort of how disputes in terms of how unaccepted or accepted services would be handled, I guess, going forward. So those 2 are minor ones. I'd like to offer that one of the exhibits I handed you today, which also does not have a number on it, but it's a contract from the Irvine Company. And this is actually the Sakioka contract, which is one of the contracts that the FTB sampled on exam. And there's 2 portions to it. This is probably, the first one is just a 4-pager, which outlines the different phases and the actual fees associated with each phase. The larger portion of the contract is actually basically the master service agreement, which contains all the, applicable terms and conditions. And for your reference, I've highlighted with the little green stickies The terms in this contract that are applicable, those same terms that Geosyntec referenced. So the first on page 4 would be that the Irvine Company can refuse to approve any portion of Fuscoe's payment and has the right to withhold payment to the extent that the portion of that payment application is disproved. There's a dispute mechanism in there too, and then the last green sticky is for the rights portion. But I'm offering this to just show that these fixed fee contracts line up with the current case structure, basically, in terms of what courts would consider allowable or not in contracts on an R&D case.
Time's expired.
Okay, thank you very much. To the department, please introduce yourself to the record. And
Madam Chair, if I may, the appellant has indicated that this is somewhat new information, and some of it is new to me based on my review of the record, and helpful, by the way. Has the department heard and seen all of this?
So we received it this morning, and I've looked it over this morning, and so I think we can address it.
And you're good with proceeding?
Yes.
all right.
Good afternoon, Madam Chair, members of the board. I'm Jason Riley, and this is Jacqueline Zumeta and Craig Scott, and we represent Franchise Tax Board in this matter. A taxpayer must establish several elements to qualify for the California Research Credit. They must engage in qualified research activity, and they must avoid excluded activities that disqualify their credit claim. Appellant Fuscoe Engineering provides civil engineering services to their clients, such as land surveying, planning subdivisions, and submitting for state and local agency permits. For those services, appellants claimed California Research Credit, but this claim fails for any of the following 5 reasons. 1, it's disqualified as funded research. 2, it's disqualified as an adaptation. 3, appellants failed to identify their business components. 4, they failed to engage in a process of experimentation. And 5, there's no nexus between their activities and the expenses. So let's examine reason 1. Even where qualified research activity occurred, a taxpayer is not allowed research credit where the activity is funded by the client, because that would be a double payment. This funded research exception is the threshold issue before your board today. If the activity is funded, it's disqualified, and the inquiry ends. There's no credit. And under this exception, it makes no difference whether appellants establish that qualified research activity occurred, because someone else paid for it. The research credit statute was designed to encourage investment in prospective research projects by reducing the cost of the project through a tax credit, essentially to change a taxpayer's decision from no, research is too expensive, to yes, the research credit helps defray research costs. So with respect to funded research, it would clearly violate Congress's intent when it enacted the law if a taxpayer could seek research credit for activity someone else already paid for. When examining a contract for funded research, the law and the line of cases from Fairchild to Lockheed Martin, Geosyntec, and Dynetics dictate that the inquiry turns on who bears the research costs upon failure, not whether the researcher is likely to succeed. Where there is no economic risk, the activity is funded. The contract determines who is entitled to the tax credit, and the line of cases following Fairchild have developed certain hallmarks of risk that must be present in a contract to avoid the funded research exception. On balance, where these hallmarks of risk are not present, the research is deemed to be funded and the research credit is not available. Often a, quote, fixed price contract places economic risk on a taxpayer. It's one thing to call a contract a fixed price contract, but the courts examine how the contract provisions actually operate by specifically looking for these hallmarks of risk. Here, respondent and appellants entered into random sampling agreements to examine 9 of appellants' contracts and to apply the results to appellants' entire claim. First, let's look at a contract that the tax court in Geosyntec held was not excluded as funded research, the rare earths contract, which is included on exhibit, hearing exhibit H2, and it's highlighted in green. This contract required both repayment on termination and required that taxpayer to pay a portion of the contract price, 10%, as a liquidated damages penalty. The client in the rare earths contract had the right to withhold payment until a milestone was achieved. There's also a specific warranty requiring the client to accept a satisfactory research performance prior to payment, and the taxpayer was required to repair or replace any defects. And the rare earths contract contemplated research. These are clear and material differences from the contracts at issue in this appeal. Differences which has placed the economic risk on the taxpayers in Geosyntec. So let's dissect appellant's Pad E contract, which is highlighted in red on Exhibit H2. Because the hallmarks of risk are completely absent, you'll notice on Exhibit H2 that each element is the opposite of the rare earths contract. For example, what happens on termination in the Pad E contract? Well, the taxpayer was paid for all services, all reimbursable expenses, and all termination expenses. So there is no risk on appellants if they get paid for any services they provide. In addition, the fee for any remaining services will be, quote, equitably adjusted. Plus, appellants would receive 25% profit on termination. There's no liquidated damages penalty. There is no warranty clause or client right to withhold payment. There is no repayment on termination clause. And the listed services are not qualified research. With respect to payment, the contract indicates, quote, fees and hourly estimates. Yet the clients may allow estimated budget costs to be exceeded. So in this contract, the ceiling price is not immovable. That is, additional compensation was available for additional work. According to the contract, appellants would be paid for any services they provided that were not covered by the contract price. So whatever work appellants did, the client would pay them. This contract did not function like a fixed price contract. Appellants were paid for all work completed. Allowing a tax credit without economic risk would pay them twice. In sum, each of appellants' 9 contracts falls squarely within the funded research exception. The hallmarks of risk are not present. Appellants were paid for their work, they didn't use their own money, and allowing the credit here amounts to a double payment. Where activities are funded research, the inquiry ends. Appellants do not qualify for the California Research Credit. Reason 2. Appellant services are procedures and methods that someone else created and approved. So appellants fail to qualify for the credit under another exception, adaptation of an existing business component. For example, appellants in their Sakioka contract did not develop the research protocols for completing a hydrology analysis. Appellants have simply used the methods as created and directed by local and state agencies. They adapted engineering formulas such as those approved and required by the Orange County Hydrology Manual for an individual client's projects. By law, this kind of activity is specifically excluded from the research credit. So even if your board were to find some activity was not excluded under either the funded research or adaptation exceptions, appellants must then meet the other requirements of the research credit statute, and they have not. To date, appellants have failed to prove that they engaged in actual qualified research activity, so they've failed to prove entitled to the credit. Which brings us to reason 3. Appellants are required by law to isolate and identify their discrete business components. That is, the product, process, or technique for which they claim the credit. Appellants identified projects, yet they failed to identify the particular elements within each project that might then qualify for the credit. Appellants have avoided this identifying discrete business components by citing to Trinity versus United States. In this, appellants are misguided, and Trinity is easily distinguishable from the present appeal. You see, the Trinity court only allowed that taxpayer to avoid the legal requirements because their records had been destroyed by Hurricane Katrina. Here, there was no act of God that destroyed appellants' records. Where a taxpayer fails to meet one part of the qualified activity statute, the taxpayer is not entitled to the credit. Failure to identify discrete business components is fatal to appellant's claim. Reason 4. The problem throughout this audit and the appeal is that appellants assume what they seek to prove, in particular, that their services involved qualified research. But what did appellants actually do? Let's look at appellant's Seabrook contract and what they claimed to be qualified research. That their services involved, quote, provide coordination between the owner, local agency, client's legal counsel, and the title company during the process of the condominium plans. Objectively, this coordination of agency approval in no way involves a scientific process of experimentation, and so it's not qualified research, and neither is surveying and marking out the location where a structure will be built on a client's property. Appellant services employed techniques developed and required by state and municipal agencies. There's no uncertainty, and such activity is not qualified research. Failure to engage in a process of experimentation is fatal to appellant's claim of California research credit. Again, should your board agree on this point, the inquiry ends. Appellants are not entitled to the claimed California research credit. And reason 5, yet even if your board finds that some qualified research occurred and was not excluded, by law, appellants must prove a connection between the qualified research and the qualified wages. While appellants' employees spent time working on various projects, appellants have yet to demonstrate that any of those projects involved qualified research activities. Thus, there was no connection, there's no nexus between the claimed wages and any qualified research as required by law. In conclusion, appellant's claim of California research credit fails for 5 reasons. The hallmarks of risk are not present in appellant's contracts, so appellants do not escape the disqualification under the funded research exception. And their services fail the adaptation exception. Appellants neither identified their business components nor proved that navigating local agency requirements involved a process of experimentation. And they've shown no nexus between the claimed wages and any qualified research. But first and foremost, this appeal boils down to funded research. If it's funded, it fails, and your board's inquiry ends. Respondent's determination was correct, and appellants are not entitled to their claim of California research credit. Respondent will address any of the other contracts from the random sampling agreements at issue in this appeal, should your board have any additional questions. But I would like to address a couple of things that the taxpayer brought up during their presentation. Several of there are 3 projects that are listed in appellants in their exhibits today that were not part of the sampling agreement. It's the sampling agreements that they signed with the Franchise Tax Board. Our universe in this case is these 9 contracts. The taxpayer and respondent Franchise Tax Board agreed that in order to keep the audit to a reasonable size, that we would only look at these 9 projects. This was for their benefit, so they only had to provide a certain amount of documentation. And it was for respondents' benefit, so that we only had a limited scope of, to keep the examination reasonable. So projects like the Great Park that you saw some exhibits on today, those are not relevant to this case today.
You can't.
With respect to the Arroyo toads. The Arroyo toads were, if anything, they were a subset of a project that appellants at audit identified only as the Sakioka contract. Is it the Sakioka?
No.
However, the Arroyo toads, this was an activity that was done in conjunction with some biologists, and if so, these biologists, this would have been what we call contract research, which is where you don't do the research yourself, but someone else does it for you, and you get to claim 65% of what those people went and researched. Now, the interesting thing here in this case is that the taxpayers did not claim any contract research. So they didn't claim anything with respect to the Arroyo toads or they haven't even proved that activity involved a process of experimentation. We don't know what subset of this discrete business component this would involve, or indeed if this was anything more than the biologist compiling known research about a about these toads and their behavior, compiling compiling sources of research into a single document. That may be library research, but that is not qualified research. And there is
So
a
you're saying I'm a
difference in
liar.
this instance. And again, the Green Streets project, while impressive, again, that is beyond the scope of our 9 project universe that's at issue in this appeal, and that respondent and the taxpayers agreed to apply to the whole population of their projects. And so again, if your board has any questions, I'm happy to address them. Thank you.
Thank you. Okay, back to the respondent, or back to the appellant. You have a rebuttal time.
Yeah.
I'm just going to surf over those real fast, and I'll let Annika do the legal mumbo jumbo.
Okay, be sure you guys speak into the
Yes,
mics.
I'm just going to surf real fast over your council's comments. The pivot, he's saying, is we get paid, and therefore you can't give us the credit. I understand. That makes sense. I'm telling you, we don't always get paid. Okay, in fact, and I could substantiate this if I have nothing to do, and I can go do this for like a trial with tons of data, but about 80% of our contracts are fixed fee. 80%. We do $35 million a year. We do about 200 projects a year, so figure 200 contracts, 80% of them are fixed fee. That means we're guaranteeing the maximum cost. Our clients are quite good at what they do, so we take that chance. But we don't, like I said, we don't get paid for the 17 iterations that we do to get to the final solution. Now, if we lost money every time, we wouldn't be in business, I wouldn't be here. So the fact is, we do make money on some, we lose money on others, and we come out slightly ahead, and hence I'm still here. And I heard about this contract that's very flexible and covers every possible thing that goes wrong, and I get paid for it. Great, show me that one, because I don't know where that is. All my contracts are generally, somebody could find some oddball one, but they're generally what I just said. They're, Pat, you're going to do all the engineering on this project for $500,000, and that's it. And that's just how I do it. And then everything I have to research, experiment, or trial and error is on me. Whether you believe me or not, that's there. I don't know about this completely absent risk thing. I disagree. I'm sorry. I always have risk. I take risk every day. I have a huge insurance policy because of it. If the building's in the wrong place, guess who they go after? So I don't know about that either. So I disagree with the fact that I get paid and this is a funded thing and therefore I'm DQ'd. Number 2, on adaptation, yeah, you're right. It's an adaptation. What isn't? Okay, I went out and bought a drone 6 years ago before anybody had them. What did I do? I adapted the drone by putting a laser on it so that it could survey the ground, and suddenly I had a 3D model. Well, that's an adaptation, Pat. We're not paying you for that. That took me a year to figure out how to do on my own nickel. Okay, so sure. If you want to say that an adaptation DQs me for this, then okay, because pretty much everything is an adaptation, even software. I have 2 code writers, and all they do is take existing software and change it and make it different and better. So I understand, but I don't see that as a real argument. Number 3, the business aspect, something about the fact that I have to isolate and document all of this trial and error experimentation stuff that I don't get paid for. I just don't do that as a matter of course, so that's why I'm here in person, to just testify on a stack of Bibles that it's what we do, believe me or not. But the business process of me designing a storm drain that everybody says, oh, that's just a plain Jane County standard thing. Well, if I had to do it 6 different ways to get it to fit and work right, I don't keep the 5 failures. I don't put those in a box and write on top of it $26,000 of experimentation and put it in the drawer and have it for you. It's gone, it's useless. So we just turn our back on it and move on. So I'm sorry. If you believe that, fine. But I can isolate our R&D process on any project. If you tell me in advance, I can box it in and keep it. But we don't, as a matter of course, because it's useless. Number 4, the experimentation test. I agree, the Seabrook project's a poor example. It turns out that the sampling, the grab bag that the staff picked out of our basket was just a bunch of children of a lesser god, is all there is to it. I'm sorry. There was just a bunch of sort of plain Jane stuff in there. It was just a miracle. I'm telling you, the projects that I showed you today were the biggest projects in our firm that I had 30 or 40 people working on in the same time period. So I'm just trying to say, sure, you can go pick around and find some little gas station I did that had nothing special about it, and I did very little experimentation. Yes, you're going to find, there's 200 contracts. I'll bet you can find 20 of them that are like that. But I'm just showing you today the big ones, the $1 million contracts that really are what make us go. So it's just a bad example that he shared with you, and I understand. That's what it is. It's just the runt of the litter that he picked. Okay, so lastly, this thing about a nexus of cost. So if you're saying, most of my costs are wages. All those people you saw, they're all highly paid, by the way, six-figure kind of people. It's like 80% of our costs. It all goes out the door every night. So yes, I pay them to do this work. And like I said, when they're just researching for me, like the woman I hired that's a scientist that does nothing but research water, so I can go get her W-2 and hand it to you and say, here, and see how much time she billed during the year. Maybe she billed 10 or 20% of her time. If that's what you need to make a decision, then we'll go to work getting you all that. I'm just here today to tell you that's what it is if you want a shortcut. So I disagree. I think there is a nexus of cost. It's wages. That's the biggest cost I have. I pay these people well, and some of them, that's all they do. I have 2 people full-time that do nothing but R&D. They don't bill anything. So there you go. That's my quick surf. Go ahead, Annika.
Time's expired.
Let's allow her at least 2 more minutes to...
Thank you.
I think we could have allowed really 10 minutes on the rebuttal since we had 20, but let's just a few more minutes.
Just a couple items here. There was a couple issues that council referred to on the rare earth contract for Geosyntec that actually never made it into the court's opinion. So those terms, and I'm not recalling exactly what they are, but those terms that he referenced that were other than the terms that I referenced, which were acceptance, warranty, and default, anything extraneous from that never made it into the court's opinion. So I therefore conclude that that was not necessarily part of the court's thinking in terms of coming up with the determination as to why those fixed fees contracts were qualified. Secondly, the PADI contract that he referred to is one of those contracts that we actually conceded in the settlement numbers, the fixed fee settlements. So we agree that since the time that that these credits were originally filed for, case law has changed. And so those fixed fee numbers, that 47.4% is 47.4% of the entire population of contracts that were claimed in this 3 to 6 period, 2003 to 2006 period, that represent fixed fee contracts. We now concur that time and materials type contracts and cost plus or cost plus to a max, anything like that is no longer qualified. That's why we offered that settlement. I mean, we obviously can't argue against something that simply we have no argument for. A council offered sort of a summary opinion of what Mr. Fuscoe does in terms of qualifying activity and whether or not there was scientists engaged on a project and who performed what.
You should work with scientists if you want a real thrill.
But, I'd offer that, obviously, Mr. Fuscoe's testimony here today is that he actually performed a lot of this R&D himself, and or other people in-house performed it on behalf of Fuscoe Engineering, people that were not subcontracted out. Mr. Fuscoe, I think, again, his testimony goes to support his process of experimentation. None of these projects, although he conceded that there's adaptation, but I'd like to offer that he's not an attorney and he's not speaking to adaptation as defined by this law. And so he can't take a design from one site, spin it around, and apply it to the next site, and that spin is the adaptation, and therefore, obviously, that wouldn't qualify. I get that, but that's not what happens. What happens is he has an idea of what a drain should be, and he approaches a new site given all the project constraints and has to make something work given all the competing constraints, regulations, everything like that. He can speak more to that than I can, obviously, but there's no adaptation here. Additionally, to the extent that there's a process of experimentation, how can there be an adaptation? To the extent that the solution is not immediately known from the outset, and there involves sort of an iterative process of design, how can that be an adaptation if there has to be a trial and error process to arrive at a workable solution? The nexus issue, actually, we did identify business components, by the way. And the business components are the subtasks and phases of these projects. They are identified in the project records. This is all part of the record, but this is, again, if you want to pull up Exhibit 4, it'll give you an idea. But this runs through, this is basically Exhibit 4 is a timekeeping record on a project. And this runs through, this is only timekeeping records from phases that were captured as part of this R&D. So, and only for people that worked in a trial and error process on this project. So this is only reflective of a portion of the project that was captured. This is not the entire timekeeping record. But what this does is it identifies in the phase name the business component that an employee, project manager Donald Butler, is working on. And it logs his time by day on this project per hour. And it shows you that there's a direct correlation between the activity, i.e. rough grading plan, and the qualifying expense, which is determined from these hours when we apply sort of a multiple of their salary. The missing link between, I think what he's referring to, the missing link in terms of how, this may or may not substantiate nexus between the qualifying activity and the expense, is the testimony from Mr. Fuscoe.
That's just all I got.
Because in coming up with these numbers and the allocations for the time spent, qualifying time spent on here, it's people like Mr. Fuscoe that were interviewed and all of his project managers that said, okay, Donald Butler, what did you do on rough grade plan? What does that involve? Okay, if you're trying to create a solution, or was there a trial and error process? And so there's this give and take conversation where.
Okay, I'm going to ask you to,
I'm just going to
ask you to
put a
wrap
cap
it up
on it.
so that we can.
Jason's
ask
comment about the storm drain being a plain Jane cookie cutter thing. Let me just pick on that for a minute. Maybe
Okay,
even
you,
my mom.
you will. I'm sorry, Mr.
All right.
Fuscoe. You will both get a chance because I'm sure the board is going to have plenty of questions for you. Thank you. Yes.
Ms. Harkey, if I may interrupt just for a second to ask a question. Appellant just mentioned just now about a concession. Back on July 6th, appellant made a submission regarding a concession they were making about revising their refund claim. And I was wondering if it was possible now to inquire of appellant, back on July 6th, regarding the fixed cost or fixed price, the funded contract question, this issue. Appellant made a submission back on July 6th, revising the refund claim, adjusting it. The original refund claim was for $765,364, and at that time stated that they were revising their refund claim to 47.4% of the original amount, to revise refund claim of $362,809, and just wanted to see if we could get some clarification today that it was appellant's position today that that was their official revised refund claim. Because, and what was so important about that is the original refund claim, that this is a Section 40 appeal before the board, and that, you know, that has significance for this board, Section 40 appeals, and that before this goes to a vote.
So what you're saying is if the appellant is actually revising their claim, which is what we have here and what was in the file, if they're revising their claim to the, let me see, assuming that there was a change in the law and that the claim was revised downward from the
65,000
downward to 362,809, that it would no longer be a Section 40?
That's correct. And so it'd be nice if we knew that now before the board voted.
Can we get some clarification from the appellant, Mr. Fuscoe, or his client? Are you revising your appeal down from the 765,364 to the 362,809?
Yes, that is correct. What is Section 40?
Section 40 just means it needs an opinion and actually an analysis done as to what the issues were, and it gets published.
Gotcha.
Okay, so it makes it...
Right, it's a requirement upon the board at the end of the appeal that the board is obligated to publish an opinion on its website.
So if it's no longer a Section 40, which means it's under $500,000,
right.
Is that correct?
If the amount in controversy of $500,000 or more, the board is obligated.
Then it's not anything that has to be published.
Right, got it, okay.
Okay, so that's what you're doing. The 362,809 is the amount of the appeal.
Right.
The 47% of the refund. Okay.
Thank you.
I have one question related to the concession.
Pardon?
I have one question related to the concession.
Sure.
Just real quick. Just comparing the two schedules to the appellant, are you saying that the Pad E building Anaheim is or is not funded research? On your exhibit, it says unfunded, but I believe in your presentation.
You know what, I misspoke before. I'm looking at my, it was not one of the ones that we removed by virtue of being time and materials.
Okay.
So it is unfunded.
It
in
is
our
unfunded.
position. Correct.
Okay. I think we're on now to the members.
We're asking for half, right?
I have put a lot of work into this only because I found the case extremely interesting, and it was very confusing to get my hands around. If somebody else wants to go first, I'm more than happy to allow that. Otherwise, I'll hand out stuff from the file that was easy for me to kind of grasp what I was doing and what I was looking at with the help of my staff. And we did not get anything new. We did not talk to anyone after the drop dead date of July 1st. This is all from the file. There were roughly 15,000 pages of documents, and the problem was not a lack of documentation. The problem was coordinating it so that it was digestible. And we tried to do that because we couldn't have any conversations, so we actually went through the 15,000 documents to see what would work in my ducky bunny presentation, because that's how I have to have this. I have to have it really clean as to what we're looking at. So I've got one for the department too. You can see these are all items that you have, that we got off your file, and I'll just...
Madam Chair, while you're doing that, just for a point of clarification, the respondent indicated that some of the examples provided today was not part of your original scope.
That's true.
But you went further to suggest that because it wasn't part of your original scope, it's not relevant to this case?
Correct.
You mean to say that?
I did mean to say that. We have signed sampling agreements with the taxpayers. This is a method that the Internal Revenue Service, the Franchise Tax Board, uses in order to keep an audit to a reasonable size
Further point of clarification to appeals, I don't know that
Yeah,
this
I do,
body is
and I have
limited
extra.
to that.
That's correct.
What I'm
The
gonna
sampling
talk
agreement was
about.
between the parties, but that does not limit the board.
Okay.
If
So
I
it
may-
is, it is, yes, go ahead.
If I may, the problem with that is that the only items for which there is evidence in the record are these 9 contracts.
Well,
There
that
are
was-
1,200 other alleged contracts for which there is no evidence in the record that Franchise Tax Board did not have access to at audit, that we did not have access to at appeal, and so it is a bunch of, it is unexamined
No, I
evidence.
I appreciate the concern, which was the reason that the question was asked. Given this new information, is the respondent okay? They reviewed it, and are they okay with it? And they're prepared to move forward because evidence presented at this time, this body can take it under consideration how the department deals with the conclusion, if there is a conclusion that says the evidence has merit. It's kind of up to you, but
Well,
I don't believe it's true that we,
Mr. Horton,
it's
could
not
I-
true that we can't take it under consideration. Yes?
we are limited in this audit by the 9 projects, I believe it was, that were chosen.
Well, we're not limited.
We're not limited to testimony, but these are the projects we're going to be reviewing, and these are the projects that,
That's not true either.
Mr. Horton, can I just kind of mention something that the tax court looked at this issue in Union Carbide, and in Union Carbide, the taxpayer attempted to remove, I'm sorry, let me back up. They had entered into an agreement with the Internal Revenue Service to sample 5 of their contracts, and the results of those 5 contracts were going to be applied across the entire population. And they attempted then to amend their petition to remove one of those contracts and to remove all the qualifying research expenses because they no longer wanted to claim the research expenses for that contract. And the tax court denied them that opportunity because they said that it was inherently unfair to allow the taxpayer to unilaterally change the agreement that they had with the IRS. So that's just sort of what we've been operating under is that guidance from the tax court.
And if I may add, the letter of July 5th essentially requests a do-over. It asks to go to square one, pretend none of the audit happened, none of anything happened, and redo the entire audit based on the entire population. And and also without Franchise Tax Board having access to those 1,200 contracts. So just toss out the random sampling agreements that the taxpayer and Franchise Tax Board agreed to be bound by in the audit.
Well, I somewhat recall Union Carbide in that the courts actually kind of said that they will take it under consideration. But let me go to appeals. You respond to that? You originally said that this additional, which I think is important because it's been entered as evidence, these additional transactions, and can this body take those additional transactions under consideration in their deliberation?
Regional transactions referring to,
The ones that they presented today?
The projects that were not part of the
Projects
original.
that are not
sample.
part of the original
was
agreement
Well-
and scope of the audit.
because that's part of the appeal years, so,
Yeah.
because the claims for refunds are that's part of the appeal years, so that's
And-
the entirety, that's part of the entirety of the appeal years, so yes.
In your thoughts in respond to the respondent's Union Carbide argument?
Well, that's how the parties performed the audit, but, so that they could do an audit, but the board's not bound by that in adjudicating the appeal.
In Union Carbide, the court actually denied them permission to amend their claim.
Was that taken up under appeal?
I'm sorry.
Was the Union Carbide case you're referencing taken up under appeal?
That issue was not taken up under appeal.
I'm sorry, can you hear?
No, that issue was not taken up under appeal. It was decided in a motion for summary judgment.
Motion for summary judgment?
Well, and the board wasn't a party to the audit between the parties, so the board's not bound by the audit.
All right, thank you.
I'll kind of follow up on that. So if I understand, so we're not bound by the settlement, the sampling agreement that the
Right.
franchise tax board and the appellant did.
Correct.
So in our deliberations, we can consider the 3 projects that they described and whether or not that satisfied the requirement for qualified research. I understand the concessions that the appellant made with respect to what they say is fixed or unfunded contracts, but in the record today, we do not have the benefit of reviewing those contracts. We just have your verbal statements, correct?
That is correct.
That's-
However,
that's-
we
You
can't
have-
provide those contracts.
Well, Annika, but they have this. This is a better cross-sampling of that period of time in our firm, and I distilled it for you so you didn't have to read through all the gobbledygook.
What is this?
This is a sort of a reference to process of experimentation and technical uncertainty. It doesn't have contracts in it or contract
No,
terms.
I'm sorry, it doesn't. I'm just talking about whether it's a qualifying
Right.
assignment.
I'm focusing more on whether or not it's funded, so we don't have the benefit of all those contracts in the record to review them.
No, I can, if it's helpful, offer how we came up with that sort of, the settlement percentage of 47.4, which is in Fuscoe's timekeeping records, people record their time to each project, and part of those timekeeping records have a billing fee associated with each contract that an employee is billing time to. And so for that time period, those project accounting records were culled through, and we only pulled out those contracts that had a percentage of completion billing associated with it, which is a fixed fee because you're billing according to a percent of completion of the project. So that 47.4% was derived from direct, I mean, I can show, what I'm saying is I have documentation to show you that 47 point, what each of those projects are that make up that 47.4%.
Okay.
So the
Right. She
the
had-
appellant's not amending their claim, they're just providing additional evidence, but just in the interest of
They are
caution.
amending their claim down to the 362 because
I
the
mean,
law
relative-
had changed.
Relative to the cases, that was just, but to our counsel, we've got appeals saying we can take this under consideration. You've got the respondent saying you can't take these under consideration. What say you?
Ms.
I'm
Dowers,
sorry, I couldn't quite hear the question. Is it, is this about the particular process that you follow?
No, the appellant has provided additional evidence to support their position. They entered into agreement with the respondent, an audit agreement, which the respondent believes should be honored at this point, and the additional cases should not be taken under consideration. Appeals has indicated that board is not party to that agreement between the parties and are not required to take that under consideration. I'm just looking from a little bit of direction here. So, I mean, I can say what I believe, and I can say what I believe about you and Carbine, and I'm very much familiar with the case, but just for the record, I'd like somebody to say.
Mr. Horton,
and
if we may.
I'm addressing your question.
Mr. Appleton.
That you weren't, the board wasn't a party to that
I heard that.
agreement,
I understand that.
so you're not bound by it.
I understand what you're saying. You're repeating what you said before. I'm asking our chief counsel to give us counsel.
I think this is relevant to the rules that govern these proceedings, which is not within my purview.
Okay.
Mr. Horton, if I may
If you wouldn't
address-
mind, I'll continue on with the projects in question. I've got data to present the projects in question because I've been combing through those particular projects. If the members would like to consider other data to support another kind of conclusion or more, if they want more data, then that's, seems like I heard that's acceptable, we can do that. But the department is focusing on their sampling, and I focused on the sampling.
Well, that's
So if I
respectful, but in the interest of fairness to the department and to the appellant, I believe that the additional evidence can be taken into consideration.
I think that's what we heard from Mr.
And I
Eppolite.
believe that if this body is going to do that, that the appellant should be in a position to be able to respond to that additional evidence. And that's why I've asked the question in the beginning. Are they prepared? Are they okay with that? They need additional time? Do you want to look at it?
I guess I didn't realize that we would be entering into an agreement to accept that the 1,200 contracts that are not for us or that your
You're
board
being a
doesn't
little
have access
sarcastic.
to, that would be evidence.
Contract.
Excuse me, if we could continue on with the appeal as is, and then maybe circle back to what else we might want to consider, or why you're wanting to consider other than the contracts that are currently here. I think that the appellant has gone through all of their contracts, or I know that from what they submitted, that's part of the record and part of the file. They submitted this base that supports their 47%, and the way that they did that was they took all of their fixed fee, all of their lump sum, all of their time and materials, they got a grand total, and then they figured out what percentage of their total contracts was that, and that's how they got to the 47.75 number based on the changes in the law. So I think you can look at a lot of contracts or no contracts or just the ones here to kind of support some of this. And so if we could continue, and then I would be happy to allow you to make a point for an additional contract, or if you want to. Right now, I'm looking at the ones that we were asked to look at based on the audit, but I think you can use the information based on Mr. Eppolite to make another decision or an additional, you can use the additional information just for consideration. But I did not consider this as new evidence because...
Well, this point of law is important because I do consider it new evidence. I do consider it relevant, and it does change my original perspective, and I'd like the department to be able to respond to that. In addition, the fact that new evidence has been entered into the record, it's been considered and opens this up for a re-audit where the department can request a re-audit, the appellant can request a re-audit, and this just becomes an exercise. So I think we probably should get some clarity. I'm not...
Which is why I wanted to stick to the projects. Why don't you let me go through the projects, and then you decide if you still need additional information and you want to allow what you just heard to really change your mind one way or the other.
I guess if I can just pop in for 1 second. If you're asking us to consider the additional contracts that were not in the record during the audit, that we would need additional time to examine those contracts.
So that's why I think we waited a long time to get to this hearing.
I just have a quick question. I'm going to digress because I just, again, we're all trying to figure out what the roles are and jobs here. But I'm concerned of what I just heard from the attorney. Is the attorney sitting, are you sitting there as our attorney on all matters as we're dealing with these issues today? If we ask you an opinion on something, or are you sitting there just as an attorney on Bagley Keene and ex parte? What is your role?
The MOU between DCA and BOE covers Bagley Keene and the APA.
I'm sorry.
The Administrative Procedures Act with respect to ex parte communications.
So in regards to legal opinion that we may turn to you on in regards to some aspect of law and whatnot, that's not part of the MOU?
Questions such as evidentiary questions is not part of the MOU.
So we're sitting here right now without an attorney to give us interpretation of the law.
I was under the impression that the Appeals Bureau did that.
At times, and oftentimes we turn to the chief counsel. Okay, thank you, just for clarification.
Okay, let me start. You wouldn't mind, because I think if you'll open up your first book, or your book, the first thing you will see in the book that I provided you is with regard to Pad E. And in all of these cases, I have one of these cheat sheets for the members to use, which I used, which basically says that qualified research expense has 3 categories for analysis. The first one is the Internal Revenue Code Section 41 test, which is 4 parts. A, claimed research must qualify as expenses for new or improved processes. And these are new improved processes to the appellant, not necessarily to the whole world, but they can be. And as you see, we've got some patented items and whatnot. The research must be used to discover information that is technical. The research activity is taken with the purpose of discovering information which is useful, has to have a solution for developing a new or improved process, and substantially all of the research must be elements of the process of experimentation for a qualified purpose. Now, the second part is the wages or expenses claimed, in this case it's wages, must have a nexus to the qualified research expense. The third part is that contract analysis must show risk, fixed fee versus time and materials. There has to be a risk of loss of failure of the research, and the appellant needs to have the rights to use the research. So, on the first one that I went through, yeah, it's a long process, but this is a big case. Pad E building, you will see the page. First, you see the description and the picture of the project, and you can read, if you choose, all of the different things that the appellant provided on these projects. This is all from the file. The next page is just a typed page as this, which goes into the IRC Section Code 41. That's what this is about. Section Code 41, the Qualified Research Activities Rules. It has 4 parts. If you recall, I said there's 4 parts to that. So the first one on this, in my analysis, was that Section 174 is a very low test. It's present in this project because there were unknown variables that had to be resolved. Due to the characteristics of the land to be developed, the desires of the developer, local regulations, Fuscoe was uncertain at the outset as appropriate design of the land, water drainage, water quality, utilities, and other infrastructure. The expenses claimed included a breakdown of wages by project, by phase, by person, and only a portion of the wages were attributable to the research performed to find a newer and improved process. The second part of the 4-part test is the technological information test. The research is used to discover information that's technical, and we found that the design and/or restore a creek is inherently technical in nature, that involve principles of civil engineering, soil sciences, hydrology, and environmental engineering. The business component test. The research activity must be undertaken for the purpose of discovering information which is useful in the development of a new improved process, a solution. This was the very first project for Fuscoe, started in 1992. Everything was new to the business, and the way that they adapted this was new. The process of experimentation test. Substantially all of the research activities must be elements of the process of experimentation for a qualified purpose. An old mall, which was what this Pad E is, it's an old mall, covered the entire 50-acre site, needed to be demolished, and all materials recycled for use in a new project. Dozens of alternatives were explored for consideration of recycled aggregate base, concrete, asphalt, and sand. Predicted several alternative layouts for Caltrans and finalized a retaining wall or design that would fit all of them. Sensitivity studies were conducted for drainage solutions when dealing with flood flows onto an old 1948 home track and other flood inundations, I guess it is. And interactive analysis of various water quality BMPs was conducted to discover the most effective solution given unique soils, regulations, site constraints. Careful and precise grading studies were completed to allow for ADA, and the very nature of the engineering firm is to develop and evaluate alternatives and with the engineering principles. So I felt that that first test, that first one test, IRC Section 41 test, they met the 4 parts here. The next thing was the wages, and what we provided. What was provided to the department and what was provided to all of us in the file of 15,000 pages were these wage statements, where they broke out exactly what was the qualified research expense of the engineers. We also were able to find in the file the resumes of the engineers showing that they were truly not just sitting around. These are really highly paid people doing very technical jobs. That's in there for you. You can see all of the resumes. So I felt that given their 47 whatever percent and the resumes that we had here, that really fell under kind of the Cohen rule, where they did provide, in my mind, enough evidence that these were technical in nature, that these were research people, that they weren't just out there doing standard engineering jobs, and that they broke off a portion of it, and they allocated it. And the research, these engineers actually had to fill out timesheets, was kind of as testifying as to what they did at the time, and that was all in our file of 15,000 pages, but I presented just for you what I had. The next is the Pad E Anaheim contract, and in that contract, if you go to, I just included a couple pages for you. I did not include the entire contract, though I do have that. The scope of services, and you can see that when you look through all of these tasks, that there are items that are fixed fee, their fee, and then there's an hourly estimate. So if you go to the very end, you can see that curb gutter stakes are probably, they're not experimental, so you can deduct the curb gutter stakes that were in here. We just went through everything, and there's a total proposed fees of $19,250, which hourly estimate $1,500, and a staking was $7,100, so minus that, so you've got some at risk. We did feel there were at risk here. And so that was Pad E, and that's what I went through with Pad E, that I felt that it met all of the 4 requirements. Sakioka, I believe, is the next project. That was 890 units, 46 building apartment complexes, a total of 40 acres on farmland in Costa Mesa. Again, you can see the picture, all of the grading, the groundwater site was truly a unique site. I kind of remember that because it's right here in Costa Mesa, right by the freeway, and South Coast Plaza area. And so I do remember that being farmland. But anyway, again, I went through the 4-part test, or the 3-part test, the first one being the IRC Section 41, and you can see on your sheet there for Sakioka, Costa Mesa, that again, the characteristics of the land, the desires of the developer. Fuscoe was uncertain at the outset appropriate design of the land, water drainage, water quality, utilities, and other infrastructure. The expenses claimed were attributable to research based on the information in the file, and they did build or use, it was research that was technical. It was technical in nature. It involved principles of civil engineering, soil sciences, hydrology, and environmental engineering. It was a very difficult project, site grading, groundwater, water quality, required unique site-specific solutions. And they worked with the city of Costa Mesa to apply new regs, innovative roof rainwater drainage system, difficult, let me see, groundwater, water quality, et cetera, innovative roof, rainwater drainage systems. And so they had some innovative new designs for this project. Again, when I looked at, from the file, we had this, which is a lot of names, but it was more compressed into one here that showed what they thought was a qualified research expense, which is basically payrolls. And then again, you get the engineering, the engineers' biographies, resumes that kind of tell what they did, how they did it, or who they are. And you can tell, again, they are not just, they're not out digging ditches. This is pretty technical stuff. So then we got to the contract, fixed fee or qualified time and materials. Again, we had to break that up. We looked at what was fee, what was not, the hourly estimates. I photoed that for you, just pieces of the contract. And so, again, I found out that I thought it did meet all of the 4 requirements. Now, on the next project, Seabrook,
Madam Chair?
Yes.
Pardon me, I'm sorry. If I could ask for your indulgence for a second. I am wondering if it might be possible to take just a few minutes recess. I flew in here for this hearing.
A long time ago?
She's going to miss her flight.
I might be able to see if I could reschedule so I could fly out later tonight. I would have sort of a deadline of, my flight's at like 3:30. So.
Okay, well, we will continue on with the hearing, so what are you requesting?
She just wants to go
I
out
just
and
want to run
change
out
her
and see
flight.
if I can change my flight. That's all.
Oh, okay. I don't know if anybody else wants maybe a 5
I mean, I
minute-
guess if you're just going to continue on with this, maybe we don't need a recess and I can just run out. But if there's going to be a Q&A that I need to be
Okay,
here
that's
for-
fine. Why don't you just run out?
Just go, she's going to go keep
I'm going to go through my projects, and then we'll talk to you, or the projects that I looked at, and then I will open up for questions to you. On Seabrook, I did not find that it met the IRC 41 test. And I did not see a nexus for wages. Seabrook seemed to be just a lump sum. It was a lump sum contract. It met that, but it was just seemed to be a standard mapping process. I did not see it satisfied the qualified research, and the appellant can argue that yes or no. But so being that I didn't believe it qualified, even though it was a lump sum contract, I did not consider that. Mountain View, and I don't think you have anything in your file for that I found out. Mountain Park. Now, Mountain Park was a 3,000-acre mountainous development. It says it used cutting-edge solutions. That's their talk, but you can see all of the maps that were in the file provided to all. And in Mountain Park, let me just get to... Okay, the 174 test, the 4-part test, go through that. I think I've said this before, land, water drainage, water quality, utilities, other infrastructure, very unique piece of property. They presented with breakdown of their wages. It was technical, I believe, because all of the different principles of civil engineering, soil sciences, hydrology, environmental engineering, and any contributions thereto. The business component test, it did create an improved process or solution. New designs were developed from research to meet strict criteria established by the U.S. Army Corps of Engineers, U.S. Fish and Wildlife, California Fish and Game. You can tell that project, 3,000 acres of mountain, very difficult site, needed a lot of different uses. Process of experimentation, it was a non-typical landform, grading that masked the development slopes and integrated sites into the mountain watershed, experimentation techniques for drainage, optimization of buildable areas, and habitat preservation. Had a unique design for landform and earthwork, dual storm drainage system, which was discussed by the appellant, unique flood control design that was supposedly never done before. We can ask about that. The wages and expense, item number 2, have to have a nexus to the qualified. Again, we got supplied with the timesheets and the amount of work that the appellant claims was qualified. Again, we've got the bios of the engineers, and again, they filled out their timesheets. This is what they did, which is kind of like a testimony. If you go to the contract.
Oh, Madam Chair, may I interrupt
Yes.
real quick?
Sure.
I follow what you're doing, and you're looking at the 9 that was part of the sampling agreement. And I was just wondering, in the spirit of time, if you can focus on the ones that they're only arguing for now, because on their Exhibit 2, for an example, they are no longer saying that Mountain Park qualifies. So perhaps we could only look at the ones that they are including in their calculation.
Oh, I am missing that. And is Mountain Park no longer considered?
I'm sorry if it's not, because it should be. It was probably the biggest contract we did during the 2003 to 2006 time period.
Said it's not.
And it
Who
certainly is.
said it was not?
Exhibit 2?
I don't know. I'm just the guy that does the work.
I think that appellant's counsel indicated that it was, that she had removed it from the group because it was funded research.
Okay.
Anything anything we got paid
Anything that
for.
was funded doesn't
Right.
qualify. I didn't find it all funded, but that's okay. If you admit that you say it's funded, then Mountain Park doesn't work.
Well, I mean, I personally, I'd like to hear if the member believes it wasn't funded. I'd like to hear what she's
I take my
saying.
exhibit back and we go through
Okay.
it.
Well, I do think it wasn't funded. We had, okay, Mountain Park, let me see, is that what this is? Okay, it says in the contract, if either the time and materials or the both fixed fee and time and materials blocks under item 1 above are checked, then all amounts listed in this exhibit are not to exceed, and the amount shown with the owner's written contract change order. So you'd have to make a change order. So both fixed fee and time and materials were checked, and so that indicated risk to us of an unfunded contract, because it states in here that, you have to have the owner's written change order. So the contract is 15,000 for that. So that's where we thought it included that. But that can be a subject for discussion, maybe with the appellant. San Mateo Creek, now that's the frog.
That's the frog, or
That's
toad,
the
actually.
frogs.
Frogs hop, toads don't.
Again, I went through the whole thing for San Mateo Creek. You can see the piece of land where it was, the 4-part test activity. I went through all of the 4-part test. I thought it met the IRC Section 41 test. The wages and expense, again, was another sheet that they provided based on the timesheets and the multiple things we've gotten that file, 15,000 pages. So I just broke out the easier ones because we did review a lot of that. And for the contract, I gave you pieces of the contract or maybe the entire contract, but you can see that it's fee, fee, fee. That's what it says in the contract, it's fee. So I don't see, hourly estimate was for meeting and coordination, an hourly estimate for construction field phase inspections, but basically it was a fee contract with risk. And in all of these cases, Fuscoe retained the right to use the research. They use it again if they choose, or it's theirs. And you could see that in one of the items that were brought. The Palm Springs, Delano Palm Springs, I am I'm not really sure, and I will ask the appellant later after you all have your chance, but the Delano Palm Springs is the one that I'm not sure about the contract. I think you can see where it was, what they were doing, the engineering, all of the four-part test. I did feel that they met the four-part test in the first IRC Section 41. They did the same with the wages. They broke out what was qualified for the Q, for the qualified research expense. Again, all of the resumes, et cetera, showing the caliber of the education and the fees that were, or the criteria that was required to work on the qualified research. The contract. Fixed fee or hourly, but, you know, there are some areas here that I will want the appellant to explain, to show me where they thought the risk was in the contract, because I'm not sure on that one. National City Costco, sounds like just putting up a Costco. I think if you look at that, you will find that that really wasn't what it was. It was quite a undertaking from below the building. The same thing, I do believe it met the four-part test of IRC Section 41. The wages and expenses, again, I think they provided a listing of what they thought was the qualified research expense based on their timekeeping. We've got the, you know, what we could drag from the file were the resumes there. And then we've got the contract from Costco that does say it's a fixed fee, Exhibit A fixed fee. So I think that that's a pretty good indication. It says that on Exhibit A, it says Fiscal will perform the services on a fixed fee basis, except where noted, and there are a couple notations, but it also that kind of speaks for itself. So I do think they met all of the qualifications on the Costco. Merriam Mountains, I had a little bit of problem on Merriam Mountains on the funded or not funded, so I would probably want an explanation on that as well. I think all of the other tests worked, but funded and not funded was a problem. For me, I'm just not sure. I would need the appellant to explain that. And Sapphire Towers, we did not have a contract in the file, so I can't opine on that, so I would have to, based on current evidence that we have, or current file documentation, I could not deal with Sapphire Towers or grant Sapphire Towers that because we don't have a contract. So I guess that's that. I think that gives the members and the staff a lot of what I focused on and what might help guide some of the questions. And so with that, I will let the members ask whatever questions they want. I'll entertain that, and then I will come back to the client the appellant, if you don't, regarding the projects that I was uncertain on. Thank you. Member Horton?
Yes, thank you, Madam Chair. I would like to ask the respondent to provide input on the chairwoman's description of these items.
So, I mean, there's a lot to talk about. And I guess we can start with, let's start with the contracts, because we've got each of those contracts with the exception of the Sapphire Towers contract, but we don't just look for the word fee. We don't just look for the word fee in a contract to determine whether it is a fixed price contract or a not fixed price contract.
Apologies, but we can't hear you.
Sorry, we don't just look for the word fee in a contract to determine whether or not it's funded. The courts are very clear that we look for all these elements, and on balance, if those elements are present, then a contract is funded. For example,
Let me just clarify. I only pulled out little portions of the contract. We did review the entire contracts, and that's where I came up with the determinations that I did. I pulled out just things that would say fee so that it might be easier to digest. But
Okay.
just before you go on about how ignorant my presentation was, I just want to be sure on the record that my staff did review the contracts. And I just got a note that there's something on Delano Palm Springs that I did not see. So I think, I just want to clarify that for the record.
in no way am I
Thank you.
mean to suggest that, but.
No harm, no foul.
But especially with respect to the Pad E contract, what happens if the contract's terminated? We look in the clause here says that, they will get paid for whatever they do, and in addition, they're entitled to 25% of the profit, 25% of their anticipated profit on the value of the services that they performed. So there's no risk that they're not going to get paid, even where a contract is terminated. They're going to get paid for whatever work they did up until the point of termination. So that is a risk that the courts looked at. And so simply by virtue of, we can't just say because there is a fee that it is funded. If we look at, say, the Sakioka contract, I think you mentioned that they retained substantial rights in that contract. In fact, one of the pages tabbed by appellants is the ownership and use of project documents, and it states here, all of the plans, designs, sketches, photographs, presentations, and renderings related to the professional services are and shall remain exclusive property of the owner. So not of Fuscoe Engineering, but Fuscoe did retain the right to use the materials for publicity purposes. But publicity is not a substantial right for which the courts or the Treasury regulations allow a right in the contract. And where a contract where a taxpayer does not retain rights, they are not, that it is also funded. Again, I think the Seabrook contract was dealt with.
You will have a chance to respond, but right now, Member Horton has asked the FTB about some issues.
While that contract, so we'll move on to the Mountain Park contract. And what does that contract actually for? If we look at the scope of the services, consultants shall provide staking as needed for grading limits sufficient for intervisibility at or at 250-foot intervals, including appurtenances. So they have to put a stake within a visible sight of the next stake, and they have to mark out the appurtenances. So any easements, any encumbrances on the property. That activity, that's the only activity that is, here in the Mountain Park contract that we have. That is certainly not qualified research.
Do you want me to answer these, or do
You
you
will
want to try to
get to-
accumulate
Why
them all?
why don't you accumulate them, and, because let him go through,
All
and
right.
then it will be your turn to
I have to
respond.
remember all
Member
these.
Horton will
Yeah.
allow you a
Okay.
chance to respond.
With respect to Delano, they are claiming just about every single thing that they did, whether or not that included aerial topography, so you're mapping out the location. That does not necessarily involve a qualified research, a sewer plan to the city. This sounds like a regulatory item. Water improvement plan to the Desert Water Agency, a storm drain plan to the city, off-site street improvement to the city, notice of intent to the State Water Resources Control Board, the fire master plan to identify hydrant locations to the city, and project coordination, which include, government agency processing. Again, those are all activities that are not qualified research within the terms of the statute. If we look at the Miriam Mountain contract, it's primarily an hourly estimated cost. So if something is an estimate, that is subject to change. And so it's not a fixed fee. It's an estimated fee.
Right, I agreed with you on that one, but we'll let the appellant respond.
And with respect to the National City Costco, that's a time and materials contract. I believe that even appellants in their May 22nd, 2015 additional briefing stated that that was a time and materials contract, and so it was a funded contract. And in that contract includes the same terms as many of the other ones that they're claiming. In the event of termination, the client shall pay the consultant for all services rendered to the date of termination, all reimbursable expenses, and reimbursable termination expenses. So in each case, while the contracts do include the word fee sometimes, the contracts don't act like fixed fee contracts. And the taxpayer, it would appear from these contracts that the taxpayers have a way of being paid.
Member Horton, do you mind if Ms. Ma asks a question?
Thank you, ma'am.
So I think the taxpayer has an unusual type of company, and I just want to focus, instead of trying to figure out, do they qualify for one of the four, let's go maybe the other way. And if you go to the Franchise Tax Board's publication, or at least the Research and Development Frequently Asked Questions, number 5, there's 14 items that say, what research activities do not qualify for California's R&D credit? The following research activities are specifically excluded by the statute. And you go through the different ones. I could read it to you, but I think the number 14 is the one where we are in dispute, or the bone of contention is the funded research, any research funded by grant, contract, or otherwise by another person or governmental entity, right? And then if you go to the Syntech versus Commissioner case, I think when it talks about, what is funded versus not funded, number 1, taxpayer must retain substantially all of the rights of research. And I just want to ask the taxpayers, do you retain substantially all the rights of your research?
Yes, we do. And actually, there's an exhibit that I didn't get to in my diatribe. Exhibit 3 that is in reference to the funding analysis. And it walks you through a handful of the contracts, of the sampled contracts, not all of them. I believe I removed the ones that we pulled out for time and materials. So I believe that what you're looking at on Exhibit 3 are the sampled contracts that are fixed fee. And this references the rights
I just
retained.
want to ask, okay.
Yeah.
Do you retain substantially all the rights of your research?
Yes.
Okay. Number 2, the amounts payable to the taxpayer under contract must be contingent on the success of the research. Taxpayer must bear economic risk of loss.
Yes, we do.
Okay. That, I think, we've been going back and forth, right?
Okay.
Cost plus contracts, funded, lump sum contracts, fixed term, not funded, cost plus contracts subject to maximum. That was in the case, right? This was in the Geo Syntech case. So I don't know. I mean, I think they qualified that they're substantially retain all the rights and that they're contingent on the success of the research and that they bear economic risk of loss. And is the franchise taxpayer, you saying that is not true?
It is our reading of the contracts that they do not have, that they do not have economic risk as it is defined in the regs and in Geosyntech.
And also that they do not retain substantial rights.
Okay, with the, Mr. Fuscoe, you've been
Yes.
waiting to respond.
Well,
Would you like to do so?
I'm going to just cut to the chase. That's just my nature. I apologize, but it's how I got to be CEO. Our contracts, I've been writing them for 40 years. And all the clients have slightly different language. And if you go into these 17 or 37-page contracts and pull out little paragraphs like they're doing, you can build a construct of anything. But fundamentally, I'm just testifying under oath, or however you want to put it, that the way it works is 80% of the work is usually fixed fee. That's what they call it. I tell them it's $30,000 for me to do your storm drain system, and I tell them it's $40,000 to do your sewer, and so on. And that's a G-max, if you will. And the contracts that they're giving you the snippets from all will say as per Exhibit A. So you got to go look at Exhibit A to really see what the work is, and that's our list of tasks. There's usually 10 to 30 tasks in every contract. And sure enough, there's 2 or 3 T&M items, almost on every contract. It's meetings and processing at the city, things that are just so vague we have no idea. All the clients get that, and they just say, well, what do you think it'll take, Pat? And I give them a number, and then they kind of try to hold me to that, but I go back begging for more when bad things happen. So there's fixed fee, there's T&M, it's about 80-20 ratio in all of our contracts, and then there's the ability to do a change order, which they're rightfully bringing up, if the circumstances change halfway to the end, and it wasn't our fault or our doing, it was someone else's, then I have a leg to stand on to go to them and beg for more money. And they will, if they're fair, they'll give it to me because it's not my fault. But if it's my fault in their view, they'll say no. Right. So of the change, we probably write 5 to 8 change orders on every contract, and we probably get 4 of them or something like that. So we have some losses there too. So when the day is done, it's fixed fee, T&M, and change orders, and that's it. There's no such thing as a cost-plus contract in my life. In my company, you won't find one. And there is risk in every contract, regardless of what the boilerplate language says. Those fees and those tasks, how I write that task, if I say 6,000 lineal feet of storm drain will be designed in these plans, and it turns out to be 7,000, then I can go back and say, see, it's different. So that's my world. I just want to, he also picked on Mountain Park. I don't know where you found it, but that was like a $3 million contract that we had 30 people working on for 5 years. And at the very, one little teeny task in the middle of all that work was for our surveyors to go out and set stakes in the ground. And somebody found that in the contract and pulled it out and said, this is just rote, robotic work that has nothing to do with research or experimentation. That's right. It is. It's one of like 1,000 tasks that we did. And so great. Somebody took a fine-tooth comb and found a task that was, not qualified, and I wouldn't even beg you for a credit for that. The fact is that project was fixed fee, 80%, and we got into so many things that we didn't anticipate. And the Irvine companies kind of say, hey, Pat, you're the experts. You're supposed to know all that. So we beg and we plead, and sometimes they give us a little more money, but in the end, we don't get it all. And that's why I'm asking for the credit. That's all. I'm not asking for credit on anything I got paid for, ever. It's not right, I wouldn't do it. Okay, I'm sorry, and since I might as well finish with these other things. So there was this discussion about the Delano. It's confusing, I guess, and I'm sorry. It's another one of those sort of runt of the litter things. But we give them a fixed fee for what's called a precise grading plan. That's the teeny-weeny little detail of every little thing in that 53-unit subdivision, all the little gutters and zillions of little data points. And we say, here's the number. And then we found out that we couldn't get the water out of the yards. I remember this because I remember the guys coming to me going, oh, crap, Pat, what are we going to do? So we went to the city, and I don't know how, it was a miracle, but we convinced them to let us put the drain pipes under the houses, which they never allow. But they did, and then we had to design this real crazy sort of Byzantine layout of pipes that ran all over the place under those houses. There's no way the client's paying me for that. They said, you should have known that, Pat. So that's the answer to the Delano, if you will. You could say it's my mistake. I should have known that. Well, some things you just can't foresee. Who would have thought that they'd design their layout so that all the water got trapped in every yard? I just couldn't foresee that. The Merriam Mountain project, same thing again, folks. I'm sure we had a lot of T&M on that because we were in the county and they were asking for things, and it's a brand new thing the county had never dealt with. But in the end, we got paid fixed fee and we got paid some T&M, and then we spent extra time and money to develop the first hydromodification report and approval in the county and in the state, by the way. So no one had ever done this before. They just said, you guys go figure it out. And I told our client what I thought it might cost, and then she said fine, and then it took 5 times as much, and I couldn't get her to pay 5 times as much, so we ate all that. But we're very proud of it, and we brag about it and try to get value from it by showing everybody in the state that we were the first and all that. So that's my answer on Merriam. Sapphire, I'm sorry, there's no contract for it, but again, I gave you the little description in there of planting that 32-story building into basically the ocean. The sea level was only a few feet below the ground, and so we had to put 11 feet of concrete in the bottom of that building just to ballast the building like a boat, if you will. And nobody foresaw that, so whoops, we had to just do it. So I'm sorry, I'm done.
If I can just add a couple things to that. In reference to the substantial rights and retaining thereof, in this type of industry and in Fuscoe's provision of services, there's 2 types of intellectual, or I guess property rights that are created by virtue of his services: tangible rights and intangible rights. I walked in, and I'm not sure if I caught everything, but what I think I overheard was opposing counsel refer to a term in the contract that references documents, ownership of documents, plans, drawings, stuff like that. That's the tangible result of his work product. That's his ideas reduced to paper. There's another half of that property that is developed in his, which is basically all of the concepts, the ideas, the know-how, the trade secrets, everything that goes into what is actually on that piece of paper that he retains, that he can therefore use on future projects. That's why he becomes an expert. That's where all of his, that's where his knowledge base comes from, is working on that over and over and over again. That's why he can approach a project and say, I bumped into an issue like this before, and on that project, this solution worked. Maybe this solution won't work here, but let's try it, and then, he can try and use that in the future. Those are the rights that he retains, and if you look at the contracts are either silent as to any rights, or they reference specifically only documents, only tangible items that you can, touch and feel in terms of anything that Fuscoe would transfer to their client. And again, there's some terms that are highlighted in Exhibit 3, and also terms comparison there to a case where it was decided not in favor to the taxpayer as a distinguishable item. In reference to change orders are offered or come up when the scope of work that was originally contemplated is being exceeded. Meaning, he pitched a project for 50 grand to do these 3 things. All of a sudden, a 4th thing comes up. They're not going to do number 4 for the same 50 grand, so we have to add a change order. That's typically where they come up. They have, their own pricing. They're still typically controlled by the same master service agreement and the same, terms and conditions. But that's where change orders come in. Additionally, I'd like to offer that even the Geosyntec rare earth contract that opposing counsel referred to had a provision in there for later authorized change orders. And that contract was still held to be unfunded. So change orders are not dispositive of risk. Third, in reference to activities that are found in the contracts that may not qualify, like survey and staking. In the production of, or in the implementation of this R&D credit, those items on any given project were culled out of the actual QREs. So Fuscoe is not claiming a credit for those items that do not qualify. Fuscoe is only claiming a credit, and we can show you with the project accounting data which activities the QREs were derived from. Fuscoe is only claiming QREs for those activities that involved a process of experimentation to resolve a technical uncertainty, and we wholeheartedly agree that survey and staking are not part of that. That's it.
Yeah, just to clarify, to me, this comes down to some of the discussion that we're clearly having in regards to the idea of the potential of economic risk and responsibility that would go into the project. And I guess where I'm kind of, again, it's tedious right now to go through these. Obviously, maybe necessary, but it's tedious to go through these in a project-by-project basis. But the point of it, to me, is trying to figure out where it is there was economic loss, potential economic loss, because of the research that was done, or it was just the responsibility of the company to do, with knowing that there would not be economic benefit at that point to be used either in that project or in later projects, or not used at all because it didn't work the way they thought it was going to work. Can you articulate for me, one of you, how would you explain quickly the risk of loss?
The risk of loss.
The risk of loss in these in a project that you would go into.
In these contracts, and again in the amended, I guess, contract amount where we're focusing on fixed fee contracts, the risk of loss is that he's pitching a solution to a project. He's providing a solution for a fixed fee. If he can't provide that solution within that price, he has to keep working until he can provide that solution. He has to correct errors at his own cost. He has to basically, go through.
Why is that not any different than any other contract that somebody
Because
would
there's
have?
a time and material type contract where you're basically just billing for each hour. So you can basically get, if he bumps into an issue under a time and material contract, a design issue that he has to, go through numerous iterations of design processes, he gets paid for each hour, for each iteration.
Most of the time, not always.
But under the terms of the T&M type contract, you're submitting a bill for the hours that your employees incur. Under a fixed fee type contract, you're only submitting a bill to the client based on a percentage of completion of the project. So you're saying, I'm 20% complete on this project. If you get to the point where you're 80% and you can't get any more, but you're still working and working and working and trying to come up with a solution, that's all the cost that he eats.
Is there ever an effort to where they, again, the company would try to seek reimbursement through a change order?
Oh, yeah, all the time.
Okay, and so basically, the path could be, there's a potential process, a path of reimbursement. However, that's at the discretion then of who you're doing your business with. Therefore, it could get turned down, therefore it was a not reimbursed loss.
It's at the discretion, but per the terms of the contract, the change orders technically are not allowable unless there's a change in scope. Meaning, unless the new thing exceeds the original scope that was contemplated under that original fixed fee. Does that make sense?
Yeah, it does, but the definition of scope sometimes would be, I assume, with the company there, and they would you would try to go ahead and do a change order.
Right.
And ultimately, they'd say yes or no.
Yeah.
I'm giving you anecdotally the reality. How the words are all put together is one thing. Like the hydromodification study on Marion is a good example. I wrote that proposal, that scope, without it because it didn't exist. In my experience, I'd never seen such a thing. And so I didn't think we would need it, right? I mean, because it's like something landed from Mars. We get halfway through the process and the county says the state just changed, the State Water Resources Board just changed the rules, and they've figured out that all your storm drains, Pat, are dumping water in these creeks, and it changes the creek's behavior and the character of the water in it. Well, that son of a gun, we should have thought of that. So now, Pat, you have to go back to your storm drain system that was maybe standard practice, if you will, and you have to fix it so that it doesn't change the character of the water in that creek. So then I go back to my client. So to your question, where's my risk? Probably a third of the time when I come back to a client with that story and say, gosh, you guys, I'm really good engineer and I've been doing this for 40 years, but I never saw this coming, and it's $50,000 or $80,000 of the work. Can you sign this change order, please, for it? Half the time they look at me and go, hey, you're the expert. You should have known that. You should have known that that was going to happen. And I get into arguments and I appeal to them and all that, but I'm just telling you, I don't win all the time. I win half the time, and it's usually because the client...
But is that by definition research?
Does that apply to research?
Yeah. How does that apply to research? I mean, if somebody changes the rules.
Yeah, well, on research, it's a little different. They're assuming I know how to do everything. So they'll say, what are you going to charge me to do these 10 tasks? And I tell them, and then I go about doing it, and I discover, as I told you, every site is unique and different. I'd find unforeseen circumstances physically on the site or regulatorily, like I was just explaining how the State Water Resources just sort of dumped this new thing on us. And again, so now, not only is it a contract issue that what we're talking about, is there risk for me, I'll lose money, but then I got to know how to do it. And nobody had ever done this hydromodification thing. So, whoa, wait a minute, Pat. Okay, I'll pay you to do it, but you have to know how to do it. I'm not going to pay you to go to school and learn how to do it. I'm just going to pay you for that finished document that Annika just described. That's all they want, and they don't care how much I have to learn. So that's where the research goes on. I have hydrologists, that's all they do, and they go study and figure it out on my nickel or on the company's nickel and come back, and then they come up with a solution from trial and error and whatever, and then we go try it on the agency, and if we get through, we win, and we get paid for that solution only, not all the research that we had to do.
Okay, thank you.
Yeah, all right.
Any other questions, board members?
guess so.
Member Horton.
Question of the appellant. When you are doing your research and designing and your analysis to come up with a process by which your client can use to accomplish the objective of the contract, at the end of that contract, and you come up with a process or a product of some sort, do you market that product to other clients?
I wish I could. It's not almost nothing I do is I can replicate anywhere else. I tried to explain that in my presentation, but I used extreme example. If I go to Alaska on the site of Mount Denali.
Let me retract.
Oh, all right, I'm sorry.
If I may.
Yeah.
Take the breathing road, for example. Did you come up with a end product or end process that allows the road to breathe?
Yes.
And then, as a result of that, you have now a process that you could patent if you want, or you may have patent that process. Right. And then you turn around and you sell it to other cities.
I think I follow what you're saying. So, yes, the group.
And let me sort of indicate that these are really leading questions. That might be helpful.
Think thoroughly.
This
is what I got paid for. But I did.
I understand that. You
yeah.
got paid for that. You were, the fact that you got paid for it is an indication of a funded contract.
That's right. But I didn't get paid. I did not get paid for all the research I had to go study on permeable, impermeable materials, on high albedo, low albedo, which has anything to do with sex. Has to do with color and the concrete. Heat gain, yes, I'm sorry.
In doing that research,
yes,
did you come up with a process that you didn't get paid for? A process or a product or a prototype that you now could in turn turn around and use again and get compensated for providing that product or that process to
not quite,
client?
but I follow what you're thinking and it makes sense to ask. So this is now in the public realm, the green streets. Anybody can do them. I just did them for the city of Burbank. It's not like I take what I did in Irvine and just plant it in Burbank. It doesn't work quite that way, but I know how to do it now. It's like a recipe for cooking spaghetti, and you get really good at making spaghetti, right? So now if you want me to make you spaghetti, I'm going to do it pretty fast and pretty well because I've been doing it. But I had to learn how to cook it myself. So I can't resell the research I did on heat gain on pavements. It's not a thing in a little box I can sell multiple times. It's knowledge that I have that enables me now to do it again and again, maybe a little faster, but each time I just ask, here's what I can do for you, these 3 tasks for this much money, and they pay me, and that's fine, and I'm not asking for credit for that. I'm asking for credit for the research I did to figure out how to do it that I can't sell, and that I'm putting in the public domain and making it beneficial for everybody.
So there are. Can you give me some examples where you were hired to perform research in order to accomplish a particular objective, and as a result of that, you were compensated, but there was research activity that took place that you were not compensated for? They didn't compensate you, but it's a process that you use to compensate it. It's a process that you ultimately sold to someone else.
If I could just highlight 2 things here. I'm a little concerned that we're equating payment with funding.
I'm not, really.
Okay.
I'm okay with you I'm okay with you developing something in your line of business of developing a
Right.
prototype.
Right.
And that's your business of developing this prototype. And then you're now using that process, that knowledge somehow, and you're marketing. You don't have to ever be compensated for it, but you're actually
Well,
marketing it.
There is a fraction of what we're asking for here that is in that box.
Falls in that box.
Yeah, most of it is not, though. Most of it is what I tried to describe a couple times, trial and error, experimentation. It's not really like developing a new technology, like a widget. A widget. It's just trying things, like on Jason's storm drain that everybody thinks it's a standard thing. It's not. All that is standard in doing a storm drain is the process. The county says, Pat, you have to figure out, you have to use this intensity of rain this often per year when the rainstorms come, and this is your time of concentration criteria. Go knock yourself out. They don't give me any drawings to copy or anything. I have to go then sit down and figure out, should I divert some of the flow? If I turn this much of it down that street, then I only have this much coming this way, and so on. And so I sit there and I do trial and error, back and forth, sensitivity tests, try this, try that, basins, underground pipes, try a different kind of pipe, concrete pipe, try a ABS plastic pipe, see what happens. And all of that I do as trial and error, experimentation. That's our normal wheelhouse stuff that I'm asking for. Now, over here on the side is this more esoteric research, like the hydromodification, which I'm very proud of. That was a specialized thing that we had to go put PhD people on. That's not as common every day, if that helps.
Yeah. I mean, it helps a little bit. I'm going to go to the department and just sort of qualify this. It sounds to me as if, though, the appellant is arguing
Right, that's what he's asking,
somewhat
but I don't get paid
aligned
for
with
that.
the
Just sort of-
Fairchild case,
Oh, well, I thought-
that there is experimentation that takes place that is not part of the original contract, that has a value, and that it is ultimately resold, barring whether it's I'm presuming that the experimentation exists. I didn't get into that yet.
So, to that point, two things. Part of the problem when we're talking about storm drains, okay, is that they haven't identified exactly what is the widget, what is the product within the storm
Product
drain.
or the process.
The product or process for which they're claiming the research credit. They're just claiming storm drain, okay? And in addition to storm drain, they're claiming sewer plan and these other, all these other items. But if
No, I think, not to interrupt you, but I think their testimony is that even though they are ending up with a drain, a standard, at the end of the day, they end up with a product that one would argue is just the same thing, just done a different way, I guess, is that in that process, they're doing research that is developing a process that is far different than any other process that has ever taken place.
Right, and this goes down to what's called the shrinking back rule. So the entire sewer system may not qualify, but some subset, some part that, hey, we actually did this research and here's our,
When you say the shrinking back rule, are you referring to substantially all? Is that where you're going?
No. I am referring, it's called the shrinking back rule in the Treasury regulations. So
Okay.
if you take a motorcycle or you take the storm drain, the entire storm drain doesn't qualify, okay? But perhaps there is some subset, you keep shrinking it back until you find the part of this storm drain that meets the requirements of Section 41. And so, and where there is a process of, 90% of this storm drain, I'm just giving you a hypothetical here, but might not qualify, but there might be some special runoff device that they developed in the course of this. So this subset, you shrink it back from the entire storm drain, you shrink it back to this part, and that's what the law says that would qualify, okay? But the problem is that I kept mentioning that they haven't identified their business components. They haven't identified, they just say storm drain. They don't say, it's this part of the storm drain that we really did all the research on. He has know-how from all these other projects.
That's an audit issue, it's not a legal issue. It's a legal issue by virtue that the law requires them to identify it, but that they can identify it through some audit process. That's interesting.
But that's one of the requirements of 41D1.
I know. So, are you saying that you would conclude that if there was a portion of this process, a project, that ended up with a new process that was not funded, but a new process and possibly a new product of some sort that was part of the original contract, but the appellant could actually use that process in other projects to be compensated for that process, that would qualify, or would that be funded or non-funded? And would it get, presuming that all the other experimentation is there and the research is there and so forth?
Well, I think, part of the problem is that we don't have the taxpayers haven't gone back and identified that part of us. I mean, that was a major part of my presentation today, was that, they haven't identified these business components.
And if they were able to, what then, say you?
And so saying they do have it, and they have sufficiently identified the business component, and it otherwise meets the requirements of Section 41, and it's not funded, then they could take the credit for it. But in this case, I think that these contracts don't act like fixed-fee contracts. Many of them, so we're not...
And given that, the second part of that would be the rule regarding substantially all. Would the department then say that it would have to be substantially all, or would, under the shrinking rule, you would allow to isolate that?
No, under the shrinking back rule, the substantially all thing was the Trinity Court applied that because the records had been destroyed by Hurricane Katrina. And so they had no other way of determining, whether or not this big ship qualified. Here, it's probably possible for the taxpayer to go and identify their discrete business component, as it says in the regulations.
Okay. Do you understand what the respondent is saying?
I do, and I'd like to offer that I think we have a sort of different interpretation than, I guess, in the definition of business component, because it's our position that we have identified the business component, and they are the designs, basically, as a whole, but they're identified more specifically by the subtasks of each project. So rough grading plan, sewer drain, items like that, those are the business components. Now, when we took the credit for a business component like that, let's say the drain, we did not take 100% of the hours that were incurred on that drain, in producing that drain. We basically, the shrink back rule is not necessarily applicable to this appeal, because the way that we captured the qualifying expenses were so detailed that we only captured expenses for individuals that were performing a process of experimentation on these individual qualifying subtasks. So we're not taking 80% of Merriam Mountains. We're taking maybe 60% of Donald Butler's time on his, 1.5 hours spent on May 4th, 2006, on the rough grading plan. So we're not taking 100% or any type of, actually,
I know.
We called out the non-qualifying, and we're not.
The respondent is what I'm looking for is a distinction between when there is funded, not funded, the activities that are not funded, and those activities that are not funded that have an experimental scientific value that meets all the criteria, and then you use that, there's a value to that you're using in your business and subsequent business activities.
So we're not getting paid for all of the work that we did. Unfortunately, I didn't create under my contract tasks a task called R&D, where somebody would, one of these college-educated licensed professionals will go, oh, I'm no longer working on the drain, I'm now researching it, I should put my time over here. We just didn't do that, I'm sorry. We just said, put your time on the drain. So then we have a $10,000 agreed price for the drain, and we spend $30,000, and we go in and go, what the hell happened? And they go, oh, I had to go figure this all out and research this and that. That we did that, okay? And then we isolated the part that we think qualifies, and that's what we're asking for only. We're not asking for the part we got paid, and we're not asking for any overage that we did on something that was just somebody made a mistake and they were fixing it. Okay, we have a
Be
thing
mindful,
called,
being compensated for it will not distinguish us as funded
okay,
versus
well, I'm just
non-funded.
trying to help.
If you have a contract and you end up with overruns of some sort,
Right.
it's just a loss, profit and loss.
Right.
It's nothing.
And I'm saying we are segregating errors or just some kid that we hired who's learning. You know, we're not, I'm just saying we've already segregated that.
In the cases that you presented to us, the fraud case, San Mateo's, coming up with this fence.
Yeah.
Was there some sort of patentable design or something with this?
No. It's just a fence. You can't patent orange juice. You can only patent...
You don't want to say that.
Well, I'm sorry.
You don't
Go
want to
ahead.
say that. I mean, that works against you, what you're about to say.
Right.
All right, for this point, let me know.
The research to create. Did you have something to add?
I'm thinking.
I don't think
Okay. Okay, are there any other questions from members?
Will it take the matter under submission?
Okay, is there a sec?
I think we need do we need some sort of a motion where you're going with your research and your analysis?
Where I'm going, we can't,
Discuss it later.
we can discuss it before we vote again, if you'd
all right.
like to.
Okay, I don't know what-
I'm, by my sheets, I think you can pretty much see that I'm thinking that most qualify. I was a couple, because I needed explanation from the appellant, and one of the problems we have is we could not call them and ask them for certain specific items. We had to find it in the file. And we did find as much as we could in the file, but that doesn't mean we found every part of the contract or everything. We took the points that we thought justified, or when we didn't find a contract, we just had to say we didn't. And I asked for explanations on Merriam Mountain, explanations on Seabrook and Sapphire Towers, which I think we got. But I'm not, they're asking for 47-point-something%, which is because the law changed from the time they had submitted. As I read this, it says in 2008, Fuscoe filed, Fuscoe et al., filed amended tax returns claim research and development from 2003-06. The credit claims identified the amended returns were based on regulations, existing case law in effect at that time. The taxpayer since acknowledged, which was July 5th, we received this in the file. We did not request this. This was sent to the FTB. The taxpayer acknowledged that since 2008, the applicable case law has changed and advanced based on recent holding on Geosyntac case. We know that certain fee structures are no longer eligible and were held to be funded, which is how they then went through every contract again from what they had, and they figured out what under the new law was funded, unfunded, and then of all of their contracts, be it 741 that's in the file or 1,200, whatever we've decided that they've done, out of all of their contracts, they figured they had a 47% of all the contracts of unfunded. And that's what they were asking for. Originally, they were applying for credit for all of it. And so this is the pertinent part that was an addendum or sent later to the FTB that is in the file. I'm happy to share that with you. But that's how they arrived at their 47%. So that's kind of what we're looking at.
So to clarify, what we need to, if we take this under submission, then the point would be that as it would come back up for a vote, if indeed we go this direction once we get clarification, there can be certainly time for discussion and clarifying of these issues and an ongoing discussion to kind of differentiate what's in, what's out.
Right.
Right?
I would encourage members, though, because the appellant is here, that if they have any questions at all on anything, like I did on these contracts, I can't ask for any additional information at this point, but I sure do wish I had absolutely every. But
I do have a question on that note.
Okay, thank you.
Good. To appellate, I'm looking at your Exhibit 2, funding analysis, financial risk. On the second page, you only list 4 contracts, 1, 2, 3, 4, as not being funded?
Correct.
So and that's 4 out of the original 9. So the other 5 you're saying are funded contracts?
I believe that was my thinking in that I pulled those out because they were time and material.
Be sure before you respond. You will not get a chance to correct your answer. So don't guess right now.
That was the intent. I can double check on whether or not I got that right.
This is these 9, I know, 9 or whatever we've got, I know we all understand are just a sampling. So that was an agreed upon sampling. But the overall.
I left out San Mateo and Seabrook.
San Mateo and Seabrook, so you're saying that San Mateo and Seabrook are unfunded contracts?
Yes.
But they're not on this exhibit?
Yes.
Well, Seabrook is on this exhibit.
Oh.
Right, and San Mateo Creek is here too. That's the frogs.
They're both in this.
Seabrook, well, they're not on the chart that she's referring to. Or San Mateo is not on the chart. 1, 2, 3, 4.
I don't know what chart are we talking about?
Appellant's Exhibit 2 that they presented today?
You know what,
Oh,
I
that
left
was
off.
presented today.
I think I left off Pad E and,
Well, there's several, no, all right, so this exhibit I hate to say it, but I'm having a hard time relying on it. It's not complete based on your analysis?
I did, oh, no, Patty is in there.
I don't
1,
know
2, 3,
what
4.
was turned in today. I'm a bit confused. There
saying
was
you're
some
clumsy.
turned in, some not. That's why I just went to what we had. Because I'm probably not considering too much of what was turned in today. We're based on what we had.
San Mateo.
I'm I restate my motion. I don't have any more questions at this time for the appellant or for the Franchise Tax Board.
Funding analysis, I see this, funding analysis. Okay. Well, if you want to elaborate on that, this is the time to do it. I think, again, these were sample projects, they're not, and we're looking at them just for a guesstimate as to where they were, and they were part of the audit sampling, but they had 1,200 or how many projects and a lot of other projects, and so this is just to break it down and make it easy. And who chose the projects?
FTB.
To be sampled.
Well,
FTB chose the projects.
These were a random sampling. The taxpayer provided a list of all of their projects, and Franchise Tax Board simply picked every 125th project.
I get that they were random sampling, but I know that the FTB did choose the projects, and some of them, are a little more difficult than others.
Actually, excuse me, Madam Chair, I'm actually reading this sampling agreement letter dated March 30th, 2009, and it states that the sample is selected from the 2003-2006 year of qualified projects listed on their report. The sample will include the first project list and every 125 project listed thereafter. So that's how it came about. It wasn't where
Right.
FTB had some insight on just picking the smaller projects.
Well, these aren't small. Some of them aren't small. I didn't say that. Some of them are, I think the description was runt of the litter. So, and I would expect that, I mean, I think when you look at, Costco, who could say that Costco was unique? Well, I think we understood by the positioning and the ground and stuff that this National City one was a little bit different than the standard Costco. So that's why, when you first looked at the file, there wasn't much, and then I started asking my staff to tell me what are we really talking about here, and because you can read it, but then that's where I came up with my test, the three categories for analysis, and if you get through one, then you go to the next, and I think on just about every one of the sampling, I came up with something that I believed fulfilled the test requirements. But since we're not voting, we will leave that up to the members to cogitate, and when we come back, hopefully tomorrow, we can cast a vote on this. And so I heard a motion to take the matter under submission.
We'll take the matter under submission.
Is there anyone seconding that? Second by Member Runner.
Can I just get some clarification on that motion, please? So what you're saying is you're closing the record for today, and you're continuing this to the agenda tomorrow?
We will
for
be voting
consideration.
tomorrow, and there may be some comment after. If somebody makes a motion in a second, then it's always open for discussion up here among the members.
I just wanted to clarify the motion that you're talking about continuing the matter till tomorrow, the discussion on the matter.
Yes, not continuing the hearing, but continuing to the vote. Okay? And discussion among the council, pardon me, I'm not city council, discussion among the board could ensue once a motion and a second are present.
Madam Chair, just for point of clarification.
Oh, excuse me, was there any objection to that? No, okay, such will be the order.
If
Okay,
the taxpayer or I only hesitate because new information that evolves out of these types of discussions that is not really being fully briefed, but I get it's the world that we're in. But under normal circumstances, we could indicate to the appellant that if they had additional evidence or information, that they could share that with appeals, and appeals could...
Yeah, but we don't have 30-30-30s under my mind anymore. I don't really want to do that.
Even outside of the 30-30, while we take the matter under submission, I don't know if that can happen now. Mr. Applewhite?
I would be very concerned, to be honest, to reopen up issues only because...
Again, this is a point of clarification that has nothing to do with the case. But, Mr. Applewhite? Just these new rules. I know how to do it under the normal
Well, I mean, that would be up to the board to, do additional briefing, the concern just being, how soon the matter would come back to the board for
No, it's come back tomorrow, so
for consideration.
I think, excuse me,
But, I would just consider the fact that you already have a lot of evidence before you in the record, so.
yeah, there's 15,000 pages in the record, a lot of data, and that's why there were a couple things that we were missing when we reviewed it. We could not call and ask for it. We actually had to grind through. I asked my staff to please justify, not just tell me. I wanted to see some kind of paper justification or evidence that these tests were met. And that's the task that they set upon doing, since we don't have that many constituent issues anymore. They had plenty of time. And two of them really dug into this, actually more than that, dug into researching the 1,500 pages. So that's why I presented kind of a small encapsulated summary for all of you as to what I was looking at, and hopefully it helped. Anyway, so we have a motion, we have a second, we had a vote. Thank you so very much, and thank you for wading through all of the reorganizational issues that we're having. I hope everybody understands we are under open meeting laws, so we really can't get together and discuss issues that affect the administration of the board. So when we get a memo that's a problem, or we can't really discuss cases with more than one other member, and since we don't want to even get caught, we don't. So it just was very, very difficult start, and I thank you very much for your patience. You were here early and on time, and thank you so much.
Thank you.
Welcome. Is that it? We good?
Thank you.
Yes,
Let me make a suggestion, since we're already almost to the dinner time. Can we take a meal break now, and then when we come back, continue on till we end?
yes, I think that would be a good idea. I feel sorry for anybody's here, but we had a very long day. We have not had a break at all yet. So what do you want to do, a half hour or? Half hour?
Yeah.
Okay, a half hour break. Actually, we'll be back at 4 o'clock. 4 o'clock.
Good. Thank you.
Have we got all the bodies that we need to resume the meeting? Yes, okay. Thank you for the recess. We are now ready to continue the hearing. Ms. Richmond, please introduce the next item.
Madam Chair,
Yes,
I will not be participating in this item, so I'll let you guys continue.
all right, finish your lunch.
So our next item is B3, Jeffrey Moffatt.
I can't hear you, I don't think your mic's on. Here we go.
So our next item is B3, Jeffrey Moffatt and Staretta Moffatt.
Thank you. Mr. Eppolite, will you please introduce the issues in this case?
Chairwoman, did you want council to go through her iterations
Oh,
first?
that's right, I'm sorry. I'm still got training wheels on that one.
No problem. This is all a new process.
And I wanted to clarify, I think Member Runner is recusing himself from
That's
deliberations, participating in deliberations in this matter.
Right, he is.
So wanted to ask the members if they had any oral or written communications from either the parties in this proceeding that may have not been provided to the other side and that they want to disclose and need to disclose.
Yes, let me get my,
To the best of my knowledge, I've had no oral or written communication with the appellant or the department in this case. And to the best of my knowledge, neither has my staff.
I have not spoken with the appellant or the department regarding this matter.
I wish I could see my statement, so I'm going to be really brief here. Try to get up.
I can go. To the best of my knowledge, I have not had any communications, nor has my staff, with the taxpayer or the department.
To the best of my knowledge, we may have had communication with the taxpayer and the department, and we discussed issues in the briefing, that were both in the briefing, with both the taxpayer and the department, and nothing new to add to that, to the best of my knowledge. Thank you.
I will ask the board if they have any communications that they think they provided to the members that is either in addition to or differs from what has been disclosed.
Not to the best of our knowledge.
And I would ask the same question of the taxpayer.
No.
Okay, and then whether or not the board has any comment that it wishes to make on any of the communications that have been disclosed.
If all information discussed ex parte is in the briefing record, we do not wish to respond today, but we reserve the right to respond upon receipt of the formal opinion on ex parte tomorrow.
Got that official response.
Now I have the official response. If information discussed ex parte is not in the briefing record, we reserve the right to request copies of all documents and written evidence of oral communications pending receipt of the final opinion tomorrow.
I would also like to add to my ex parte comments going forward that I, like Member Runner, believe that the ex parte is applicable after July 1. We've had absolutely no ex parte communications with anyone after July 1, and it is only to those prior to the statute that I am responding that to the best of my knowledge.
Then I would ask the taxpayer whether he has any comment that he wishes to make to the disclosures that have been made just here and now, separate and apart from any argument you might make.
Other than my wife was actively running against Mr. Runner's wife, and, for Senate, and I was running for Congress and actively going against one of Mr. Runner's appointees. So, but, given that he's not here, but just to make that, so that was actually in both the 12 and the 16 election. Other than that, that's all I have.
Thank you.
Okay, thank you. To the appellant, will you please
Ms.
introduce?
Harkey.
Yes. Oh, okay, now it's your turn.
Thank you.
I'm sorry.
Chairwoman Harkey, members, one issue before the members in this appeal, and that's whether appellants are entitled to a loss for a canceled sale of real property.
Thank you. And now to the appellant. Please introduce yourself for the record. You will have 10 minutes to present your case. Then we will hear from the FTB for 10 minutes if they choose, and you will have 5 minutes on rebuttal after that.
My name is Jeffrey Moffatt. I'm representing both my wife and myself. And the dynamic in this, as I brought up in my briefing, is kind of some small-town politics. I happen to have I own a block of properties and had sold one of the sides of the properties for $1.8 million. We were going to be using it for high-end drug treatment. Long and the short of it, one of the arguments that the FTB stated was that there was no proof that the Grimes had taken possession of the property, and because of that, they were saying that the case that I had covered, Cornfield versus CIR 787 F. 2nd 1049, they said, well, because you didn't show that they had taken possession, we're going to disallow this. I believed it was in my exhibits previously, but just to make it perfectly clear, there's a single page that you have in front of you by Armando Chavira. It was in response to the breach, and also indicates that they vacated the property. So they took possession of it, and where it's similar to this Cornfield case is it was a long-term lease also. This was a lease option to buy for $1.8 million. And again, the proof that they had it and left, or the leaseors and the buyers, is this Chavira document. The next thing I have is this HUD finding, and what's also interesting is the city of Lancaster had created a new not in my backyard policy that the Department of HUD finally did a finding in 2011, and it found on page 2 of this is the document that you also have in front of you, that there was several points that were unconstitutional and illegal. The problem that I had with this is they came and looked at the property, as opposed to when I sold this thing in 2008, where we were doing drug treatment. They were looking at it in 2010, 2011, and they were saying, hey, Jeff, you didn't show me the medical records of your clients. And I said, please give me a subpoena for, that satisfies HIPAA requirements. I asked them multiple times because they said, well, we want to see that you had patients there. Drug treatment individuals are in fact patients. They wouldn't give me a subpoena, and if you would care to give me one, I'd be glad to help prove that out. But unless I'm given a subpoena, I can't give out client-patient records. So anyway, the problem that, at least as to this HUD finding, is that it said, hey, this was illegal, but we can't see that it impacted you. But again, my testimony is that in fact it made it impractical and shut down a $1.8 million deal. And the other thing that's kind of interesting at least in Lancaster, is we had a property right across the street, a school district, that was being flipped over to a friend of the mayor's. As you may know, Mr. Runner used to also be a mayor of Lancaster. So there's some interesting connections, but he wasn't a part of this deal. But anyway, there was a 3-part deal with the Johnsons and the city to move in a university right across the street from this block of properties that I have. All of a sudden, while this process is going, the city changes the ordinance, creates this unconstitutional ordinance where I can't sell these properties, have a $150,000 or so that I've taken in between collateral and cash, and and then I have this breach sale. On, this loss carry forward, just, to make it clear, was presented to the IRS, and the IRS has accepted it. There is no funds due to the IRS for this particular tax year. And so from my standpoint, it's kind of a res judicata issue. This was a business, was breached by a city, which is a sub-government of the state, was found to be unconstitutional, and I was impacted. And therefore, at least under this Kornfeld case, this loss carry forward should be allowed. I could stop right there and just reserve the rest of my time, if that would be okay, Ms. Harkey.
You can stop when you like. You will have 5 minutes on rebuttal, and then I'm sure it'll be open to questions. But if you have more to add, it's still your time. You've got another 5 minutes if you want.
All right, fair enough. Let's see, I guess the next thing, just from a last clarification, is this three-part sale with the city and the Johnsons that involved flipping a school district, which was going to be sold for $1, but it turned out to be, from what I understand, contingent on me not getting continuing business as a drug treatment facility. But given that I ended up getting the HUD involved, that third part of that deal went sideways. I had individuals come to me from the school district that were there. They were already pointing to the building that they were going to be moving to once this deal all went through. What do you know, when HUD got involved, the mayor was kind of on the hook. He ended up buying this McMahon building on 10th Street in Lancaster and putting his own law firm there. So they still finished out with it, but the school district is still the school district, and my properties are still there. But, again, there was, I would, if the court would entertain issuing a subpoena, if it would like to grant me that. I don't know if you have subpoena powers, but I'd be able to, number one, show that I have had medical clients or drug treatment clients in there, and I was impacted, and would have satisfied that the element that HUD said I didn't show. The next thing is I'd like to be able to show, if you would issue me a subpoena, or that I could go and apply to the past owners of the McMahon's building, the school district members, I believe they would call it the chancellor of the school district, and show that if a subpoena would be issued, to show that there was in fact negotiations for this transfer of property, and the elimination of my program was part of the deal. But under the current, in the normal appeal process, I haven't been able to obtain subpoena power. But I want to make sure that's on the record, I'm asking for it. And that would also come to light that there was some nefarious issues. I don't know if you're all familiar with some of the corruption that's going on in the high desert. They found some shady deals in the neighboring cities that have similar impacts. Victorville has done some things similar. Palmdale, our mayor's being indicted. And now the city of Lancaster has some shady dealings back from 08 and 09. So it's not unusual to have this type of thing. But again, being able to prove it, I need subpoena power, and if you would grant it to me, I'd appreciate it. But long and short of it, I had a property that I couldn't sell, and that's where the loss carry forward comes from. And I'll rest my first 10 minutes on that.
Thank you. Thank you very much. Okay, for the department, you have 10 minutes. Please introduce yourself for the record.
Good afternoon, members of the board. My name is Bradley Craigle. I am here with Roman Johnston on behalf of the Franchise Tax Board. This matter raises one issue, whether appellants were entitled to report losses on the attempted sale of real property after the buyers defaulted on the sale and appellants remained the owners of the property. In 1994, appellants purchased property located in Lancaster, California. The property included 3 dwellings, a single-family residence, and 2 multi-housing dwellings. Appellants operated a business on the property called Miracle Star Women's Recovering Community. In addition, appellant Jeffrey Moffatt owns a business called Worldwide Legal Services Incorporated, a California S corporation. In March 2007, appellants and Worldwide entered into an agreement to sell the property to another couple for $1.8 million. During 2007, the buyers apparently paid appellants approximately $114,000 under that contract. According to appellants, the buyers then defaulted on the contract. For the tax year 2008, Worldwide, the S Corporation, reported an ordinary loss of $17.8 million based on the purported sale of that property. On their individual California return, appellants reported a pass-through loss of about $17.5 million. During audit, appellants informed the Franchise Tax Board that the loss of $17.8 million was a mistake. The loss should have been approximately $1.8 million. On the tax return, appellants claimed the loss based on a sale of business property. In their briefs, appellants have argued that they're entitled to claim the loss under Internal Revenue Code Section 165. In regard to the sale of business property, the Internal Revenue Code provides that a loss from the sale of business property occurs when the basis or cost of the property exceeds the amount realized from the sale. Case law provides that gain or loss on the value of property is taken into account for tax purposes only if and when the sale or loss is realized, that is, when it is tied to an event such as a sale or disposition of the property. Internal Revenue Code Section 165 provides that there shall be allowed as a deduction any loss sustained during the taxable year and not compensated for by insurance or otherwise. In order to be allowable as a deduction under Section 165, a loss must be evidenced by a closed and completed transaction. In determining the amount of a loss under Section 165, the fair market value of the property immediately before and immediately after the casualty must be ascertained by competent appraisal. Pursuant to Revenue and Taxation Code Section 1831, California conforms to the Internal Revenue Code provisions relating to gains and losses on the sale of property, and pursuant to Revenue and Taxation Code Section 1721, California conforms to Internal Revenue Code Section 165. In the present case, the evidence shows that appellants entered into a written agreement whereby they agreed to sell a parcel of real estate. The buyers defaulted on the purchase. There's no evidence that legal title ever transferred from the sellers to the buyers. The evidence indicates that appellants have owned the property from 1994 until the present time. That's in Exhibit A. The evidence indicates that appellants lived on the property from 1994 to 2007, briefly moved out after the attempted sale, and returned sometime in 2007. That's in Exhibit F, page 2. Appellants owned and possessed the property in 2008. They have failed to show that a sale was completed. Because there was no sale or disposition of the property, there was no loss on the sale of the property for tax purposes. Similarly, there was no loss under Section 165. Appellants continued to own the property. There was no closed and completed transaction. Appellants have not produced evidence demonstrating a casualty loss or a theft loss. There's no evidence of damage resulting from an occurrence under Section 165, and there's no evidence of an accident or some sudden or unexpected event for purposes of Section 165. For those reasons, the FTB requests that the Board sustain its determination. If you have any questions, I will answer them.
Thank you. Okay, you have 5 minutes, sir, on rebuttal.
Sure. Unfortunately, he's misreading how Kornfeld happens to modify this 165, and it involved, again, a lease that was breached. And I have this in my brief, my answer. I believe it's in page 6. And what they looked at was a long-term lease that was stopped for various reasons, and that was deemed allowable for a long-term loss. The fact that the individuals claimed that I was gone for a period of time. I think once that property was sold, I was entered into a 1-year lease, so I lived elsewhere. I think I moved back 2008, give or take, and presently I haven't lived on that property since maybe 2009. So the fact that his timing is a little bit off. His claiming of an unexpected event, when you have a government organization creating unconstitutional laws in a way to benefit some friends, I would say that's an unexpected event and should qualify. I should also say that it satisfies some government malfeasance that I'd like to also ask the court to direct an inquiry to, if you have such a ability to do so. Given that we had some interesting connections here, I might not have that granted. But if you couldn't have more of an unexpected event than to have a government create an unconstitutional series of law, not in my backyard, and my wife takes the position that being a black female, that the local power structure didn't want to see a black female with $1.8 million in her pocket. That's my wife's position. But my position is that they had they had millions of dollars tied up in a 3-way transaction, and moving me out of business and creating this was a way to maybe benefit some of their friends. You couldn't expect or have a more unexpected event than illegal activity, maybe for some friends, but nevertheless, illegal activity. So I think that in this situation, I satisfy the loss carry forward rules. And as clarification, it is a 1.8 as opposed to an 18 million. It was a heavy zero. So that's all I have. Do you have any questions for me?
We will bring it back now to the board. Members, do you have any questions?
Madam Chair, if I may, the taxpayers asked a couple of questions and regarding the board's subpoena power and jurisdictional questions. Bills can, just for the record, respond to those.
Bills, Mr. Eppolite. The board's subpoena powers that were raised and a couple other, what were they?
Jurisdictional issues.
Jurisdictional.
Over some investigation and something. And I could answer it, but I don't.
What was the jurisdictional question?
I don't believe we have jurisdiction over something going on. I mean, I know we don't, over a zoning or city issue.
That's correct. No.
Right, okay. And the next thing was, he wanted to know if we could use our subpoena powers, because then he could bring in, I believe the taxpayer thought he could bring in more evidence that would discount that it wasn't I guess, a rehabilitation facility.
That I wasn't impacted. So that was kind of...
That it wasn't impacted. I'm not sure what are the exact issues we're dealing with here today, once again?
Well, you're looking at a loss on the sale, a loss on the canceled sale of real property.
Right, and So subpoenaing something to show that,
We don't have the authority to subpoena under the circumstances.
I don't see
no,
what's,
we can subpoena for testimony that we need for hearing, as I understand it, at some point, but not for,
Well, where it's relevant, Ms. Harkey, is that, if I can show,
I mean, there'd have to be a showing of good, there'd have to be a showing of good cause for it.
well, let's hear from the board members some of the, have any questions? Does anybody have?
Sure, I'll ask a question.
Yes, please, Ms. Moffatt.
Okay, so, Mr. Moffatt,
Yes.
you reported the loss on your, is it S Corporation?
Yes.
And was the house, the title, the S Corporation on assessment records?
See, I thought we flipped the house into the corporation, so I believe that was the case. It was part of the business itself. So it was originally self-owned, but then it was put into an S corp.
But before you transferred it to your S Corp, it was your personal?
Exactly. Well,
property?
in zoning laws, when you have it's high-density residential. So you have a facility that could house maybe 40 people, and something, so did I happen to live in one of the rooms? Yes, I did. Did I happen to have 15 other drug addicts and people in treatment in one facility? Yes. I had another one that I had 13 or 14, and I had another one that I was working on a license for 6. So did I happen to personally live there? Yes, but I happened to manage all these, before we sold this, I was living on site, also doing management, yeah.
And did you own the house outright, or the?
It had a
property?
mortgage on it.
You had a mortgage on it. Did you take mortgage interest on your personal return?
Let's see. Originally, I did.
But then after you transferred it?
I think we switched it into the S corporation. I think we took the mortgage interest on the S corporation.
Okay, I don't have your tax return, so I can't tell what.
I think that's, as of '08, I think that's how it worked out.
Yes, thank you, Madam Chair. So it was in your name originally, and when it was in your name, you most likely claimed the mortgage interest deduction.
Well, I wouldn't be taking a business loss and a mortgage interest in the same year.
And then once it became in the S Corporation's name, then you just had treated it as regular business property and claimed the available deductions that a business can claim. So when, I lost my train of thought. To appellant, in your briefing, you referenced this Cornfield case.
Yes.
I would like for you to talk about the Cornfield case, and then I would like for the Franchise Tax Board to speak about that case, and I'd like to hear both opinions on whether it applies or it does not apply.
Okay. Well, here was a plane that was on a long-term lease option, similar to my property, and what they were looking in the Cornfield case is they were upgrading this plane from one dimension. It was going to be, I think it was taken from one service to be used for a gentleman's private business jet. And midway through there was a problem with and on my briefing, that where he ended up selling the plane to a company called Auteur. It's page 5 of my brief. And they placed it in the service, and later the lease was breached, and the one of the arguments was, well, gee, it wasn't a purchase, it was a lease that was breached. And as I get into the briefing, it was page 6, I'll show you what the conclusion. So we hold that the taxpayer had an honest profit objective in acquiring the BAC, or the BAC 111 aircraft, and that he placed the aircraft in service. The day he took delivery, and then he returned it to British Airways for completion of the Auteur lease. And in that situation, there was a taking of delivery, and I believe he only had it for a short period of time, and then there was a breach, and this loss was allowed to exist. It was amazing. And so this was if I remember right, there was no mandate that a purchase actually had taken place. The only real issue was there a lease? We have a lease in my situation, and was there a breach? And there was in both cases, and there was a loss carry forward. And
Okay, I was going to have the Franchise Tax Board talk about that case as well, but I've since changed my mind. I think it'd be more appropriate for appeals to speak on that case, since the taxpayer did cite it in their briefing, but it's not referenced under the applicable law section of our hearing summary. So is Cornfield applicable for this case? Is it controlling?
I'm going to have to look.
You're going to have to look? Okay, then I'll go back to the Franchise Tax Board. Can you guys speak on this case, please?
Yes. The Cornfield case involved a transaction that was involved the issue of whether or not a transaction was entered into for profit within the meaning of Internal Revenue Code Section 183. Section 183 provides that in the case of an activity engaged in by an individual or an S corporation, if such activity is not engaged in for profit, no deduction attributable to that activity shall be allowed under the code. So the activity involved in that case was the taxpayer's aircraft leasing activities, and essentially the court found that the taxpayer was engaged in the business for profit. So that's kind of the gist of that case. In this case, we're not questioning
right, that's what I was going to say. So in this
whether,
particular case, when he leased the property, lease option to buy the property to the third party,
right,
that is an activity that was entered in for profit, so any income or loss from the lease part of it is deductible, but any loss from the canceled sale when title did not transfer, I'm not seeing how the Cornfield case or RSC Section 183 applies. It seems to me that we have to go to RSC Section 165 and a closed and completed transaction analysis to see if there's a deductible loss.
correct.
I mean, it's just, okay. So it seems like we have two types of issues that we need to look at, and what's controlling for the issue before us is 165. Yes.
If you're asking me, I would say yes. I think there's more problems than that with respect to whether or not the activities of the city of Lancaster resulted in the loss, but
Right, but
there's
some other side as far as what the city did. I thought I read what the city did as far as changing the ordinance and the zoning, that took place before the appellant entered into the transaction with the third party. I may be mistaken, but I don't see how that's a casualty loss.
Well, that's
of
an
any sort,
unexpected.
under my understanding, under the code section. But that's why I just wanted to get more clarification on why you were citing Cornfield, and in my reading in Cornfield, it did not appear to apply either. But that's the only questions that I have at this time. Thank you, everyone.
Thank you. Okay, I have one. This is just replies to the casualty loss. For a casualty loss to be in effect, don't you have to show that the fair market value of the property decreased from before before and after the intervening act? Like that, your property value decreased because of that act?
Well, if it went from being worth $300 a square foot, 6,000 square feet, so it was worth commercial prices in 2007, and after that, it's now worth essentially, you're looking at going from a commercial price to maybe residential price, 100 or $100 or less. And right after the '08 crash, that property started being worth $50 a square foot. So from that, the fact that there was the person breached the agreement.
Did you have a refinance of this property for $1.9 million on September 5th, 2008?
Well, it wasn't a refinance. It's another subcorporation of mine.
Okay, and there was $1.9 million, it looks like you refinanced the property for $1.9 million.
No, it's a lien that's been placed on there. It's not.
A lien that was placed on.
Yeah. So there wasn't any cash out. Happens to be another corporation of mine.
Okay, so you put a lien on a property that wasn't worth $1.9 million, of $1.9 million to your other corporation.
I'm putting right now, I'm putting so as of, for estate planning purposes, my other corporation put a lien on that property. Right now, the property has been up for sale, I think it was up for sale last year for $700,000, and it didn't sell. So we know right now that I had a sale at 1.8, and I didn't sell it at $700,000.
Yes, Member Horton.
Thank you, Madam Chair. Another leading question. Whenever there is clarity in the law for me, it causes me to sort of ponder if the law has been clearly explained. So, of the appellant, was the property ultimately sold?
No, I still own it.
Still own the property?
Yeah, still own it, and still fighting with the city. When I have an agreement with the city that it's high-density residential, but what do you know, on their tax records, they show it as something else.
What income did you receive that you believe you should offset this loss against?
Or
what income did you receive, and then as a result of the actions of the governing body at the time, suffered a loss?
Well, I lost, and when you have
I understand the loss, and
yeah,
I think that has merit.
So I lost, $1.7 million?
What income did you receive to
what
offset
income I received
the loss against?
Was $100 and some odd thousand. I thought it was like $140,000. He said it was $115,000.
So you sold the property and received $100 and some thousand?
Yeah. And then I had to foreclose back on the property. And so I have this, I have a property at one point in time is worth 1.8. I have city interfering, breaching a contract. My understanding of the law is that I'm able to, that breached loss, that expectation that I should have had, I'm able to have as a law, it's a business loss, it should be a loss carry forward.
Yeah, I want to explore that because I didn't necessarily see that in the record. The respondent, is there evidence in the record that you've observed that the property was sold?
Well, there's the appellant's statement that they sold the property to this other couple, and there is an agreement in the record that calls itself a purchase agreement, I think. But a lot of the provisions in the agreement make it look like it's a lease agreement. It looks like it's a lease option to buy. And the buyers paid some amount in 2007, but then according to appellants quit paying they took the property back over. So, I mean, it's
Was it, maybe I have to go back and look at it. Could it be a continuing sale?
It's a lease option.
It's a lease option.
It looks like a lease option.
And you reported the lease income.
I did.
And it's your testimony that as a result of this act, you received, somehow entered into a lease, had a contract.
I entered into I'd say a purchase option, but it's a...
Purchase option.
Right.
A lease with an option to buy. Received income. Something happened. You lost money.
Yes,
That's what happened.
that's exactly it.
I don't necessarily see that.
I,
Pills was itching to say something.
Appellant has suffered an economic loss. That's not deductible for income tax purposes.
I know that.
we do understand that. Where I'm thinking this goes with me is that it was a lease option to buy, which always has a level of risk with it that doesn't get completed. There was not a sale. I do not see a deductible loss can be taken without the sale occurring. The casualty loss that is being claimed might be against the city of Lancaster, but as I understand, city legislative mandates are zoning, and I think that might be proof, but I don't know that I don't believe that shows a tax loss.
Well, I'd say that Ms. Harkey, the way that Cornfield case, having a lease option that had a loss, that loss was able to, given that it was for a business purpose, that loss was able to be seen as a loss carry forward.
This is real property, though. This is
Doesn't
real
matter.
property. I do believe it does, because your contract was not a leasing of a plane. Your contract was a lease option to buy that was never completed, and that's always a risk. You got some earnest money.
That's not what Cornfield, matter of fact, Cornfield went and exactly indicated that it didn't matter that it was a lease option, that there was in fact transfer, and it was for business purposes, was put in, and the real issue there was when it was breached. So if we look at, was it for business? Yes. Was it breached? Yes. The fact that both had a lease option, the case law doesn't say, gee, it matters if it's a British Airways jet or property.
Okay.
Madam Chair,
Since
I'm reading.
the sale was incomplete and legal title to the property never transferred, I don't believe there can be a realized loss. I think that's the point, and that's explained in Treasury Regulation Section 1.1001-1. A deductible loss cannot occur before a completed sale because until the sale occurs, there remains the possibility that the taxpayer may recover or recoup the adjusted basis of the property. Since there was never a sale, the property is still owned, I don't see that there was a loss. There may be a loss of mental value of the property, or what the zoning may have changed, but that's not a loss for sale of property.
Yeah, I kind of agree with the appellant's interpretation of Cornfield, but I don't agree that the facts are the same in this case. The facts seem to be different, and I do agree that it's a timing issue pursuant to Cornfield, but the timing issues aren't the same in this case.
Well, let me give you an example. Let me read you the page 6 that I have of my brief, and it covers there. In this situation, it's kind of similar because it was a $4.5 million purchase price, and they had So it wasn't fully completed. It was returned, and long and short of it says, at that time, so I'm reading on item 20, page 6 of my brief, midway through. At that time and until October 31st, 1969, the plane was under lease to Auteur International Airways. Taxpayer promptly returned the plane to BAC for the completion of the lease. BAC in turn reduced the plane 4.5 million purchase price by 50 grand. And what they ended up doing is, in the next paragraph, they ended up breaching this lease, and going page 7, it says, as a consequence, they did not complete the transaction with British Airways, defaulted on the installment purchase agreement. Eventually, British Aircraft sold the plane to Hong Kong for $3 million. And pursuant to a decree in London court, taxpayer forfeited his deposit but was released from the further liability. In this case, they were able to show that there was also a long-term, or a loss carry forward on this whole transaction. And that's where, although we're dealing with planes compared to properties, we're looking at a breached lease. And it was seen as, even though there was still outstanding money, title hadn't fully taken place. It didn't have to take place for that to be seen as a transaction allowing for a loss carry forward.
Members, do we have any more questions? I have a motion.
Move to take the matter under submission.
Is there a second? Second by Member Horton. Motion by Ms. Stowers, second by Member Horton to take the matter under submission. Thank you very much for your presentation. We will be voting later on tomorrow.
All right.
Thank you. Okay, we now are taking one case out of order. As I understand it, it is B14. Is that correct, Ms. Richmond?
Yes, ma'am, that's correct.
Okay, will you announce the next item, please?
Item B14, Victoria Joy Le Beau, please come forward.
Get out of here.
Okay. Just reading over the disclosures. Okay, thank you. Welcome to the State Board of Equalization. I believe our attorney will read a statement now.
I was waiting for, because of the change in the law, I wanted to ask the board members if they have received any written or oral communications on the matter before them that they suspect have not been provided to the other side, and to disclose those now.
Okay, I finally have a written statement from my staff rather than having to scroll ahead. So, in the matter of Victoria Joy Le Beau, to the best of my recollection, we hereby disclose that we have had communications with the appellant and with the tax department in the above referenced matter. My office discussed the issues presented in the briefing record with both the taxpayer and the department. We do not believe the law imposes a disclosure requirement prior to July 1, 2017 operative date of that provision of AB 102. However, we hereby satisfy our ex parte disclosure burden to the extent one exists.
I've not had any communication with the appellant or the department on this matter.
To the best of my knowledge, I've had no communications with, or my staff has had no communication with the Department, Appeals, or the appellant on this matter.
I have not had communication, written or verbal, with this taxpayer nor the department since July 1st, when I believe this law took effect, and I believe that the conversations that may or may not have taken place prior to July 1st are not applicable under the law.
Okay, and Ms. Victoria Le Beau contacted my office on June 28, 2017, and spoke with Joel Smith of my office. Ms. Le Beau shared that Charles Le Beau would represent her at the hearing. Ms. Le Beau also sent Mr. Smith an email on June 28, 2017. The email is part of the appeal record.
Thank you. I would ask Board Counsel if they have submitted any oral or written communication to the board members that is either in addition to or different than what has been described that has not been provided to the other party.
And not to my knowledge, we haven't.
And I would ask the appellants the same question, whether or not you've provided any oral or written communication to the board members that you can recall that are other than what has been described here that was not provided to the other party.
Not to our knowledge, no.
And then I would ask the board if they have any desire to respond to any of the communications that have been disclosed here.
So if all the information discussed ex parte in the briefing record is in the briefing record, we do not wish to respond today, but we reserve the right to respond after receipt of the final opinion on ex parte communication. If any information discussed ex parte is not in the briefing record, we reserve the right to request copies of all documents and written evidence of oral communications pending receipt of the final opinion on ex parte communication.
And then I would ask the appellants whether or not they have any wish to respond to any of the communications that have been disclosed right here, in addition to any statements that you might make.
No, we do not.
This isn't Mr. Epplin.
The issue before the board, good afternoon, Madam Chair, members of the board. The issue in this appeal is whether appellant has demonstrated error in the Franchise Tax Board's determination to deny her innocent spouse relief.
Thank you. All right. You, to the appellant, you have 10 minutes to present your case. Then we will turn to the FTB that will also get 10 minutes, and then you will have 5 minutes on rebuttal. Please introduce yourself for the record.
My name is Charles Le Beau, and I'll be the representative for Victoria Le Beau, and I'm also a witness in this case relative to documentation as to the postnuptial agreement and transmutation agreement, and also the pleadings that were submitted for the petition for legal separation, which was determined to be final by the Superior Court of San Diego. And so those documentation I can testify to. And if I may proceed, I would like to proceed. There is a case that we provided everyone that is on point, and it's the Ninth Circuit Court of Appeals case in 2013. It's Karen Marie Wilson versus Commissioner of the Internal Revenue Service. That case involved a couple that had some financial problems. The husband was engaged in some illegal activity. The wife didn't know about it, and they omitted from their tax returns a substantial amount of money. She claimed innocent spouse, and that was denied, and then she took the case to the tax court. The tax court agreed with her, and then there was an appeal to the Ninth Circuit Court of Appeals here in California, and the issue there was whether there could be additional evidence submitted beyond the tax court evidence or the administrative record, and they said that there could be additional documentation, and that's what this innocent spouse submitted and prevailed in the case. Like Victoria Le Beau, she didn't know anything involved in my activities when I was practicing law. I had all the financial records, the tax returns, and that at my office. I retained the services of CPA to do the tax returns. Unfortunately, the CPA, in preparing the tax returns, even though he knew that we had a postnuptial agreement and a transmutation agreement, had us do a joint return, which should have happened is I should have prepared the return myself, frankly. I fired the CPA, and in subsequent years, I did, in fact, prepare the returns as being married, filing separately. Prior to the taxes at issue in this case, I always paid for many, many years. We moved to California in 1978. We paid our taxes. I became very seriously ill, actually before 1995, but it was diagnosed in 1995 that I had congestive heart failure with myopathy, and I was going to go on the heart transplant list. Then in 2000 and 2001, I had numerous stomach surgeries and had to remove part of my stomach. So I was going through, while I was still practicing law, all these surgeries, over 30 since 1995. And so everything was kind of up in the air. We have a son, an adult son, who has autism. My wife hasn't worked since 1980, okay, at all. She has no income. She has Social Security now. I have Social Security, and I have a little bit of consulting income. I don't practice law anymore. I retired or resigned in 2006. I was, I'll call it a dictator. And that was kind of the way I grew up in my family. I put the tax returns in front of Victoria and just told her to sign them. She didn't look at them. She didn't ask questions about them. She just signed them. I then proceeded to file the returns. She didn't know what was in them. And, I mean, frankly, I think her position is, hey, I'm the housewife. I take care of the house. I take care of the adult son with the autism. I have more than enough on my plate. I'm relying on you. And we have this postnuptial agreement and transmutation agreement, Charles, that says you're liable for all debts, the mortgage on our house, all the taxes and things like that. Victoria had a separate bank account. I had a separate bank account. My law office had a separate bank account. When I started practicing, in effect, we transferred the ownership of the house in about 1989, 2 years after I started, into Victoria's name. I have deeds that I have as exhibits here that show since then the property has been in her name as her sole and separate property. There was 1 year when I was going into surgery where we set up this limited liability company for estate planning purposes, and for about a year or so that the property was in the name of that entity. But after I recovered from that surgery, that was sent back to Victoria and not in any entity, and that entity, in effect, was liquidated and dissolved. So it's been in her name. It's in her name now. Franchise Tax Board has filed liens for the taxes that I owe against her property. Some of the exhibits here show that her credit has been harmed by that. She has a poor credit. And I have attached the liens, showing the liens by the Franchise Tax Board as an exhibit here. When I became ill, Victoria tried to get a job, full-time, part-time, and she couldn't get a job because everything showed up as her not paying taxes, and so she was not employable. So she's been harmed. The difference, I think, in our case versus this Wilson case, by the way, this Wilson case followed an 11th Circuit Court of Appeals case, and And so it is not a unique case. That case was, if I could just refer to it quickly here, that case was Neal versus the Commissioner, and that was a 2009 case, 11th Circuit. Again, that was an innocent spouse on equitable grounds. That was an IRS tax case. But California law and the IRS provisions, as the board may know, on the innocent spouse, including the equitable relief, they parrot one another. And so we had a CPA doing the returns. In the Wilson case, they didn't get a CPA involved. In fact, Mrs. Wilson actually prepared and filed returns for prior years. And the issue was, well, since you did it in prior years, didn't you know the nature of the business, and therefore you should not qualify for innocent spouse? Well, she was separated, but hadn't gotten the divorce finalized. The divorce was finally finalized, and that's what she submitted as additional documentation. Like Victoria and Charles, myself, when we separated, in effect, in 2013, because of my health problems, because she's my caregiver, because she drives me, I don't drive, I live in a separate bedroom in the house, and she lives in a separate bedroom. We were separated. Like in this case, they were estranged, so they said. And we filed, like I say, in January of this year, a petition in San Diego Superior Court for legal separation, and that was granted in June 30th of this year because of the 6-month statutory requirement for divorce or legal separation. So Victoria didn't know what was going on, okay? And all that she did know is that we had in prior years paid taxes, so she assumed that we were paying taxes during the years in issue here. And we were paying the taxes. There was no underreporting of income, unlike Wilson, where this guy was a crook. I'm not and wasn't a crook. We were disallowed deductions that resulted in deficiencies because deductions were disallowed. And the California picked up some of what the IRS did. Now, there is a tax case, different years, but the issue is the same. That was before the tax court, and the tax court in that case is here, and it's signed. The Franchise Tax Board took the position we don't have a signed copy. We have a signed copy by the judge in that case where it said that Victoria is not liable for the taxes in the years, it was 2003 through about 2007, which are different years in here, but albeit the same issue, and that is, were the postnuptial agreement and the transmutation agreements, did they effectively transfer without fraud the property to Victoria as her sole and separate property? And the tax court in effect said yes, and the tax liability for those years it's mine, tax liability, not Victoria. That's a federal, as you know, U.S. tax court is a federal court. So that has been determined, and it's similar. If the years issued with the board now were present before the tax court, the court would rule similarly that I'm liable and Victoria isn't liable. She is an innocent spouse, truly innocent. There wasn't any physical abuse, but there's been emotional abuse because I was a very domineering person, AAA personality, workaholic, control freak, whatever you wanted to call me, that's what I was, frankly. She was emotionally, I'll say, abused. There's no doubt about it, frankly. She's very upset about this. I can tell you right now that in effect has been one of the reasons why we went through this legal separation. She could kick me out of the house right now. I don't own the house. There's no side verbal agreements or understanding where we've whispered in each other's ears that the transmutation and postnuptial agreements are not really the agreements. It's just something that was made up to get out of whatever. That's not true. I can tell you that Victoria and I were married on May 16th of this year. We've been married 47 years. Because of the way I had to grow up, I always believed in the family, the family, the family, the family. Do what you can to keep the family together, and that's what I've believed that I tried to do. And I've made mistakes, there's no doubt about it. Basically, that's all I have to say at this point. Thank you.
Thank you very much, Mr. Le Beau. Okay, to the department, please announce yourself for the record. You have 10 minutes.
Good afternoon, Chairwoman Harkey and members of the board. My name is Brad Catino. Sitting to my right is Marguerite Monnier, and to my left is Craig Scott, and together we represent Respondent Franchise Tax Board. Mrs. Le Beau is not entitled to innocent spouse relief for the 1994, 1995, and 1997 tax years. Mrs. Le Beau and her spouse, Mr. Le Beau, have been married since 1970. The Le Beaux assert that Mrs. Le Beau has not worked since 1980. Despite this fact, the couple has transferred the family house out of joint tenancy solely into Mrs. Le Beau's separate property. In June 1995, the couple filed their first in a series of bankruptcy petitions, all of which were eventually dismissed. In late 1997, the couple jointly filed their 1994 and 1995 tax returns and reported unpaid balances owed. In 1998, the couple again filed for bankruptcy, but again their case was dismissed. The couple jointly filed their 1997 tax return again in 1999, again reporting an unpaid balance owed. Subsequently, after receiving information from the IRS, respondent proposed a deficiency assessment for in 2001 against the couple that went final without protest. 2 years later, the couple executed a post-nuptial agreement. While executed in 2003, these agreements purport to be effective as of August 1989. Despite not working since 1980, the agreements list Mrs. Le Beau's separate property to include the couple's home, their automobiles, all accounts receivable, furniture, and equipment from her husband's law practice. On the other hand, the agreement saddles Mr. Le Beau with all household expenses and tax liabilities. In October 2015, Mrs. Le Beau filed a claim for innocent spouse relief, which led to this appeal. On her request and subsequent correspondence, Mrs. Le Beau lists that her and Mr. Le Beau reside in the same family house, with Mr. Le Beau paying the mortgage despite the property being in Mrs. Le Beau's separate property. In January 2017, Mrs. Le Beau filed for legal separation from Mr. Le Beau. In their declaration of the couple's property, Mrs. Le Beau lists as her separate property the couple's vehicles, household furniture, saving and checking accounts, while Mr. Le Beau is again responsible for all liabilities but has no listed assets. Based on these facts, Mrs. Le Beau is not entitled to innocent spouse relief. When a husband and wife file a joint return, they are joint and severally liable for the tax due. What this means is that each person who signs the joint return consents to be liable for the entire tax, penalties, and interest that arise from the return. It does not matter which taxpayer earned the income that gave rise to the deficiency liability. In this case, Mrs. Le Beau signed the joint tax returns for all tax years at issue, and thus is jointly and severally liable for the tax liability reported. A taxpayer can seek relief from liability that arises from a joint return by filing for innocent spouse relief. There are three forms of innocent spouse relief that are available: traditional, separate allocation, and equitable. Traditional and separate allocation relief are only available when the tax liability is based on additional tax assessed by respondent. In this case, respondent assessed deficiency for the 1995 tax year, and thus traditional and separate allocation relief are only available for that portion of the 1995 tax year liability that was a deficiency. For the self-assessed liability for the 1994, 1995, and 1997 tax years, the only form of relief available is equitable. There are two factors to grant traditional innocent spouse relief that appellant cannot establish: the knowledge and the inequitable factor. The knowledge factor considers whether appellant did not know or have reason to know at the time the return was signed that there was an understatement of tax. Mrs. Le Beau has not explained what she knew at the time the tax returns were signed, why she never reviewed the filed returns, what, if any, inquiries she made into the couple's finances. Further, there is no evidence that Mr. Le Beau was evasive or deceitful. Without more information from Mrs. Le Beau's state of mind at the time the tax returns were signed, the knowledge factor cannot be established. In addition, as I will explain in further detail, the evidence provided by appellant demonstrates that it is not equitable to hold her responsible for the 1995 tax deficiency. Accordingly, since Mrs. Le Beau cannot establish the knowledge and inequitable factors, she is not entitled to traditional innocent spouse relief. Mrs. Le Beau has also not shown that she is eligible for separate allocation relief. A required element is that at the time the innocent spouse claim is filed, the requesting spouse is no longer married to or is legally separated from the non-requesting spouse. In this case, Mrs. Le Beau filed her request for innocent spouse relief in October 2015. At the time the request was filed, Mrs. Le Beau was still married and not legally separated from Mr. Le Beau. Accordingly, appellant is ineligible for separate allocation relief for the 1995 tax deficiency. Appellant is also not entitled to equitable innocent spouse relief. Appellant cannot establish that the fraudulent scheme condition, a threshold condition required to be eligible for equitable innocent spouse relief. As stated earlier, the couple alleges that Mrs. Le Beau has not earned income since 1980. Yet the family house, automobiles, checking accounts, saving accounts, and accounts receivable from Mr. Le Beau's law practice are all considered Mrs. Le Beau's separate property. Meanwhile, Mr. Le Beau, the alleged breadwinner, has no discernible assets in his name and yet all of the family's liabilities. Further, the couple's post-nuptial agreement was executed in 2003 but purports to be effective as of August 1989. The couple has not explained the reason for these transfers or why the agreement was signed in 2003 but effective in 1989. Accordingly, Mrs. Le Beau has not shown that she is not part of a fraudulent scheme. However, if this board were to find that Mr. Le Beau does meet the threshold factors, the balancing factors still weigh against granting relief. As stated in your board's hearing summary, while most of the factors are neutral, the knowledge factor weighs against relief in showing that Mrs. Le Beau did not know or have reason to know that Mr. Le Beau would not pay the tax liabilities at issue. As stated earlier, the couple has lived together for 40-plus years. They have entered into complicated agreements together. They filed briefs and declarations on their behalf. Mrs. Le Beau has shared in the benefits from Mr. Le Beau's law firm, and at the time the returns were filed, they had jointly filed for bankruptcy together. Mr. and Mrs. Le Beau have been and continue to operate as a team. Accordingly, appellant should be denied innocent spouse relief, and respondent's action should be sustained. I'd be happy to address any questions or concerns the board may have. Thank you for your time.
May I respond, please?
Yes, you do have
Okay.
5 minutes on
yes.
to respond.
Yes.
Thank you.
The Wilson case, joint tax returns were filed, like in our case, okay? Unlike the Wilson case, I fired and was going to sue the CPA that prepared the joint returns. I was extremely angry. Unlike Wilson, after I discovered that, I started filing married separate. The Wilson case, the couple was not divorced when they filed or requested innocent spouse. They were still living together, allegedly estranged, okay? We have declarations under penalty of perjury from Victoria saying, in effect, and from myself as well, that she had no knowledge of the tax returns. She's not worked since 1980. I challenge the Franchise Tax Board to produce any W-2s, any 1099s, refuting the fact that Victoria has not worked since 1980. They can't produce them. They don't exist. I challenge them, okay? Part of my practice, frankly, involved so-called asset protection. It is not uncommon for somebody that is engaged in a profession to try to protect their assets from the claims, unwanted unbased lawsuits, okay? We never did this to avoid or evade taxes. We did this to protect our family home from litigation, okay? I had 2 clients that sued me, that were frivolous, that in part caused me to resign, okay? They haven't collected a dime, okay? And they can't collect a dime. The house is in her name and has been in her name. It's not a fraudulent scheme on anybody because we had no lawsuits, no taxes when it was transferred. We have certified copies of the deeds, 1989, showing that that's in her name. The fact that I was slow in doing the postnuptial agreement and transmutation because of illnesses, and we made it effective back to 1989, the reason is that the property was transferred in her name in 1989. That was always intended to be the time when the property would be in her name. That's proof that the property has been in her name since 1989. It's not a fiction. Certified copy of the deed in her name and other subsequent years are in here as exhibits. That's evidence. That's proof. That's not a verbal comments, okay? She could kick me out of the house today, and I couldn't sue her. I couldn't get back in. I don't own, okay? I don't own any cars. That's right, because the cars were purchased. And there was a reference to law office receivables being in Victoria's name. No, they were in my name, okay? All the law office income belonged to me, including receivables. That was mine. That was part of the deal, that she got the house and she never practiced. She couldn't have the receivables. She was not a lawyer. She couldn't have those legally, okay? Those were client receivables. She's not a lawyer. It's not unusual for people to do what we did, frankly, because we had a long-term marriage. We've had our ups and downs. We've had our differences. And right now, one of the big differences is this situation right here that has been like a sledgehammer over her head and over my adult son that's got autism. You know, he doesn't know, am I going to get kicked out of this house? You know, are they going to foreclose on the liens? We did the bankruptcies through the advice of an attorney by the name of James Kent, a bankruptcy attorney. He did those with the idea that we were trying to settle up with the IRS and the Franchise Tax Board. They weren't Chapter 7 bankruptcies, they were the reorganization, Chapter 13. We were trying to negotiate a settlement. We couldn't. We did offers in compromise. They wouldn't accept them, okay? They knew that they had the gold mine in our property in La Jolla, okay? That we bought for peanuts, okay? And it has appreciated greatly in value, okay? I'm sorry to be upset. I am upset. I've had a long day, as you folks have had, and I appreciate your taking us out of order. I'm not well. She's not well. And we really believe this Wilson case is right on point, and we believe that we have better facts than Wilson. Thank you.
Very much.
And we're here for equitable relief, no other kind of relief, just equitable innocent spouse relief. Thank you.
Thank you. Member Renner.
Yeah, just a quick question I'll start off with. I may come back. In regards to the prenuptial agreement.
Pardon me, it's a postnuptial agreement.
Postnuptial, excuse me. Yes, you're right. Executed in 1989?
Well, it was executed in April of 2003, and it was properly notarized that year. But it has an effective date in 1989. And the reason for that is it was tracking the most valuable asset that we own, the house, which was transferred in 1989 from the community property, our joint names.
So again, help me understand that. So it was executed, it was actually executed when?
2003.
2003.
Yeah. But in the documents, it has an effective date in the documents of 1989. And the reason, again, is to trace the fact that the property was put in her name in 1989. It has been effectively in her name since then. See, to me, family is everything.
Let me go to appeals. I guess I'm a post-nuptial agreement that was executed in 2003, but I guess trying to identify properties back to 1989, and the years of dispute here are in between those years.
Right.
It just why? Well, I'm not saying I don't want to. Is that odd?
I don't have any background in family law or estate planning. I couldn't say.
Okay. Yeah, I'm probably is an unfair question at that point. It just appears odd to me in the sense that it seems to be trying to capture tax events that took place in the past with a document that was executed after the tax events with property ownership prior to the tax events. That just seems odd to me.
If, in fact, the deed was done in 2003,
right,
I would agree with you. But the deed of the property was done in 1989, long before there were any tax issues, long before. The fact that the post-nuptial agreement, it was not backdated. In other words, we did not say that the post-nuptial agreement was in 1989. No. We say that we signed it in 2003, it was notarized in 2003, but we wanted an effective date in 89 because the cars, by the way,
let me follow up.
Were in her name that year, too.
So the original deed of the property in 1989 was just in her name?
Yes. Prior to that, prior to 1989, we bought the property in 1980.
But doesn't the fact that even if it wasn't in her name under California community property law, doesn't that still have exposure to you?
No.
Even though there was not a post-nuptial agreement entitling those issues?
No, because we have a document, the deed, that the property's in her name.
You didn't have to file. I thought there was a filing of some other paperwork that explicitly talks about sole ownership.
Well, we want...
That in order to protect, in order to I think, defend against the community property laws of the state.
Well, I wanted the post-nuptial agreement and transmutation agreement to kind of, how shall I say, put the frosting on the cake. But the fact the deed was in her name in 1989 as her sole and separate property and had been through, 90, 91, 92, and all those years, that protects that property. Now, true, other assets, if there were other assets that were in my name after 1989, they wouldn't be protected without the post-nuptial agreement. You're right. But at the same time that we transferred the property, the automobiles that we had were all put in her name. I've not owned an automobile since 1989. Okay? I challenge the Franchise Tax Board to show that I owned any assets after 1989. They can't produce any documentation or any witness to say that I owned anything because I didn't own anything. Like I say, I wanted to...
Why would I not believe that just is, and pardon my expression, a scheme to protect yourself from certain tax liabilities, even though you were the income earner during that period of time?
At what cost? She could walk away with that property. She could walk away.
At a gamble. at a gamble.
That's right.
Sure.
That's right. I mean, yeah, that's right. It's called hardball. Because when I would give advice on asset protection, we did family limited partnerships. We did, for the big exposure people, we did offshore trusts and corporations for estate planning and asset protection and other types of domestic asset protection. But the ultimate, I told the clients, is transfer your golden egg, so to speak, or eggs, to your wife. But you got to be.
Haven't I heard of spousal situations to where one spouse has endeavored to protect their property, but yet California community property laws enable the spouse to have access, even though there was an attempt to shield the assets?
No.
You think that the clarity there is just the deed, not property that's accumulated during the time of the marriage?
Yes. The deed will protect. Now, let me just say this, that without the postnuptial agreement and the transmutation agreement, if somebody transferred property in their name, whether it's a house or automobiles, or any appreciation in the community property, in the value, in other words, say the house, that appreciation is 50-50. Normally, that would be 50-50, okay? After 1989, for example, in our house, that'd be 50-50. But the postnuptial agreement says, oh, no, Charles, okay? And the legal separation by the San Diego Superior Court Family Law Department blessed the transmutation agreement and the postnuptial agreement and said, that's fine, we agree. These are her assets. Charles, you have all the liability and you have no assets. They blessed it, in effect. Okay? And it's here. That's an exhibit. The petition under penalty of perjury that was filed by Victoria, okay, to the family law court listed the assets as her assets. The final judgment, which is in here, decreed in effect that the house and the automobiles are her assets. I don't own anything, okay? Because my parents got divorced when I was 13 and we lost our house. And I said, when I have a family and I get married, I'll do almost anything, not illegal, but anything to protect my family from lawsuits and things like that, okay? And to keep the family together. Victoria and I, we had a lot of arguments. She didn't want me to leave a big secure corporation as in-house counsel to go and set up my own law office. She didn't want that. She didn't like it. She opposed it. She was very angry about it. When I became very ill, she wanted me to retire. And I said, I can't retire. We need the money. She says, you're going to kill yourself. Your doctors have told you to retire. Well, I finally did in 2006.
Thank you.
Yes. Sure, thank you.
To the appellant, I want to kind of start with the tax court decision, 2002, 4, 5, 6, and 7.
Yes.
You said that tell me what happened in those years?
I beg your pardon?
You're saying that the court determined that she did not owe anything for those years?
That's right. And we have that decision.
I have it in my
as an
exhibits. I just wanted to make sure that was your argument.
It's solid.
And you're saying it's the exact same. What type of filing status did you have for those years?
I beg your pardon?
How did you file your tax returns for those years? Married filings? Joint?
Those were joint tax returns.
So after 1997, you continued to file jointly?
We started filing, separately, I think I want to say 2007, 2008.
Okay, because I thought your testimony was when the CPA did the years before us and filed joint, and you realized that he filed a joint return, you let him go because you did not want to have a joint filing. You wanted to be married filing separate.
Yes.
So
I fired him, yes.
You fired the CPA
I was going to sue him, too.
When did you fire the CPA?
when we realized that joint returns were filed and we were going to have tax issues because of the joint returns.
So did you fire him in 1998, 1999?
I can't remember, frankly.
But subsequent to that, you still went and filed joint returns for 02, 04, 05, 06, 07?
06, I'm not sure about 07.
Franchise Tax Board, do you have your filing history in file?
We don't have it before the IRS, but I believe that that they did file joint returns for, I believe they didn't file in 03 and 04, but they filed in 97, didn't file until 2002 was the next year, and I believe it was joint.
They didn't file a return in 98 for okay.
Yes, and then the next return was, I believe, filed in 2002.
And it was a joint return?
I believe it was.
Okay. All right, I was wanting to get clarification on the filing styles, but my real question really goes to appeals. I want to make sure I have a clear understanding of the law as with respect to traditional, separate, and equitable. With respect to traditional and separate allocation, only the assessment, 1995 assessment, would be eligible for that relief?
Right.
But my understanding that it's time barred because the relief should have been requested within 2 years of the collection activity?
Right.
So then legally, traditional and separate, there's no way they could be granted traditional or separate because it's time barred.
Time barred, right.
With respect to equitable relief, it's my understanding that in order to be eligible for equitable relief, you have to be unmarried or legally separated.
Correct.
And it's my understanding that when the appellant wife first filed for relief, they was not legally separated. We now have documentation showing the legal separation effective for the 2017 time period.
Mm-hmm. Right. January, I think.
January was when you were filed, and it was granted June because you had to wait 6 months. Now that they are legally separated, does this board have the authority to grant equitable relief, or is it something that they would have to go back to the Franchise Tax Board and request relief as being legally separated? Because my understanding, all we can do is determine whether or not the Franchise Tax Board erred and not granting relief. And one reason why FTB did not grant equitable relief is because they were not legally separated.
Right, they didn't meet the threshold.
They didn't meet the threshold.
Well,
my question is, could we even look into this legal separation effective 2017?
Well, according to, and what the board has held in other appeals, the Wilson decision here, the court held that the tax court had de novo should apply a de novo standard of review, and therefore could look at evidence that wasn't in the administrative record when FTB, or in this case the IRS, reviewed the petition. So I suppose, this kind of stands for, or the board would have the authority to...
Evidence versus something that hadn't taken place yet, to me, that's different.
Yeah.
They weren't legally separated. They're not legally separated until June 2017.
Yeah, I agree. That's why I'm hedging a little bit.
I'm sorry to cut you off, but it seems to me that depending on how this board ruled, they could go back and ask for relief and say, look, we are now legally separated.
I think you're right. I think they could.
May I comment briefly?
Sure.
Equitable is equitable, frankly. I think the board has power to give equitable relief in this situation. Victoria and I had a lot of soul searching. We're Catholic. We were married in a Catholic church. We don't believe in divorce or legal separation. We were physically separated by way of not sharing the same bedroom. Same house, but not the same bedroom. We believe that the board, like in the tax court, has de novo ability to go back retroactively and give equitable relief for somebody who finally said, okay, we've got to do this legal separation. We don't want to do it, but we have to do it. We did it.
Okay, thank you, sir. Let me go to the Franchise Tax Board. lost my train of thought. Will you talk to me about whether or not they would be eligible for equitable relief, considering that they were not legally separated until June of this year? Also, talk to me regarding have they established the economic hardship? And third, and most importantly, this is right as it stands right now. This is a joint liability. Are you pursuing other collection action against other jointly liable persons? Mr. Le Beau?
I'm not privy to the
You can't discuss
specific,
that?
well, I just don't know the specific collection actions that FTB might be taking against Mr. Le Beau right now. I just am not competent to talk about that. But with respect to, there's one thing I did want to clarify, and it has to do with the statute of limitations to request either traditional or separate allocation relief, either B or C relief for the part of 1995 that's based on a deficiency assessment. There is in the statute a 2-year statute of limitations to request either of those forms of relief from the date FTB takes its first collection action against the requesting spouse. And this statute, as you know, mirrors the federal statute. At the federal level, and based on tax court decision that was first enunciated over 10 years ago, what the court held that 2-year period wouldn't start running unless the taxing authority gave notice to the requesting spouse of his or her right to request innocent spouse relief. And at the federal level, that notification is put on the collection documents now that the IRS issues. And the Internal Revenue Manual, which is the administration guidance document that the IRS uses and that we typically follow, says it has specific guidance in there that 2-year statute will not start running unless there is notification about requesting innocent spouse relief either on or mailed with the collection documents. FTB doesn't have that system in place, and therefore, in a manner that obviously benefits a requesting spouse, it's our position then that 2-year statute would not have started running with respect either to B or C relief for the part of the 1995 year that relates to the unpaid deficiency. So
that's an appellant's favor there.
Okay, so that, as I said, that would benefit Mrs. Le Beau. With respect to the marital status and equitable innocent spouse relief, marital status is simply one of the 7 enumerated balancing factors. And so the marital status simply would direct FTB to how to weigh that factor just in the mix of things FTB considers when determining whether it would be inequitable to hold a requesting spouse liable. So the fact that they were married when the request was filed and that they are now legally separated, the only difference there would be that for purposes, and it's kind of, it says that if you are no longer married, if you are divorced or if you're legally separated, that factor, that enumerated factor will weigh in favor of granting relief. However, there's a case, I think it's Syrium from the tax court, 10, 15 years ago, that says that if you are members of the same household, even if you live separately in that household, then you are still considered married, in which case that factor would weigh as neutral in the mix of considering the factors. So it's not a huge issue one way or another because FTB doesn't assign much weight to that factor in its view of all factors together to reach a determination that it is not inequitable to hold Mrs. Le Beau responsible for these joint debts. And there was a question, if I could...
economic hardship, what evidence do you have or do not have regarding economic hardship?
For economic hardship, as a requesting spouse, she has not claimed that it would create an economic hardship, but I would note that the documents that the Le Beaus filed recently with their legal separation papers include a schedule of assets and liabilities, and for example, her separate property residence is listed with a fair market value of $2 million and debt against it of just under $250,000. So what, 1.7, $1.8 million of equity there, jewelries of $20,000, vehicles, I can't remember the value, but at any rate, just kind of at first blush based on that, it wouldn't appear then that there would be economic hardship. And when you're analyzing economic hardship, and when you know that there's someone else who is sharing living expenses, then you have to look at the contribution that that person is making as well. And as Mr. Le Beau has indicated, he is making the mortgage payment, and he may be contributing to other household expenses as well. The bottom line is, the only information we have would support a determination that denying relief would not create an economic hardship. And finally, with respect, Mr. Runner, to your question about having a postnuptial agreement executed in 2003 and having an effective date of 1989, there is a specific family code section, it's Family Code 852, that says that a transmutation agreement is not effective unless it is in writing, and to this date, we do not have a fully executed copy of the transmutation agreement in the record. We have a copy of a postnuptial agreement, but not a copy of a transmutation agreement. It would also be our position that since it's not effective until it is in writing, that a statement in the document saying that it's effective any date before it is signed would not make it effective at any earlier date before you have full execution of the document. It's also, by statute, Family Code 853, not valid as to any third party with respect to real property unless it's been recorded. So, and those things I just say because you had asked some specific questions about it, but it was, the property, so far as we can tell, was transferred to Mrs. Le Beau as her separate property in 1989, but that in and of itself, that's just a fact, and it doesn't ultimately really make a difference, I don't think, on the innocent spouse determination, except to note that every month when Mr. Le Beau pays the mortgage, he's transferring what would be considered his separate property asset to a separate property asset, which is the equity in her separate property, and thereby, if relief is granted to her, depleting the assets available to FTB to collect solely against him. So every month, her separate property is increasing because he has the liability and she has the asset to which that liability attaches.
May I respond,
Can I
please?
follow up on the?
Yeah,
Okay.
just a minute. Are you through?
Yeah, I give the floor to Mr.
I would like to let him respond to what was just said. I think it just keeps it clear.
Okay, go ahead.
We have, as exhibits, fully executed postnuptial and transmutation agreements. The family law court would not have completed the legal separation with those documents attached and referenced in the petition as being exhibits if they weren't fully executed. They're fully executed. They have been recognized as legally valid and enforceable, therefore, by the family law courts. The Franchise Tax Board cannot circumvent or override a San Diego Superior Court determination that the legal separation validated the separate property of Victoria. I am obligated. I could be sued by Victoria if I didn't pay the mortgage. I am named only on the mortgage. Victoria's not named. She's never been named on the mortgage. I'm only named. In the transmutation agreement and the postnuptial agreement, it says that I am legally obligated. If I didn't pay the mortgage, she could sue me. And as far as economic hardship, with her bad credit and my bad credit, we couldn't rent an apartment. We could not rent an apartment. Our son asked if we could co-sign for him on renting an apartment for him. We couldn't co-sign. Our credit, and their credit report is attached as an exhibit, is so bad, if we lost, or she lost, the house, we couldn't rent an apartment. Not a good apartment, maybe a slum landlord. We couldn't because our credit is bad. And we've got tax liens, okay? So there's economic hardship. In fact, I'll be honest with you, okay? I wish Victoria could sue the Franchise Tax Board for putting a lien on her sole and separate property for all these years, destroying her credit, destroying her ability to get a job. She has been harmed, and she will be further harmed if this matter isn't resolved in her favor. She will be harmed, and our son will be harmed.
Go
Thank
ahead,
you.
Mr. Runner.
Just to clarify, I think you actually answered my question. Then the mortgage is in whose name?
Only in my name.
And that mortgage was, how old is that mortgage?
Well, we bought the property in 1980. We used Crocker Bank then.
Is the mortgage from the original purchase?
Well,
Or is it a refinance?
Crocker Bank went through an acquisition.
No,
then
but
we
it-
were with
but it's the
security.
mortgage.
It's the original
It's always
mortgage.
been in my name.
Is it the original mortgage?
Well, it is the original mortgage that's been assumed by virtue of bank acquisitions,
Okay, but it
yes.
is the original mortgage?
Yes.
At that point, you were the only one qualifying for the mortgage?
Well, I don't know if I want to say qualified, but I was the only one that went on the mortgage because I was the only one working. She had
Okay.
no income.
And in that mortgage, you identified yourself as you qualify as owner occupied?
Yes, at the time, in 1980, we had, the property was in our name as joint and several and community property.
You were the mortgagee.
Yes.
Okay.
Yeah, okay, thank you.
Just one follow-up on this transmission agreement that the Franchise Tax Board said was not fully executed, and I saw that you guys were very upset, and you referenced your stacks of exhibits saying it's in there. I believe what FTB is saying is that the signature seems to be inadequate.
Which exhibit
I have
is
a
it?
V and then I have a bunch of squiggly lines. I don't have a complete signature.
I can respond to that. What happened is because of, these documents were kept at my law office, and because I closed down my law office, I misplaced the original transmutation of postnuptial, and these are copies, and they're not good copies, okay? I will certainly, say that. But that's her signature, it's my signature. They're not good copies, okay? And it was notarized. I mean, you'll see the notary on those signature pages, and the notary is the same date as we signed, which I believe was April 23 of 2003. And I will tell you that that issue came up with the family law court, and it was explained to them. And the family law court said, fine, we find that it was fully executed, it's legal, et cetera, et cetera. But that was briefly discussed in the family law court in June 30th of this year when we got it finalized. We appeared in court, Victoria and I.
Okay, I understand what you're saying, sir. Thank you. Okay. But Franchise Tax Board, is that why you were saying it was not fully executed?
Well, right. What we're saying, the reason that we say it's not fully executed is that on the signature page, there is a copy of what appears to be somebody's signature and a handwritten date, and above Mr. Le Beau's name, and above the line for Mrs. Le Beau's name, there are some symbols and a capital V, and same thing on the dated line. And when you look on the notary page, it's the same thing. The dates that the notary would note, and the notary's signature, and the full stamp are all missing from the notary page. It has for what I would call gibberish. I mean, it's some letters and symbols, but it's not anything that is readily discernible as a date or a name.
Okay, can I turn to it for a minute, please?
It would be from FTB's opening brief, Exhibit N,
Yeah, I
pages
know.
36 and 36 and 37.
Okay. Let me just say that on page 14, Victoria and my signature appear on April 22, 2003. Okay? On page 14. Okay? And they were notarized by, I forget her name, Elaine, I can't read her last name, on that same date. Okay? The transmutation agreement was done on the same date as the post-nuptial agreement. Those documents were drafted, signed, notarized on the same date. Okay? So. There's no fraud here, okay? To the contrary, okay? Somebody might want to examine my head and say, why did you do this? Because of the way I grew up and my family fell apart, and I was the oldest and had to work full-time and go to school full-time. I put my family ahead of everything, and I still do. Family is so important to me.
Thank you, sir.
Family and education are the keys. Without the family, without the education, you go nowhere.
All right, thank you, sir. Thank you, Franchise Tax Board.
Thank you. I have a question. I heard the Franchise Tax Board say something about the 1995, when the deficiency was noted, the large chunk of this is from 1995, and we're claiming, or it says in here, that the statute of limitations ran out before they filed the appeal for that. Otherwise, it would have qualified. So will you go back and explain that to me?
Could I comment briefly? I believe that I forget the young lady's name, but she has explained the situation there. We do qualify for 1995 because the statute of limitation didn't run for innocent spouse in 1995 because of the date of the notices. And the fact that the Franchise Tax Board does not have, doesn't have a notice like the IRS does.
Well, that's the point I'd like to hear again. That's what I'm trying to understand.
Okay.
Sure. In sum, the 2-year statute of limitations that the statute says would start running when FTB issues its collection notices based on federal litigation with the IRS and subsequent policy decisions by the IRS, that 2-year period doesn't start running until the collection notices, either on them or, in another paper in the envelope, advise the taxpayer about the ability to request innocent spouse relief. And since FTB's collection notices don't contain that information printed on them, and it's not in the envelope as an additional piece of paper, it is FTB's position that that 2-year statute of limitations in which to request relief under either B or C, traditional or relief by separate allocation, would not yet have started running. What that means as a practical matter in this case is that FTB does consider Mrs. Le Beau's request for traditional relief and/or relief by separate allocation for the portion of the 1995 liability that's attributable to the deficiency assessment, to that NPA. It considers it to be timely so that she may be considered for those forms of relief. It's our position she doesn't qualify for relief under either B or C, but we believe that it was timely so that she may be considered for it.
Okay, so what I'm hearing is that it would be possible for this board to grant the 1995 year because the clock has not run out.
The 1995 year, the unpaid tax has 2 components. It has a component that was self-assessed and unpaid, and with respect to that component, a taxpayer may be considered only for equitable innocent spouse relief, which is the F relief, but for the portion of the 95 tax year that is attributable to the deficiency assessment, that NPA liability, that part may be considered for either traditional or separate allocation relief. And then F is for, you can be considered for anything where you can't get relief under B or C. So if we found she doesn't qualify under B or C for that deficiency portion, then that could also be considered for relief under F.
Okay, I guess I need appeals to clarify. Then I'm understanding, but I just want to be sure I'm really clear. And for some reason, I can't get to my...
May I briefly comment?
No, not right now, please. Okay, so appeals, what I'm hearing is that it is possible for equitable spouse relief under...
F, subdivision F.
Yeah, under all the other reasons except equitable, and so he said, okay, so FTB's lien was in essence kind of improper because they assumed the 1995 deficiency was final even though the assessment or the notice period was still open.
Right, they didn't have a note. I don't know that that was in anybody's mind, but, I mean, it was proper in
It
that.
probably wasn't anybody's mind, but I think it's factually correct that the lien on the property is improper.
That's correct.
It's
I guess-
improper because the FTB assumed that the 1995 deficiency was final, even though it was not.
That's correct.
Because they had to be noticed.
That's
And they were not, she was not noticed of equitable, of innocent spouse relief that she could have taken, and that is the law that they have to notify her at that time, and FTB did not.
I'm sorry, Miss, I think you're getting the two rules, excuse me, Madam Chair, but I think you're getting the two rules confused. For the 1995 assessment that went final because they did not file a protest, that's a final liability.
No, but she's got,
Right, let me finish. So FTB had the right, it was a joint and several liability, and FTB filed a lien against the property, which I understand is in the wife's name only. Based on, unless we decided that she's not jointly liable for that tax debt, it was filed correctly.
Well,
but as far as the timeliness of the request for innocent spouse relief, FTB is saying that there is no statute of limitation concerns here because their collection notice did not give the taxpayer notification to request relief. So the 2-year rule does not apply here. They have the ability to request, they request relief timely.
Okay.
The question is, do they qualify?
Okay, but what I'm getting from my FTB counsel, my personal one, is that the lien was improper because FTB assumed the 1995 deficiency was final, even though the statute of limitations was still open.
That's correct.
That's the point I'm trying to make, and I do believe that is an accurate statement of the fact, and that's what I heard. Although you're shaking your head now, I wrote it down. And I'm here, I heard it twice, that's why I asked you to repeat it a second time, because I wanted to hear this. And so I do believe the statute of limitations was still out when the lien was filed.
Could I please comment?
Sure, go ahead.
Because you're absolutely right. And that's why I believe that Victoria, technically, on that basis alone, as a claim against the Franchise Tax Board because they improperly liened her property. Not only that, but I believe that at least on constructive notice, the Franchise Tax Board was on notice that the property has been in her name since 1989. And therefore, they should have been on inquiry notice at least. What's going on here? Should we lien property that appears only in her name? Should we question the taxpayers and find out what the heck's going on here? Can we legally lien property that's only in her name even though joint returns were filed? And I believe that certainly for 1995 they could not.
I tend to believe that too, and that's the advice that I'm getting, and that's what I heard it the first time, then I asked you again, you repeated what I thought I heard, I was asking appeals, and then my own FTB person says, that's the deal. So I thought I heard you once, and I heard you twice, I heard it here, and then it kind of got retracted, but I'm on very good advice that, you know, the statute of limitations was still open when the lien was placed.
Right.
And so I do have a problem. I don't have a problem with 94 and 97. I do have a problem with 1995.
That's the big issue.
I think that I could make a equitable relief for her, but I don't think I have to make an equitable relief. I think I can go back to the statute of limitations wasn't met and the lien's improper. So I think we can do any kind of relief that we choose. I was not going into this case at all thinking I was going to even be thinking this way. It's only the testimony that I got at this hearing from the FTB that got me wondering what was really going on here. And I've had it confirmed that it was, if the statute of limitations is still open and you place the lien, then you've placed an improper lien. So
One
that's...
follow-up question on that, Madam Chair, if you don't mind?
Sure, no
So
problem.
you're saying, can someone please explain to me, because obviously I'm confused, what statute are we referring to that says that they placed the lien improperly because the statute of limitation was open?
The IRS notices advise the taxpayer about the liability to, or the ability to claim innocent spouse relief. FTB does not do that, has not been doing that. And so FTB has not really legally issued a notice proper in compliance with the law.
To the franchise tax board, is that what you're saying? That because your collection notice does not inform a taxpayer about innocent spouse relief, therefore you have an invalid lien?
I apologize if I was not clear before. The only effect of not including information about innocent spouse relief with any collection notice is that it doesn't start the 2-year time period to request innocent spouse relief. It has nothing
It's
to
not
do
final.
with the
It's not
collection action.
Okay, but
Could I comment?
the lien was placed.
It's not final. They cannot place a lien until it's final. And in 1995, it was not final.
Franchise tax board, did you have a final tax liability for the 1995 tax year?
Yes.
Why?
It was final because we issued an NPA in 2001, and it went final without protest.
Thank you.
Can I ask appeals to weigh in on this discussion?
I agree with FTB, it was final.
The
They don't
tax-
protest an
tax was
NPA.
final,
Just
but
let me,
with the
let
lien.
let him finish, go ahead.
Okay, yeah, if a notice of proposed assessment is issued and there's no timely protest filed, it goes final. What Ms. Harkey is referring to or focused on is just what Ms. Monnier said. And this is not in the law. FTB isn't required to put a notice of right to request innocent spouse relief, but they've decided to follow IRS practice. But that doesn't invalidate doesn't affect the finality of the assessment.
It may affect whether you can attach the house or not.
I've never heard that before, actually.
Well, I heard it twice
you.
today, and I
I've
heard
heard
it again, so
And I know.
that's 3 times. Okay. Are there any more questions? No more
Madam
questions?
Chair, just for clarification here, so the 1995 can be considered for traditional and separate allocations?
Well, part of it can.
Part of it can? What
Right.
part?
Well, the part that's attributable to that NPA liability, I don't have a dollar figure for you. All I know is that when they filed their 1995 return late,
Jointly.
the joint return was filed in, I think, 1997, so it was filed about a year late, and they self-assessed a liability, and they didn't pay it. So FTB, of course, was taking collection action, and I just don't remember offhand how much, if any, we may have collected, so I don't know by the time, several years later, we issued the NPA for the 95 tax year.
So given the testimony of the appellant relative to their separation, Is it possible to have that period in time considered?
The deficiency part, as I
For
understand.
separate allocation,
Mm-hmm.
it depends on when the filing of the innocent spouse request happened. In this case, because it was done in October 2015, while the couple was still married and not legally separated, they do not meet one of the requirements for separate allocation relief.
You just said that didn't matter. I heard up here that was only one factor.
For equitable relief, it's one factor, so that's under F. Separate allocation relief is under C, 18533C, and one of the factors for that one, and it's an AND test, not a balancing test.
So, aside from the form over substance, given this body believes that there is grounds for separation based on the testimony, how can I frame this? Without them having to go back and file and provide, under the traditional, provide evidence. Madam Chair, let me process this. Let me take a look at the law myself again, just one more time. Let me read this.
Okay. I think it's obvious in my mind there's been some errors and some omissions, and so I would think some relief is warranted. I did not come into this hearing at all to grant it due to the marriage, divorce, the community property aspect of income, all those things. But the lien and the issue that there was a deficiency assessment that occurred. There was some self-assessed and unpaid, but the deficiency assessment, I'd imagine, I'm just assuming is a pretty good chunk, and that the lien was placed.
I'm showing the deficiency of about
Notice,
$57,940 based on the hearing summary.
Is that for 1995?
Yes, ma'am.
How much is it?
$57,940.
Okay, and there would be,
The rest of it is.
there would be interest and penalties
Interest
on
and
that?
penalties and post-amnesty penalty, which was part of the self-assessed because it was unpaid liability, and not because it was a.
Okay, I would think that would,
The post-amnesty penalty goes not just because of a post assessment, but back then, when any taxpayer had an unpaid liability during the amnesty period and did not pay that liability, the amnesty penalty was imposed
right,
on all.
right. And there's a problem, and the lien is a problem.
I really would appreciate if we do take this matter on a submission, if our appeals division could do some research with respect to this lien matter, if the lien was issued in error.
Okay.
Mm-hmm.
I think that's a big problem. I think with the statute of limitations still open, with the lien was issued, I can imagine, I know what liens can do to a person. I went through a long litigation where liens were slapped on, and I had to get them all removed, and it's not a fun thing. It's not inexpensive, and when they're erroneous, there's very little you can do except get them removed. It's a nightmare, to be honest.
Yes.
So if you could do that research to discuss when the Franchise Tax Board may impose a lien, what's their procedure, was this particular lien imposed in error?
Mm-hmm.
And if it was, then then it should be withdrawn with the notification that was imposed in error, and that would kind of reinstate your credit if it was done in error.
Yeah,
But I
think
appreciate
it's
that
more
research
to do
for
with the
tomorrow's
statute of
vote.
limitations that was still open when it was.
Yeah,
lien.
speak on that too, because I statute of limitation with respect to imposing the lien statute of limitation with respect to allowing them to file for equitable relief. I think we're talking about two separate statutes here.
Yeah, we are. And I would, just for the record, I would like my counsel to please do some research on that before tomorrow.
Madam Chair, question of the appellant. I know you testified to this, and my apologies for being redundant, but I couldn't find it in my notes here. In 1995, I believe you testified that you had separated, and you were living in separate rooms and...
No, pardon me, that was 2013 is when we, in effect, physically separated.
So in 1995, you were...
We were together.
You were together.
You know, I had serious heart problems. I was going to go on the heart transplant list.
We had to file for bankruptcies twice.
Yes.
Came out of them.
Well, that was an advice of counsel, bankruptcy counsel, to try to get the Franchise Tax Board and the IRS to negotiate a settlement. They wouldn't.
All right,
for no amount of money. In effect, they said, no, we got your house. We want everything.
Okay,
thank
you.
Thank you.
Presuming that they were wrong, there's still need to meet certain conditions in order to have the innocent spouse relief.
Yeah,
Statute was still running.
Again, if I may say, the Wilson case didn't get into the issue of allocation or separate. The whole thing was equitable relief. And they found that there was sufficient reason to grant equitable relief because of the innocent spouse, and that's facts and circumstances. And if you haven't had a chance to read that case, that is an excellent case. And I believe, again, our facts are better than those facts.
Okay.
Thank you.
Thank you. Do I
Very
have
much
a motion
appreciate
to
all your
take this
time.
under submission?
Move to take the matter under submission.
Do I have a second?
Second.
I have a second from Member Runner. Such will be the order. Thank you for coming before us, and we will be voting on this, we hope, tomorrow.
And again, Victoria, and I very appreciate all the time that you've spent and the fact that you've taken us out of order. Thank you very, very much.
Thank you. Safe travels.
Thank you.
Thank you.
Okay, Ms. Richmond, our next item.
Item B5A and B5B has waived appearance, so our next item is B9. Dmitry Beinus and Larisa Beinus, please come forward.
Thank you. What'd you say? Where?
B9, I think.
B9.
Okay. I didn't hear her. Okay, statement, counsel.
With the change in the law, I want to ask the board members if they have received any communications from either party in this matter that was not provided to the other side, or they suspect was not provided to the other side, that they want to disclose at this point to the best of their ability.
Not to my knowledge.
I have not.
Okay, I'll read mine. On this particular matter, which is item B9 of our hearing date, to the best of my recollection, we hereby disclose that we have had communications with the appellant and with the tax department in the above referenced matter. My office discussed the issues presented in the briefing record with both the taxpayer and the department. We do not believe the law imposes disclosure requirement prior to the July 1, 2017 operative date of the provisions of AB 102. However, we hereby satisfy our ex parte disclosure burden to the extent one exists.
I have not had communication, oral or written, with this taxpayer nor the department since July 1st, when I believe the law took effect. and I believe my conversations that may or may not have taken place prior to July 1st are not applicable under the law.
And I don't believe we have had any contact with the taxpayers rep, or the franchise tax board on this issue, myself or my staff.
I would ask the board whether or not they've submitted any communication, oral or written, to the board members other than what has been disclosed, that they would help the board out if
To the best of my knowledge, we have not.
I would ask the appellant the same question, whether or not he knows if there have been any disclosures that he has made, either oral or written, to the board members that are in addition to or other than what has been disclosed here.
No, there has not.
Counsel, if you have, you're requesting any opportunity to respond to any communications that have been disclosed.
If all information discussed ex parte is in the briefing record, we do not wish to respond today, but we reserve the right to respond after receipt of the final opinion on ex parte communications. If information discussed ex parte is not in the briefing record, we reserve the right to request copies of all documents and written evidence of oral communications pending receipt of the final opinion on ex parte communications.
I would ask the appellant the same question, if you have any comment as to any communications that have been disclosed here.
No.
Thank you.
Okay. Please introduce the items.
Ambrose.
Mr. Ambrose, sorry.
The issue in this appeal is whether appellants have demonstrated they're entitled to a refund of the underpayment of estimated tax penalty.
Thank you very much. Okay, to the appellant, you have 10 minutes to make your presentation. Then we will turn to the FTB, who will also have 10 minutes, and then we'll come back to you for a 5-minute rebuttal. So please introduce yourself for the record and begin.
Madam Chair and members of the board, good evening. My name is Carl Hebler. I'm a CPA, and I'm representing taxpayers Dmitry and Larisa Beinus. And I prepare their tax returns, and we'd like to explain the history around their request for the refund. There's a penalty that was assessed for underpayment of their 2015 taxes. And probably the easiest way to help you explain this is if you could just look at this one handout that I've given you. It's underneath the cover page. It's a 3-year outline of their taxes with the circles A, B, and C on it. And I'll just briefly go through that just to help you understand what happened. The taxpayer, Mr. Beinus, is a owner of a retail outlet store, retail stores in California. He started it in 2007 or 8, and with his own money, and has built it up, and he's starting to unwind it now that he's retiring. He turned 62 in 2014, and we had, he basically has an internal accountant, and I do the filing of the tax returns. In 2013, there were payments made according to what we call an estimated tax payment schedule. You're familiar with these. These conform to the 90% rule, and they meticulously follow them, and I use those numbers to report it on their tax return. In short, there was an overpayment on the taxpayer's 2013 tax return. Coincidentally, they had to amend it because we found out they owed more tax, and so we amended it in 2014 to pick up the extra income. Still had an overpayment. The little lines that you might see here, starting with on the right column B, we applied a $54,000 overpayment from 2014 based on the 2014 tax return. That tax return included, if you look at the little circle C, an overpayment of $23,000 from the 2013 tax return. Unknowns to the taxpayer or myself, the 2013 payments of $156,000, $220,000, $165,000, of totaling $540,000 in 2013 were incorrect. There was the person that wrote his personal accountant short paid that last payment by $30,000. We're not disputing the tax, we're not disputing anything really. What I'm trying to do here tonight is to provide you a context of why there was a reasonable cause, there was no willful neglect or intention to underpay, and we had just always been in an overpay position, giving the Franchise Tax Board the overpayments and then evening it up the next year. In the last year, in 2015, as he started to wind down his business, they paid less, and he ended up owing more. They owed $104,000, and that was paid off. And then the Franchise Tax Board issued a notice of deficiency for $24,000, which was traced all the way back to that underpayment from 2013. The position of the taxpayer is he pays, $500,000, $400,000 a year in taxes. He's a good taxpayer, very compliant, files electronically, pays electronically, doesn't miss a day, and he feels that he relied on me or his internal accountant or someone that he was not aware that he was carrying a shortfall balance the whole period, to the point where his 2015 tax return was short by $24,000. When the Franchise Tax Board issued the notice, he paid it right away, so everything's been paid. Our request tonight is to request an abatement of that penalty under reasonable cause, and we track it to the Internal Revenue Code's umbrella of reasonable cause, whereas there was no willful neglect, there was no purposeful underpayment, and that there was a reason behind it where he relied on an outside taxpayer. And basically, that's the position. And then secondly, one of the exceptions that the FTB may or may not apply is the IRS has a rule called first-time abatement. You probably are aware of it. First-time abatement is basically a forgiveness of underpayment penalties or any other kind of penalties that were based on reasonable cause, and this allows the tax agency to resolve and move forward claims quicker and not clog up the courts and the appeals, and then it puts the taxpayer on notice to be a good, diligent taxpayer going forward. And that only applies if they have a history of compliance and they're not everything's filed, which is the same situation here. Taxpayers paid in compliance, never any issues, and the first-time abatement may apply, may be extended here. And then the only other point I'd like to get out at this point is that one of the mitigating points of this tax year, 2015, that the reasonable cause may apply if a taxpayer is 62 and retired. And in 2014, Mr. Beinus, in 2015, in 2014 he turned 62, so in 2015 he was 63, already retiring. He didn't get these notices and was able to start winding down his business. And in fact, in 2016, which isn't part of the context here, but just to continue the position that he is retiring, his income went down about $1.5 million in 2016 as he's closing his stores and made the decision to retire. It's a K-1 income. He's not actively working, doesn't get a W-2. He has professional managers handle his stores, so he wasn't. His wife has been retired, doesn't work, so they may qualify for that exception as well. Thank you very much.
Thank you. All right, clock is still ticking, but FTB, you have 10 minutes. Please introduce yourself for the record.
Good evening, Chairwoman Harkey and members of the board. My name is Maria Brosterhouse, and with me is Natasha Page, and we represent the Franchise Tax Board in this matter. The issue in this case is whether appellants have demonstrated they are entitled to a refund of the estimated tax penalty for the 2015 tax year. Taxpayers who receive income not subject to withholding are required to make quarterly estimated tax payments. When taxpayers do not make payments accordingly, a penalty is imposed. This penalty is essentially equal to the interest that would have accrued had the required estimated payment been made on time. Appellants were required to make estimated tax payments during 2013, 2014, and 2015. For both the 2013 and 2014 years, appellants' reported estimated payments overstated the amounts actually received by FTB. As a result, appellants believed they had a remaining overpayment available for 2015. For 2015, appellants reported approximately $370,000 in estimated payments. Yet FTB records reflected the receipt of only about $346,000. This resulted in an underpayment of about $24,000. Due to this underpayment, the estimated tax penalty was imposed. Appellants have argued they have demonstrated reasonable cause for the abatement of the penalty because they relied on their CPA to properly calculate the amounts due. They further argue their CPA was unaware of adjustments FTB made to their account, which led to the underpayment. There is not a reasonable cause exception to this penalty. The code does allow for a waiver of the penalty in extremely limited circumstances. The first is by reason of casualty, disaster, or other unusual circumstances by which the imposition of the penalty would be against equity or good conscience. The second is that the underpayment is due to reasonable cause, and either the taxpayer retired after attaining the age of 62, or the taxpayer has been disabled during the year in which the estimated tax payments were required. Appellants have not provided the facts to support either situation in total. Additionally, as to the first-time abate penalty, the FTB does not follow federal and does not have a first-time abate penalty rule. Additionally, FTB informed appellants of this discrepancy in 4 separate notices dated between June 6, 2014 and February 9, 2016, providing them ample notice of the difference between what they reported and what FTB received. As such, appellants have not demonstrated they're entitled to a refund of the estimated tax penalty for 2015, and FTB's claim denial should be sustained. Thank you, and I'm happy to take your questions.
Okay, you have 5 minutes on rebuttal, sir.
Okay, the age of the taxpayer may not have been in the original response. I've attached, on the last page of the exhibit, there's out of my records, information worksheet. It tells you their dates of birth. Just for the record, they were born in '52. He also, again, just reiterating that the retirement, since he's an owner, he's not an active store worker. He doesn't clock in or clock out, but it is his company. He owns it, so he looks at it, but he's not actively working there every day. So I'd just like to put those matters further out, because that could be, in my opinion, a very strong reason why this $1,800 penalty could be abated, and then putting in the context that he's been paying substantial tax on time every quarter, and as we explained earlier, this missing amount just kept tracking, and we were always in an overpayment position, and we'd like to just make you aware of that. Thank you.
Members.
I have a question.
Ms. Mott.
I've questioned the Franchise Tax Board. When it says retired, it's very generic, and I didn't pull up the regulations. So what does that mean, retired?
That's a great question. You know, because I didn't have facts to substantiate it, I didn't actually look into that. But what I want to emphasize here is they have to demonstrate that they both attained the year of 62 during that tax year and retired, and established reasonable cause. And I don't believe appellants have demonstrated reasonable cause here. What they're essentially arguing is reliance on a CPA, and in order to establish reliance on a CPA, it can't be based on something like a math error, which is what we have here. It needs to be reliance on a CPA for a substantive issue. Regardless of whether he was retired or not, I don't believe they met the exception.
And the second question, when was the return amended, the 2013? So I assume the original return was filed on time?
Correct.
Yes, it was. And the hold on, let me grab that. ...2013 return was reported, June 3rd, 2014 was when we received it.
This is the original or the amended?
The amended, I apologize.
June
3rd, 2014.
Shortly after the due date, just when we realized.
Oh, I see. So you filed?
Filed in April.
When did you file your original return?
April.
April.
2 months
On
later.
time.
2 months on time, and 2 months later, there was a recalculation with his business with the K1
yeah.
that we had to just quickly amend it.
Okay. And then your 2014 return, was that filed on time?
Yes.
2015 filed on time?
Yes.
So you had paid the estimated tax payments based on the original tax return?
Correct.
That was filed in 2013?
Right.
And then it was amended, and therefore it kind of threw everything off?
And just to clarify, it's a little dismissive to say it was just a math error, because it was a communication error. On the left column of that worksheet, there was like a $165,000 payment made in January, or I reported it, and apparently his accountant that helps make the payments shorted it by about $30,000. And it wasn't a math error on my part, it was really a disconnecting of two people. This guy's, he's a store owner, he's not looking at every line item, and he relies on us, and we serve him well. It's just that this overpayment, in good faith, kept pushing it forward, and we do feel it's reasonable. It is a cause for the deficiency. Given that it is, then we feel that that subsection for reasonable cause under age and not being an active manager of your business anymore would allow the board to, give us the rebate, the abatement of the penalty.
Those are my questions.
Any more questions? I'm fine too. So, we ready to make a
We'll
motion?
take the matter under submission.
Motion
Second.
taken. A motion and a second to take the matter under submission. Thank you so much. We will be making a decision tomorrow.
Thank you very much.
Thank you.
Good night.
We hope. Okay. Okay. Ms. Richmond, please introduce our next item.
Our next item, B10, Keith William Brown. This taxpayer never showed up to sign in for his hearing. We have called him and left a message, and we have also emailed him to see if he's coming, and we have not received a response.
So we don't think he's here. Is
So our
Mr.
next
Keith
item-
William Brown available? Mr. Brown, are you in the room or hearing this? Okay, thank you.
So our next item is B13. Mary E. Dougherty, please come forward.
Okay, Madam Counsel.
Because of the change in the law, I would ask whether or not the board members have received any oral or written communication from either of the parties in this case that have not been disclosed or you suspect have not been disclosed to the other side, and to disclose those now.
I have not.
To the best of my knowledge, I've not had any oral or written communication, neither has my staff, with the appellant or the department or appeal.
Okay, in this matter, B13, Mr. Dougherty, to the best of my recollection, we hereby disclose that we have had some communication with the appellant and the tax department in the above referenced matter. My office discussed the issues presented in the briefing record with both the taxpayer and the department. We do not believe the law imposes a duty to disclose prior to the July 1, 2007 operative date of the provisions of AB 102. However, we hereby satisfy our ex parte disclosure burden to the extent one exists.
I've not had communication, oral or written, with this taxpayer nor the department since July 1st, when I believe this law took effect. And I believe any conversations that may or may not have taken place prior to July 1st are not applicable to the law.
And I don't believe, to the best of my knowledge, I have had any communication with the taxpayer or the taxpayer's representative or the Franchise Tax Board, and this is myself and my office.
Thank you. I would ask the board counsel, in order to assist the board members in their obligation to disclose, whether or not you're aware of any written or oral communications that you have submitted to the board members that have not been provided to the other side.
To the best of my knowledge, we have not.
Thank you. I would ask the appellants the same question, whether or not, in order to help the board members discharge its obligation, whether you're aware of submitting any oral or written communications to the board members that have not been disclosed to the other side.
No, we are not.
I don't know that, have any disclosures been made that the board counsel would want to comment on?
If all information discussed ex parte is in the briefing record, we do not wish to respond today, but we reserve the right to respond after receipt of the final opinion on ex parte communications. If information discussed ex parte is not in the briefing record, we reserve the right to request copies of all documents and written evidence of oral communications pending receipt of the final opinion on ex parte communications.
Thank you. I would ask appellants, I don't believe that any disclosures have been made regarding communications with the board counsel, but if so, do you wish to make any comment?
No.
Okay, thank you. Mr. Ambrose.
Good afternoon, Chairwoman Harkey, members of the board. John Johnson with Appeals.
Oh, okay, so you're doing it this time.
I'll do it this time. Switched
Okay,
up on
I'm
you.
just going to say appeals.
The issue before the board in this appeal is whether appellant has shown that she's entitled to a refund of the underpayment of estimated tax penalty for 2013 and 2014.
Thank you very much. Okay, welcome to the State Board of Equalization. You will have 10 minutes to present your case, and then we'll turn to the FTB that will also have 10 minutes. Then you will have 5 minutes on rebuttal. Please introduce yourself to for the record and begin.
Good afternoon, Madam Chair and members of the board. My name is Christopher Donis. I'm Ms. Dougherty's representative from the Tax Appeals Assistance Program, and this is Mrs. Dougherty here next to me. Mrs. Dougherty is eligible for a waiver of the 2013 and 2014 penalties imposed by the Franchise Tax Board. The basis for this waiver and subsequent refund can be found in Internal Revenue Code Section 6654, to which California conforms. Specifically, IRC Section 6654 E3A and E3B, The former provides for a waiver of the underpayment penalty if the government determines that by reason of casualty, disaster, or other unusual circumstances, the imposition of the penalty would be against equity and good conscience. The latter subsection B provides for a waiver of the penalty if the government determines that the underpayment was due to reasonable cause, and either the taxpayer retired after having attained the age of 62, and such underpayment was due to reasonable cause and not willful neglect. Ms. Dougherty qualifies for the exception under 6654E3B because her failure to make timely estimated tax payments was due to reasonable cause and not willful neglect. Ms. Dougherty's failure to make estimated payments occurred despite the exercise of ordinary business care and prudence. Ms. Dougherty exercised ordinary business care and prudence in as early as November of 2012 when she discussed selling her rental properties and home with her CPA. She knew that at her age and with her limited knowledge of tax law, she needed the help of an experienced tax professional. Ms. Dougherty's reason for failing to make timely estimated payments was such that an ordinarily intelligent and prudent business person would have acted similarly under the circumstances. An intelligent and prudent business person would have relied on a tax professional when they know their knowledge of tax law is severely limited. When selling real estate, they would seek advice on how to meet their tax obligations with the proper payment deadlines. They would also file an extension when they are not prepared to complete their taxes. Ms. Dougherty did all of these things. However, the information from her CPA was wrong. Ms. Dougherty's 2013 AGI was over $1 million, and the CPA should have advised her that she did not qualify for the 2013 safe harbor requirements. This is much more than just a computational error, as the FDB claims. This is clearly an error in substantive tax law because the CPA did not give her correct advice as to the applicable law. By the time the 2013 tax return was completed and filed in October of 2014, it was impossible for Ms. Dougherty to go back and make timely estimated tax payments. And she received the same bad advice about the substantive law in 2014. Ms. Dougherty is also, we feel also qualifies for 6654E3A because the substantial increases in her income from 2013 and 2014 do constitute unusual circumstances that the imposition of the estimate penalty is against equity and good conscience. Because of her low income received and low taxes she paid before, Ms. Dougherty had never heard of an estimated tax payment and relied on her CPA, as we all would, to tell her when she was supposed to be making them. These property sales were unusual circumstances because they distorted her annual reporting requirements in such a way that Ms. Dougherty was unable to anticipate and comply with on her own. We disagree with the FTB's interpretation of the statute and believe that they place way too much emphasis on the doctrine of justem generis at the expense of a plain meaning reading of the statute. We argue that nothing in the words unusual circumstances requires an element of loss or damage as a negative consequence. Ask the estimated 70% of lottery winners who are broken 5 years after their windfall if their experience was an unusual circumstance. There's a reason we have idioms in the English language dating back to medieval times, such as a curse in disguise, a wolf in sheep's clothing, and be careful what you wish for. Not all seemingly beneficial things come along that are positive.
Go
ahead. Okay.
I just wanted to correct one thing. I certainly am aware of estimated tax payments, but I always relied on my CPA or tax advisor to let me know when and how much I needed to pay an estimated tax. I did not compute that on my own. Wouldn't know how to.
Okay. At the end of the day, what we have here is a lifelong faithful taxpayer, Mrs. Dougherty, who lived in a house for 42 years and always paid her taxes on time. And then because of her age and her health, she was unable to keep up with the physical demands of her rental properties and her home and had no choice but to sell them. She did as any normal person or ordinary intelligent and prudent business person would do. She hired a CPA to help her sort out the mess. She gave her CPA all the information and documents she had, AKA she timely disclosed all relevant facts and documents to her accountant, and the CPA botched the job and gave her incorrect information about falling under the safe harbor provisions, a clear misinterpretation of substantive law resulting in the dispute before us. The moment her subsequent accountants discovered the error, Ms. Dougherty immediately made the payments and without hesitation and squared up with the state. After all the dust settled, Ms. Dougherty paid $169,000 and change for 2013 and around $293,000 for 2014. But the FTB, as they are wont to do, went after Ms. Dougherty for just a little bit more. For all this talk of reasonableness, what on earth is reasonable about spending thousands upon thousands of dollars going after an honest taxpayer just to take a few bucks more from her after she paid the state nearly $500,000? This is the reason why people are leaving the state in droves for places with more just and fair tax authorities that often forego fancy Latin terminology for simple, fair common sense when it comes to statutory interpretation of the tax code. For all the aforementioned reasons, we respectfully ask that the board, in the interest of fairness, equity, equity, good conscience, and most importantly, the law, to abate the penalties for 2013 and 2014 in the amount of $1,307 and $745.41. Thank you very much. Ms. Dougherty would like to address the board if she may.
Madam Chairman and members of the Board of Equalization, I want to address a couple of different things. One is the interpretation of what unusual conditions are. My experience for 16 years on the school board in Arcadia and 10 years of volunteering with the Chamber of Commerce as legislative chair or co-chair and the San Gabriel Valley Economic Partnership on their legislative committee. My interpretation of those words are that the legislature doesn't want to list 100 different items that could result in a change. They want you to be human. They want you to address the disruptors of life. And perhaps one of you or more have had the experience of having a parent or relative or friend move to a senior living community, and that's what I did. Let me assure you that that is a disruptor of life. I moved from my home of 42 years and closed down the last of a rental business that I had been involved in for over 40 years and sold my last rental property that I had owned for over 35 years. I left friends and volunteering in the community and business connections. I downsized from a 4,000 square foot home on an acre of property to an apartment 70% smaller than my home. That is a huge change. It's a disruptor of life. I sorted and shredded 50 years of records. And in my home, as in probably many of yours, every cupboard and closet was filled with stuff. And downsizing means getting rid of 70% of all of the stuff. My adjusted gross income for the 9 years from 2004 to 2012 was fairly even. In 2013, it increased by tenfold. In 2014, it was a 20-fold increase over my average income over those 9 years. However, it diminished in 2015, 40% from what that average had been, and in 2016, it's 12% of what that average had been. I would say that that is a major disruptor of life. And also, I want to comment on the reference to, in the summary, that I didn't provide information on health conditions. I had vertigo for over a year in the 1980s. And it lasted a year's period of time. The lingering effects is a little balance. And you know what? As you get older, things creep up on you. And it is a blessing to society to when somebody recognizes that they are in diminished capabilities in any area and decides voluntarily to stop doing that thing which puts them or others at risk. Also, in regards to information provided to my CPA, I want to let you know that I did discuss before I sold my rental properties the possibilities of a 1031 exchange. It didn't work out. I executed the 1031 preliminary forms, but I did not finish that transaction. I did not devote the time to finding a replacement property, but I explored the idea. I also discussed with my CPA how to structure the sale of my home, and discussed with him, I forget what it was called, annuity or something interest trust. It was something that he was a highly respected CPA in Arcadia, and I explored the idea, and I did not keep those records because I decided that that was not a good choice for me. But I had discussed the sale with him, with my attorney, the whole thing, and I never knew, as I mentioned earlier, I never knew how estimated tax was computed. I was married for 46 years to a CPA who had a master's in taxation and taught for the California CPA Society, and I relied on him to do our tax returns. When we got a divorce, and in that period after our divorce, the attorney that I had used in the divorce recommended a CPA, and I used that attorney. After that, then I chose, perhaps made a bad choice. I'm not an expert at choosing CPAs either. and I chose a CPA in Arcadia who had been very active in the community, who I knew personally and had a good reputation in Arcadia. I think he gave me some bad advice. He wrote the first letter to the Franchise Tax Board pointing out that my taxes had been in fact paid, and that didn't result in a reversal of the Franchise Tax Board. And that was well after all of the taxes had been paid and all of the cash of the checks for 2013 had been deposited and had cleared my bank.
If there's any time, like is the case that went before, that where this should be determined by the board to see reasonable cause, this is the case. Anything else you'd like to say?
Thank you.
Thank you very much.
Your time's over, but you'll get 5 minutes on rebuttal. Okay, FTB, please introduce yourself for the record.
Good evening, Chairwoman Harkey and members of the board. My name is Brad Catino. Sitting to my right is Marguerite Monnier, and together we represent Respondent Franchise Tax Board. As currently stated right now, appellant is not entitled to a refund of the estimate tax penalties imposed for the 2013 and 2014 tax years. Appellant filed timely tax returns for 2013 and 2014 and reported overpayments for both years. Appellant requested that those overpayments be partially applied to estimate tax penalties that she self-assessed on those returns. Subsequently, appellant requested a refund of those estimate tax penalties, and after further review, respondent issued a claim denial, which led to this appeal. For both the 2013 and 2014 tax years, appellant did not remit adequate estimate tax payments by the due date, and thus respondent imposed estimate tax penalties. Under California law, there is no general reasonable cause exception for the estimate tax penalty. While respondent is sympathetic to Mrs. Dougherty's current situation, there are only 2 limited statutory bases for the estimate tax penalty. The first basis to waive the penalty is when a taxpayer can establish a casualty, disaster, or whether a very limited, unusual circumstances where an imposition of the penalty would be against equity and good conscience. As stated in your board's hearing summary, appellant's assertion that her income was unusually high does not constitute a casualty, disaster, or an unusual circumstance that would warrant waiver of the penalty. Appellant's income may have been unusual, but they were certainly foreseeable events and known with certainty before the next quarterly installment was due. Appellant could have made timely revised estimate tax penalty payments based on anticipated gains of sale, but chose not to do so. Accordingly, the first basis does not apply. In regards to the second limited basis to waive the estimate tax penalty is when a taxpayer retires after reaching age of 62 or becomes disabled, and most importantly can demonstrate reasonable cause to waive imposition of the penalty. The first factor has been established. The taxpayer was 62 at the time the returns were filed, but she hasn't shown yet the reasonable cause. Currently, appellant has not established reasonable cause because her reliance on her CPA was computational rather than interpreting substantive tax law. In United States v. Boyle, the United States Supreme Court stated that a taxpayer can establish reasonable cause only if certain conditions are met. Those conditions require that the taxpayer reasonably relied on a tax professional for substantive tax advice, and 2, the tax professional's advice is based on a taxpayer's full disclosure of relevant facts and circumstances. In this case so far, the evidence does not establish that appellant provided all relevant facts and documents to her CPA. However, based on her testimony today, if appellant does provide additional information that she did contact her CPA regarding the sale of the property, respondent would be willing to review its position. Accordingly, as currently stated based on the evidence before the Franchise Tax Board, there isn't a basis to waive the estimate tax penalty, but respondent will review additional documents provided by appellant that shows that she had communications with her CPA. I'd be happy to address any questions or concerns the board may have. Thank you for your time.
Thank you. Okay, you have rebuttal time of 5 minutes.
Thank you. Respondents claim that all the CPA needed to compute the necessary estimated payments was to know the gains on the sale of the properties is incorrect and oversimplified. First, the CPA needed to know the law. He had to know when Ms. Dougherty needed to pay 100% of the prior year tax or 90% of the current year tax. Second, the CPA needed to know when the properties would be sold. Ms. Dougherty initiated the sale of both properties in 2013, yet her rental sold in May of 2013 and her home sold in February of 2014. The CPA could not know how much estimated payments were required because he did not know when the properties would be sold. Third, the CPA needed to know the gains of the properties. This means not only did he need to know the sales price that the buyer and seller would ultimately agree to, but he needed to calculate the pro rata depreciation for the properties. He also had to determine the adjusted basis for both properties and take into account any improvements. This would have been a demanding challenge for the CPA because Ms. Dougherty had been living in the same location for 42 years. Fourth, the CPA needed to estimate the total tax liability for the entire year. Making estimated payments is not just about knowing the gains and the sales of the property, it is about knowing the entire tax return. This means that the CPA needed to do more than just computations. Instead, he had to accurately estimate the entire year of taxes, but do it in May of 2013 and February of 2014. This means even if the CPA knew the law, he still needed to accurately estimate the interlocking pieces of a tax return to determine the correct amount of estimated payments. All these steps to determine estimated payments is substantive tax law strategy and not just computations. Finally, Ms. Dougherty also satisfies reasonable cause under Doyle, or under U.S. v. Doyle. She relied on the improper substantive advice of a tax professional as to a matter of tax law because determining estimated tax payments is substantive tax law. However, in this case, her CPA either did not know the law applicable to Ms. Dougherty's situation or improperly assessed her tax liability for the 2013 and 2014 years. The tax professional she relied on held himself out to be a tax professional with competency in tax law because he titles himself as a certified public accountant and has been doing Ms. Dougherty's taxes for 10 years and charged Ms. Dougherty to complete her taxes. Ms. Dougherty also timely and fully disclosed, as she said, all relevant facts and documents to her CPA because she kept her CPA informed since November of 2012, and she also used him, as she mentioned, multiple times to consider what her options were with to do with the sales of the proceeds. Ms. Dougherty timely and fully disclosed everything she knew because she understood that by failing to do so, she'd be putting her future finances at risk. Because Ms. Dougherty satisfies all elements here of reasonable cause, even those under U.S. v. Boyle, her estimated tax penalties should be abated.
Well, and nobody, if you've ever sold real estate, it ain't over till escrow closes. And I did not know that escrow was going to close. When you have a buyer who is not a resident of the United States, you don't know what's going to happen in the meantime. And I didn't know that it was going to close when it closed. My home, I knew 30 days before. I had 30 days to downsize and take care of 50 years of records in doing so. So saying that the close of escrow is a foreseeable event Well, yeah, maybe, and maybe not. All escrows don't close. And I would suspect that most people who rely on, who have a CPA do their tax return, rely on the advice of their CPA. Now, I was married for 46 years to a CPA who was a tax professional, and then, as I said, relied on him and relied on, one year, as a matter of fact, I changed one number on a tax return when we had been married 2 or 3 years. I changed one number, and you know what? If you change one number on a tax return, it changes everything. And so he thanked me, please, not to do that again. and so I truly relied on my CPA. Maybe that's bad advice. Maybe the Franchise Tax Board doesn't agree with that, but that's what happened. But the real reason why I'm here, 100% of the taxes owed had been paid. There is no doubt that they have 100% of the money. The money that they were seeking, they started seeking a year and 9 months after they had the check and it had cleared my bank. The whatever it was, 56,000 check from the close of escrow on the sale of rental property was paid May 1 of 2013. They sent me the notice that I owed the $43,000 in October of 2014. A year and 6 months later or so. And they kept sending me notices. Now, the Board of Equalization has a policy written that has to do with harassment of employees. And I searched your website, and you also have a policy that has to do with harassment of taxpayers. Now, I think when you start sending notices for an unpaid balance that has been paid that long in advance, over a year in advance, I think that's, by definition, I think that is harassment. Look at it this way. Suppose it was a credit card company. Now, I have a history of paying every bill when it is due in full. Now, supposing I paid my credit card bill every month in full when it is due, and the credit card company decided that I owed interest and penalties. And they sent me notices from from October of 2014 to February of 2015 that I owed additional monies and kept adding more interest. That's what the FTB did. Yet they had 100% of the money. I received a letter from their person in their office that said they'd never heard from me, and yet I provided, and in the documents that you have, I have the telephone number of the people that I spoke with, and the fax number of, what was his name, Kelvin, at 916-843-2470, that I faxed the check. I faxed the 593V, and he asked for me to fax the 593, and I did that. And I sent, that's all in those attachments, that I faxed all that information. All of that information was simply ignored, and another notice was sent, and another. That's like the schoolyard bully. And the FTV started the fight. The schoolyard bully started the fight, and I'm here to say, if you treat me that way, I don't think they singled out Mary Dougherty. I think that if they do that to me, they're doing it to other people. And you have a policy that says taxpayers should not be harassed. If that's not harassing, I don't know what is.
Thank you. Members, return to the board. Are there any questions? Yes, Member Runner.
Yeah, from FTB. Tell me the issue in regards to relief with retirement, age 62. Tell me how that works.
So that's one of the factors in regards to the estimated tax penalty, the B relief, that you need to be age 62.
And you're going to speak up. I'm
Sorry.
having a hard time hearing you.
Sorry, there's a two-part test for
Okay.
the B relief for estimate tax penalty. One is that they have to be either age 62 or disabled, and the second is, and that they must be reasonable cause to abate the penalty. Appellant does meet the first requirement of being age 62 or disabled. It is the second requirement regarding
Is
reasonable
it just
cause.
age 62 or is it retirement?
It's either,
It's either.
yes.
Oh, it's
Okay.
either?
It's either.
Yes. Yes.
Okay. So that would be, so there are two parts. That's one part.
Correct.
And the second part is
It's a reasonable cause.
reasonable cause.
Yes.
And tell me the parameters of reasonable cause.
Based on Mrs. Dougherty's statements during the hearing today, we would, if she would attest to them under penalty of perjury, we would accept that as evidence of reasonable cause.
Okay.
Good for you guys.
So I would assume that you're willing to do that.
I didn't understand
Yes, we are.
that.
I think you won your appeal. We will not be voting.
I can't hear you, I'm sorry.
Well, again, just for clarity, I assume that you're willing to, that the taxpayer is willing to do that.
If you attest under penalty of perjury to what you stated here today, they're on board.
Absolutely.
Okay.
Okay.
Okay, so what would be, in terms of, I guess, the process for that now, let me go to appeals. How do we conclude this discussion then?
I believe that was sufficient.
Okay.
Thank you. Okay,
Just
so
to-
the
just to
so
close
the
the loop,
FTB
does that mean the
is
franchise tax board is going
withdrawing.
to? Thank you.
The FTB is withdrawing their case based on, or providing there is a sworn testimony, or that the testimony given today is certified as being sworn and accurate and under oath?
No problem.
We'll withdraw our claim denial.
All right.
The FTB would then withdraw its claim denial. And she would be
And
entitled.
the refund claim that she filed, we would then.
Right.
Okay, really good. So you guys will all get together and take that into consideration?
Am I allowed to
That's-
talk to them after, I don't, first time?
Right, you just
I
have
can-
to, you have to
Yeah.
get something that's sworn testimony and, or have them say that the testimony you provided today was true and accurate and blah, 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 and you swear and sign under penalty of perjury.
Very good, thank you, Madam Chair.
Thank you.
Okay,
And we know
thank
you've all
you.
been here, got here way before we did at 1300, so we appreciate it.
Thank you, FTB.
Appeals.
I told him
Appeal.
13 is my lucky number because my firstborn was born on Friday the 13th.
Okay, Mr. Hill,
So with that, no vote will be necessary then.
thank you.
Thank you.
Okay, good. See, sometimes it pays to show up. Thank you very much for your consideration.
Thank you.
Okay. Boy, I'm getting tired. My eyes are starting to cross. But I've done worse at council meetings, so let's keep rolling. I think we're on a roll here. We kind of got our spiel going. Okay, what,
We're done.
is that it?
That concludes our
We
hearings for today.
have no action on property taxpayers' Bill of Rights. We want to get rid of that, property taxpayers' Bill of Rights.
Now, let's get that off.
So our next
Yeah.
item is
And
F,
let's
public
get these
hearing.
staff recommendations on the Gs.
So our next item is F, public hearing, F1, property taxpayer bill of rights hearings, and I don't believe we have any taxpayers that wish to make a comment.
Do we need to hear a report, or do we just announce that individuals have the opportunity to present their ideas, concerns, and recommendations regarding legislation, the quality of the agency services, and other issues related to the board's administration of tax programs, including state and county property taxes, and any problems identified in the Taxpayer Rights Advocate Annual Report? Is there anyone here that wishes to make a statement? Hearing none, why don't you introduce yourself for the record, sir? And I don't believe there's any report necessary.
Good evening. My name is Mark Sutter. I am here representing the Property Taxpayer Advocate for the Board of Equalization. And just like you mentioned, once a year, the board conducts an annual hearing that gives the public an opportunity to speak about just about any property tax matter, and also to discuss the annual report that we published. We do not have any signed-up speakers, so unless there's somebody in the audience, I think that would conclude our hearing.
Okay, thank you very much. There's no need for a vote. We've heard there's no speakers. Thank you very much for showing up and sitting.
My pleasure.
Okay.
Have a great day.
All right, now, Ms. Richmond.
Our next item is G, Tax Program Non-Appearance Matters Consent. G1, Legal Appeals Matters. Sub-item 1 has been previously pulled, and these matters may be taken in one vote.
Okay.
So moved.
So moved by Member Horton. Second by Member Runner. Such will be the action. G2.
Our next item is G2, Franchise and Income Tax Matters. Sub-items 21 and 22 have been previously pulled, and these items may be taken in one vote.
So moved.
Second.
So moved by Member Horton, second by Ms. Stowers. Any objection? No, such will be the order. Okay, then there's G4.
Our next item is G4, Sales and Use Taxes Matters. These items may be taken in one vote.
So moved by Member Horton.
Second.
Second by Ms. Stowers. Any objection?
I just have a question. Why is it still under our agenda?
Because the legislation has not been changed for these items yet.
Oh, okay.
Oh, so it's still our duty. Oh, boy.
Really? It's sales and use tax.
Okay.
Okay.
Well,
I'll just leave that alone.
such will be the order. Thank you. Motion second, no objection? Right. Okay. Well, we got a petition for rehearing?
Yes, our next item is H, Tax Program Non-Appearance Matters Adjudicatory. Item H2, Franchise and Income Tax Matters. These items may be taken up separately or in one vote.
I think I need to take them up separately because I have recommendation from my staff on H21, which is Alan Taylor and Susie Taylor, and H22, Amandagari Abel and Albert Abel Jr. to grant the petitions.
And we also have contact, our taxpayer has contacted us, so do we need to put those on the record as well?
Is this a formal hearing or part? Do we need to say that for these?
Yep.
Okay, then, council, on item H2, which is franchise and income tax matters, there's four items, item 1, 2, 3, and 4, that we need to vote on. So will you please ask your questions? Work your magic.
Item of H? Or
Well, I think she can do them all at once. We can say that we've had.
Okay, you want me to go first?
Yeah.
Okay, so on H1 and H21 and H24, the taxpayers did contact my office, spoke to my staff prior to July 1st, 2017 regarding their arguments on appeal. All of the documents are in the briefs.
I have not had any communication with any of the taxpayers on H21, H22, H23, and H24.
To the best of my knowledge, I have not had any communication on H21, H22, H23, H24, and neither has my staff.
To the best of my recollection, on H21, H22, H23, and H24, I do believe that we have had communications with appellant and with the tax department in the above referenced matter. My office discussed the issue presented in the briefing record with both the taxpayer and the department, if we discuss them at all, and we do not believe that the law imposes a disclosure requirement prior to the July 1, 2017 operative date of the provisions of AB 102. However, we hereby satisfy our ex parte disclosure burden to the extent one exists.
Of the H items, I have not had comment or communication, oral or written, with these taxpayers, nor the department since July 1st, when I believe this law took effect. I believe any conversations that may or may not have taken place prior to July 1st are not applicable under the law.
Okay.
Where are we at?
We've done our bit.
We're taking these up separately?
I think we have to. I can do two together if there's, I've got H21 and H22 to grant the petitions. So I will make such a motion. Do I get a second on those two?
Second.
Second by Member Moffatt.
Objection.
Motion. And one objection. Call the roll, please.
Oh, one moment, Chairman Harkey. H21, I believe, is not a petition for rehearing. It's a summary decision.
It says petition to rehearing, so, oh, no, it isn't. It is grant, okay. Well, I think my staff wrote wrong here. Okay, so the decision.
Summary decision.
I would recommend you take the decision up first separately. Sub-item 1 up separately, perhaps, the decision.
If this is the only decision, then, right?
That's correct.
Okay, and the rest are petitions. Okay, we've just got the wrong advice to me. Okay, so on H21, the Ann Taylor and Susie Taylor, we want to move to, I don't have the right instructions, so I don't know even what we're talking
Move to
about.
adopt staff recommendation.
Second.
Okay. Any objection? No, okay, such will be the order.
H22.
And then H22, my staff has recommended that I grant the petition.
Madam Chair, maybe we should put these items on the record, or just tell me what we're discussing.
Item H22 is a petition for rehearing on the adjudicatory calendar.
What's the?
I don't even know.
It was a decision of innocent spouse petition for rehearing where it appears that the Franchise Tax Board denied the innocent spouse relief. They filed a rehearing, and Ms. Harkey is.
What was our vote?
My
Let's
staff
see.
is recommending a motion.
This was a hearing that we did, right?
Right, innocent spouse relief was not granted. I don't know when it was that we did the hearing.
And do we have new, is there new information that would require a rehearing?
As I understand it, there must be. I'm sorry, there's nobody here answering this question for me, and it just says to grant the petition. And generally, I don't have a whole write-up on those. So I apologize.
So you're saying your motion is to grant the petition for
My
rehearing?
motion is to grant the petition for the rehearing based on the advice of my
On your
personal
staff, and that's for
staff.
H22 Amanda Gary Abel, right?
Right.
Yeah, the
And
letter says, wish to present new material to support my case. That's the letter from Amanda Gary that I have in my file.
Okay, thank you.
Say it again,
Thank you,
please.
Member Moff.
I'm sorry, I have a letter in my file dated January 19th, 2017, from Amanda Gary, basically saying, I wish to present new material to support my case and to discredit false statements made about me that prevented me from getting a fair consideration at the first hearing.
Did she indicate whether or not that was an oral hearing? I mean, it was a hearing, so it had to be an oral.
It was
here
a
it
summary
is.
decision.
It was not appearance matter?
It was a what?
It was a non-appearance matter.
She was a non-appearance the first time, and now she's asking for a rehearing.
Move the grant.
Correct.
Okay.
Okay, so it's a second to grant? Yeah, I've got the whole write-up here. I'm sorry, I just
Two
did
appeals,
not.
do you guys have that new evidence as well?
I'm not sure if that was in the actual petition for rehearing, or is that a separate letter that was submitted?
It looks like we pulled it, maybe my office pulled it in October 2016 on the G2 consent calendar. The taxpayer filed a timely report, a timely joint 2008 California income tax return, but did not report an early distribution tax penalty of $54,000 from the wife's
Alex.
qualified
That's lovely.
retirement plan. And so we pulled it to ask her about it, apparently, and she has information and she wants a hearing.
Okay, there's a motion to grant.
I believe the facts you repeated, though, refer to Alan Taylor. They do refer to H2 subitem 1.
Got that
So
screwed
that may be
up?
the advice that you were trying to,
I'm
that you
sure.
were beginning for that appeal.
Yes, you are right.
But
I'm
it's-
tired. My eyes are crossing. That was Taylor. This is Gary, Amanda Gary. The taxpayer is a victim of a vindictive husband and very ugly divorce, which is
She's got new
pending
information.
for more than 5 years. She's worked through this and she has new information. So it's $1,400, 2008. There's a motion to grant the petition. I'll second it, and...
And I was just asking, this new information, do you guys have that new information? Does appeals have that new information?
I don't
You
know.
just have
Can we
what
just,
you
can we
communicated
just...
with her?
Yeah,
that she had new
let's have
information?
appeals at least contact her and get her new information, if you wouldn't mind.
But are we going to grant her here?
Since we can't. Well, we just had the motion in a second. Are you going to object to
No,
it?
no.
No?
I'm still discussion. I was just wondering if you guys,
I don't know what to say.
Well, again, again, that's part of the issue. Typically, we would be more aware of whatever new information it is, but since we no longer can have communication with the taxpayer, it's hard for us to answer this question.
Yeah, so we need...
So I guess we're going to have to take her at her word that she has new information.
okay, I have no objection to this one.
Yes.
Okay, thank you.
What are we going to do? Got a letter?
Okay.
Yeah.
Okay, no objection, so we'll grant that petition. Now on H2...
I'm really sorry to interrupt, but can I just get some clarification? When you say there's no objection to the motion, you presume that everyone is voting, is that correct?
Right.
Okay, and that there were no
Thank
abstentions?
you, I'm sorry.
And
Yes.
if there was somebody who was abstaining, you would state that?
Normally, we'd chime up and say...
We'd object, yeah.
Yeah, object, or
If we object, then we
someone would say
then we do
no
a roll
or
call vote.
not voting.
And if somebody abstains, that they would also speak up?
Yes.
Okay,
Yes.
correct, thank you.
I think the air conditioning went off. It's getting warm in here. Okay, so then H2-3 and H2-4, I'll make a motion to deny the petitions.
Madam Chair, my apologies, but my items are out of order. Can you further define the appellant?
You're asking me, huh? Okay.
H23 is Michael A. Mills.
Michael A. Mills.
And H24 is, who?
That is Dinesh Swahini
And Rajmi Soni.
And the motion is, again?
to deny the request for petition, deny the
Second hearing.
petition. Okay, there's a motion from Member Horton and a second from Member Runner. Any objection? No. Okay, such will be the order. Now, approval, okay, do we have any consent? Doesn't look like the N1, the board meeting minutes.
Move approval.
Second.
Any objection? No, okay. N2, I've
They should
report
be
on
taken
time
up together.
extensions for Alpine, Amador, whatever.
Move approval extension.
Okay.
Do we vote on those now? I thought we didn't vote on those.
It
It's
says
just a report.
Information only.
You can do it both, I
information.
guess.
We can do both. If that's
Oh.
for information, it's information.
Yeah.
If not, if we had to vote on, is there any objection? No? Okay. Executive Director's Report, can we put that off till tomorrow?
I would
Agree.
like that.
Yeah, let's just do that tomorrow.
You may have to come back and report on all this other legal stuff.
Yeah.
Yeah.
And
P3.
let me see, what about P3?
Something may get organized between then and now.
P3, it's just the item 1, item 2, item 3 is this fiscal year 2017 private railroad car tax rate. And then P3-2 is adoption of the 2017 private railroad car roll. And then P3-3 is adoption of the 2017 state assessed property roll. And we can take those all in one.
I'm not, Deputy Controller cannot participate.
Okay, so we have a abstention by the Deputy Controller.
Madam Chair, one is for informational purpose, the other two would require a vote. We could take up P3-2, P3-3, but would require the department to put something on the record in regards to those.
Okay, I can't rush those through. So Department, there you go.
Good evening, board members. Dean Kinney, Deputy Director with the Board of Equalization's Property Tax Department. The first item is the private rail car tax rate. It's informational only. Staff calculated the rate for 2017, 2018. It's 1.141. I'm happy to answer any questions you have.
Move staff recommendation.
Second.
The second item is the adoption of the 2017 private.
Vote on independently?
I don't know
Okay.
what we need to do.
Is there, yeah, because the State Controller is abstaining. We have a motion and a second. Any objection here?
We could do that and acknowledge the non-participation of the State Controller.
Right, she's abstaining. State Controller is abstaining.
She's not participating.
Not participating. Not participating. Pardon. Non-participating of the State Controller on all of the P3 items. Okay, so we have a motion and a second on one. Any objection from those that are participating?
We're receiving and filing on one.
Okay, well, we got a motion and a second. So, okay, we'll receive and file. Sorry.
Two.
Okay, item number 2, do we, I'm not waiting for Ms. Richmond to tell us if we need to vote or not, and this is the problem. Okay, item number 2, adoption of the 2017 private railroad car roll. Would you like to?
Just ask the board adopt the 2017 private railroad car.
Acknowledging non-participation on the part of Deputy Controller. Second.
Right, she's not participating on any of the P3 items. Okay, there's a motion, there's a second. Any objection?
Ms. Harkey, who made the second?
I did.
The second was Member Horton, right? And the motion was made by Member Runner. Okay, item number 3.
I ask that the board adopt the 2017 state assessed property roll.
Move adoption.
Move adoption by Member Runner,
Second, noting non-participation of the Deputy Controller.
second by Member Horton. Non-participation of Deputy Controller. No objection. Such will be the order. Okay. Do we have anything at all to hear on closed session? I don't think we have anything discussed because we don't have
No
a,
settlements or anything?
we have no chief
We
counsel.
don't do those
We're
anymore.
good.
We don't do those
Okay.
anymore, do we?
Okay, so, hallelujah, you guys. Great, great deal. We are, the meeting will we're recessing right now, and the meeting will reconvene on Friday, July 28th, 2017 at 9 a.m.
If I could just get some clarification from what has been asked, Mr. Scott had referred a couple of times to awaiting a final decision on the ex parte matter, and I'm wondering if there's something that you expect from me tomorrow,
Yeah, we did.
other than what I've offered.
We wanted to know, we wanted to get clarity on the statute that says it doesn't start till July 1. Isn't that right?
Yes.
And we want clarity that starts on July 1, because we don't want to be non-disclosing or in a position of being accused of non-disclosing for a retroactive action.
Yes, so I think like all.
Recognizing that there are, there's room for interpretation in the law, I will reread what I have. I am not in a position to produce a written memo. I don't have that capability.
I would hope that since we got the memo the day before the hearing, and we're hearing hearings and we're supposed to vote tomorrow, that somebody that's been watching this hearing will have been already preparing something because they see the disarray that we are in. So if you could contact GovOps and tell them that we need some clarification on when and we need some legal analysis by tomorrow so we can vote, that we need some legal analysis on the disclosure requirements or the ex parte prior to the beginning of July 1, and why, if we have to do something like that and go back and get documentation, under what justification, what statute, what are we looking at that tells us that we have to do that? Since we were the presiding officers, we have not changed that position. The law changed. The law states specifically July 1, 2017, and we all feel that that is probably the date we should begin to disclose ex parte. Going back retroactively presents a huge problem if it's at all even possible, and I think it puts us in a legal dilemma. So we want some clarification that, in fact, the statute language is correct. That is July 1.
Let me just say real quick, too. My understanding is from Mr. Gao is that there has been communication with government ops and that they are looking at this?
Since I had asked, I have not received a response. So
But you have asked?
I had asked. So
Okay, just a minute. Okay, so you have asked them, and so I guess the answer is, part of what we're looking for is a response from them. And so I would encourage our council now to communicate back up to GovOps and see how they're doing on that project. The other issue I think we were looking for, and that I think FTB was dealing with, that we've also then asked the now the new department to give us, and that is, if they can't do that, a waiver that would include, that would indeed, in their interpretation, deal with the fact that we had no obligations to disclose ex parte communications prior to July 1st. So
Well,
I think those are the two issues that we wanted to get clarified.
Yeah, and I think part of the complication is we've had staff changes, some of us. I think Yvette's the only one that's been here the whole time that can definitively say whether someone on her staff or herself has indeed met with taxpayers about cases. So, that's why, I have to preface to the best of my knowledge that we haven't, because some of the staff that left, I don't have access to their emails. We didn't keep track of all the meetings, so.
And they probably wouldn't know anyway. And
Well,
here's
I don't know.
more the point, that anything that we decide, the taxpayer could claim that there was an ex parte that we didn't disclose, and so then we have problems. So I think for all concerned, the statute's the statute. Clear direction as to why the statute is not correct, and let us know. By noon tomorrow. We got one day. They can get noon tomorrow. Thank you.